Please rise. Circuit Court is now in session. Honorable Robert Rashio presiding.
Thank you. You can be seated. Go on the record in the matter of Arnold and Asmussen versus Rosenblum, Kotek, and Cotting, Harney County case 22 CV 41008. Time set for continuation of the defendant's cases. You ready to proceed then, Mr. Marshall?
We are, Your Honor. Dr. Siegel is available, and I believe he is logged in.
You ready to proceed, Mr. Iowa?
Yeah.
Hello.
Yes, Your Honor. Thank you.
Dr. Siegel, are you on the line, sir?
Yes, I am here.
All right. Good morning or good afternoon where you are.
Yes.
I'll turn it over to you then.
Good morning and good afternoon, Dr. Siegel. Thank you for joining us again. Before we return to the topics we were talking about yesterday, I wanted to ask you about a separate topic. In preparation for your testimony, did you determine the number of firearm homicides in Oregon for each of the last 21 years?
Yes, I did.
How did you study that question?
Well, the gold standard database is the CDC Vital Statistics database, which tracks every fatality. And one of the things they track is whether or not it was a firearm-related fatality and whether it was a homicide or not. So using the CDC database, I tabulated the total number of firearm homicides in the state of Oregon annually during that period.
Well, hold on. I just want to, I know you're on the East Coast. It's Oregon. I know it doesn't spell that way, but it's Oregon.
Sorry.
When I hear Oregon, it triggers all kinds of responses from me, and I just want you to be aware of it as we move forward. Go ahead, please.
I apologize to the court for my failure of witness preparation.
That was terrible, but I'll forgive you.
I've heard worse pronunciations of our
I've heard
state's
way
name.
worse as well, but it didn't not trigger me then.
Do epidemiologists rely on this type of data in their work?
Yes, absolutely.
Is it reliable?
Yes, this particular database is very reliable.
Your Honor, we're going to show Dr. Siegel two exhibits, 151 and 152. I will pass them up. They've been provided to counsel yesterday in one form and re-provided this morning.
Okay.
Let's look at exhibit 151. Dr. Siegel, what is exhibit 151?
This is a chart that shows the annual number of firearm-related homicide deaths in Oregon from 2001 through 2021.
And how many firearm related homicide deaths were there in Oregon in 2001?
In 2001, there were 47 firearm homicides.
And in 2021, how many were there?
There were 146 firearm homicides in 2021.
What was the increase between those 2 years?
The increase was 310%.
Objection, lack of foundation. He hasn't explained how he calculated the increase.
I mean, I'll overrule. I think that there's a lot of other factors that are not necessarily derivable from this number, but I'm happy to have you introduce it as the CDC's number.
Dr. Siegel, what was the change between 2001 and 2021 in the number of firearm-related homicide deaths in Oregon?
It was a 310% increase, which is about a tripling of the number of homicides.
The defendants move for admission of Exhibit 151.
Objection, Your Honor, hearsay. This is an out-of-court statement offered for the truth of the matter asserted. Dr. Siegel can testify to it, but it does not become part of the court's record under 703. It's no different than an expert witness report or anything else that Dr. Siegel uses to inform his testimony.
May I be heard?
Yes.
Under 803.9, records or data compilations of deaths, if the report thereof was made to a public office, is an exception to the evidentiary rules of hearsay. That is allowed to be provided in chart or compilation form under Rule 1006. In addition, as the court has ruled previously, as I understand it, the expert is allowed to provide hearsay, and including in
You got it. You're already there with 803.9. It's fine. It's admissible. It is an exception to the hearsay rule, and I agree that it can be compiled. I mean, I'll give it the weight that I give it. It's without context. It strikes me as a fairly limited inquiry, but I'll allow it in. For example, Oregon's population is much larger than it was in 2001. For example, there are spikes and peaks and valleys in this document. For example, I don't know how to, you want me to say that this has been this extreme increase, but I don't know the factors behind that. So I'll admit it and give it the weight that I think it's due on those issues. I just want you to be aware of where the court's thinking is so that you can fill your record and complete it. Go ahead, please, Mr. Marshall.
Let's look at Exhibit 152. Dr. Siegel, did you look at any other measures of the burden of firearm homicides in Oregon other than the raw number of firearm-related deaths?
The what now?
Yes, I also looked at what's called
Hold on,
years.
doctor, excuse me, the form of the
Sure.
question. What did you just say? The burden?
Of the burden, did you look at any other measures of the burden of firearm-related homicides other than the raw number of deaths?
How is burden a scientific term?
I can try to lay the foundation. It has a specialized meaning in the
Well,
world of
then I'd like to know
epidemiology.
what that would mean.
I understand.
I don't understand what that seems argumentative to me at first. So
Understood.
feel free to complete your record.
Sure. Dr. Siegel, are you familiar with a term of something called disease burden?
Yes,
What does that mean?
in epidemiology, disease burden essentially refers to the overall consequences of a disease or an injury in a population. So it would include things like the number of deaths, the number of injuries, the economic cost, the social cost, the years of potential life lost. In other words, the number of years of life that would have been experienced had those people not died at the age that they died. So
Then you have not walked through this process to the degree to come to that kind of final conclusion. You have not provided me a scientific basis to understand this number under 702, and I'm not going to allow you to ask that question unless you lay a proper foundation under Brown and O'Key. I mean, that is, all of those factors are massive concepts of which I don't understand how I would evaluate that question without better understanding of the science.
Are you familiar with one of those measures that you just listed, the years of potential life lost?
yes, it's a very standard measure used in epidemiology.
Let's just first define what that measure is.
The measure is simply adding the number of years of life that were lost, typically up to age 65, due to an injury or due to a death. And the reason why this statistic is sometimes calculated is because it accounts for the age of the people at which they die. So for example, a disease where everybody was dying at age 95 would not have nearly the impact on society as a disease where people were dying at age, say, 5. There would be a lot more lives, a lot more years of life lost in the latter situation. So the years of potential life lost is a statistic that is intended to enhance our understanding beyond just knowing the number of deaths.
How is it calculated in general?
You simply take the age at which each person died from that cause and subtract it from 65. And then you add all of those together.
Why, excuse me, Dr. Siegel, complete your answer. I thought you had stopped.
So yeah, so essentially you take, let's say somebody died at the age of 10. You want to know how many potential years of life would they have, were taken away due to that. We use the age 65 conservatively. What you really would want to use is the life expectancy, which in this country is more like 75. But to be conservative, we sometimes just use age 65.
Who uses this measure?
Epidemiologists use this measure. The CDC uses this measure. It's one of the most common measures in epidemiology.
Did you calculate this measure for years of potential life lost in Oregon due to firearm-related homicides from 2001 to 2021?
I did.
How did you do that?
I used the CDC database, Vital Statistics database, the same database that I used for the mortality estimates.
And did you have to perform the calculation, or was the calculation already performed by the CDC?
The CDC automatically, I did not have to tabulate it myself. The CDC automatically provides the numbers.
And is that because the CDC itself publishes that data?
Exactly.
Do epidemiologists rely on CDC data for this point?
Yes, they do.
What were the years of firearm-related homicide, years of potential life lost in Oregon from 2001 to 2021?
So there was an increase in 2001, there were 1,276 lives lost. In 2021, there were 4,391 lives lost. That's a 344 increase, so percent increase. So it's more than a tripling in the number of lives lost during that time period.
Does Exhibit 152 show the other data that you obtained from the CDC?
Yes, it does.
Is Exhibit 152 a fair and accurate presentation of that data?
Yes, it is.
The defendants move admission of Exhibit 152.
Your Honor, objection as to relevance. I don't know how this gets us any closer to understanding the facial challenge of ballot measure 114.
I'll overrule. What was the population increase in Oregon between these years, Doctor?
It was approximately 10%.
10%?
Yes.
Okay. Where'd you get that number from?
That's just census data, U.S. Census.
Okay. Thank you. Go ahead, please.
We're now going to return to Dr. Siegel's study that we ended on yesterday. And I have a matter for the court. I don't think there's a problem with Dr. Siegel listening to this, but if the court disagrees, we can have him, mute himself or log off.
That that's your burden, not mine.
Okay.
You decide what you think is best.
I think
And
it's
if
fine for him to listen to
And
it.
if it corrupts
Okay.
the evidence and I exclude him because of it, that's a choice. I'm
Okay.
gonna just.
I don't think it will corrupt him at all because it's his article and that's what I'm going to be describing. His article comes to a conclusion that this article relates to two policies that are at issue in this case. The court has excluded the evidence regarding to purchase. It is included or may include, depending on the foundation that is laid, the evidence related to large capacity magazines. My request is recognizing that the court will exclude any testimony that relates to permit to purchase, that when I ask, for example, what were the results of this study, we allow Dr. Siegel to describe accurately what he studied for the completion of the record. I think this would be a very difficult question, how to handle this in a jury situation, but the court absolutely has the capability to exclude from its decision any evidence that relates to permit to purchase. I think that we're going to end up with 2 or 3 mentions as we go through how this study actually was done and what its results were of that. And I just wanted to alert counsel and the court that an accurate description of this article will also have information about permit to purchase. And so the fastest, easiest, and clearest way to create a record on this is just to exclude it after the fact.
Your Honor, plaintiffs would ask that, I believe the purpose of motions in limine and evidentiary rulings is to keep evidence off the record, not merely to keep it out of the court's consideration. I do understand that this court can filter appropriately, but plaintiffs would ask that, I think it's fairly obvious that all sides expect this case to be eventually heard by a court of appeals, and plaintiffs would ask for a clear record and that there not be testimony regarding matters that this court has excluded pursuant to the rules of evidence and the court's rulings on the evidence. And plaintiffs don't think it would be difficult for Dr. Siegel to not testify about permits to purchase. Can the witness not filter the witness's answers?
He studied 8 policies. Permit to purchase was one of those policies. If I ask him how many policies did you study, do we want him to answer 8 or 7 plus other of those that the court has not excluded? I mean, that's the situation that we're in, and I'm not going to belabor the point on permit to purchase. I just don't want to ask the witness to try to apply the legal ruling when he's describing his own work. Excuse me.
Your Honor, plaintiffs would also add that 6 of these types of laws aren't even at issue in ballot measure 114, and yet they're a part of Dr. Siegel's data set. And I think that goes to the relevance of Dr. Siegel's data set that he's dealing with here, that he's not only looking at so defined large capacity magazines, but he's also looking at assault weapons bans and red flag laws and other laws that are not at issue in this case that are in his data set. And those have been properly excluded by the court and should remain excluded by the court. Sounds to plaintiffs like this data set is 1/8 the value of as 1/8 relevant, perhaps.
No. First, I guess I don't think I understand what you're suggesting you're going to do with this witness. You're intending to have him review his study with you? Is that what you're saying?
Yes, we are going to go over the methods used in this study and what the results of the study were. and how that informed as a foundation for his opinion about the relation between state gun laws and the incidence and severity of public mass shootings in the United States.
Okay. So there's a number of logical pieces that need to occur prior to me allowing him to make any conclusions based upon whatever evidence you're going to present to the court. You understand that, correct?
Yes.
Okay. Look, part of scientific evidence is that I'm comparing a red apple to a red apple. And the point of the court's earlier rulings with regards to permit to purchase programs is that I'm comparing a red apple to an entire store full of many types of apples. And I don't know how to do that in terms of a scientific conclusion under 702, which is what the court's obligation is to the law. So the reason I exclude that evidence is because it has not been told to me that each and every one of these programs is a red apple. What's been told to me is some are Granny Smith apples and some are other kinds of apples that I can't come up with the names of right now. And so I'm not going to allow any testimony of a scientific nature unless I understand that the public policy that's being reviewed is identical to the public policy proposed in Oregon, because to do so is to compare different types of apples against the red apple. You can show me that they're the same and that there are also additional data sets that are effective in coming to this conclusion beyond just the language of the policy. There are so many variables that are involved in this type of dialogue, then I'll hear you. And I'll allow it into the record. If you can establish under Brown and O'Key, to remind you that under Brown, the court is a gatekeeper to scientific evidence and whether it'll be admitted or not. And I'm a gatekeeper, as Mr. Aiello points out to the other courts. And he's asked me to keep this record clean and to make appropriate factual findings regarding this scientific evidence and whether I'll allow it in or not. And I feel that to allow just a permit to purchase as a basis is too simplistic an analysis to determine whether this policy is going to be effective against the magnitude of a harm in which the state has provided, the defendants have provided some data. And I find that the state asked the court to do a facial determination on the constitutionality of this law. I said, okay. So now if you want to talk about the magnitude of this problem, you're going to do it through 702, or you're not going to do it at all. So go ahead and try to lay your foundation. Red apple to red apple, Mr. Marshall.
Dr. Siegel, you testified yesterday, I believe, about this, but what were the large capacity magazine bans that you reviewed as part of the study in Exhibit 153?
Well, there are 8 states that have passed large capacity magazine bans. All of these policies are exactly the same in that they ban large capacity magazines.
Sorry.
I was just gonna say, the only difference between the policies is that in 2 of the states, they had a 15-round limit, and in 6 of the states, they had a 10-round limit. But obviously, the majority of the states that were included in the study had a 10-round maximum limit.
This, whatever documents up.
Yeah,
there,
it's
I
the
don't
wrong,
want
it's the wrong,
this-
it's the wrong.
What's in front of me, I want to watch.
It's 140,
the
it's 140,
witness
oh, sorry.
testimony. If you want to introduce something, you can introduce it and then you can publish it. I decide what publishes and doesn't publish as well. So go ahead, please.
You testified yesterday that you applied a difference in difference calculation. Did you look?
You're doing it again. You're publishing, and I'm not able to observe the witness. Go ahead, please.
You looked. You did in your study. You did a difference in difference calculation, correct?
Correct.
Did you use any control variables?
We did. We did. We controlled for the state population. We controlled for the population density. We controlled for the portion of racial groups by race. We controlled for the proportion of young adult males. We controlled for the poverty rate. We controlled for the unemployment rate. We controlled for per capita alcohol consumption. We controlled for the divorce rate. We controlled for the incarceration rate. We controlled for and we controlled for the level of household gun ownership in the state.
I didn't hear what he just said. It got mumbled.
Sorry.
What did you just say?
We controlled for the level of household gun ownership in the state. In other words, the percentage of households that own a gun.
I understand that. I just didn't understand what you said because it mumbled. That was it.
Oh, okay.
Thank you.
Sorry.
Go ahead.
We've had some discussion about the quality of internet broadband and our video conferencing services throughout this week. So appreciate your patience with us on that. When you were conducting the calculations necessary to do the difference in difference analysis, how did you perform that calculation?
So the calculation is essentially performed by looking at the number of mass shooting events or mass shooting casualties in a state in the years preceding the ban compared to the years following the ban, and then comparing that to all other states that didn't have a ban, to the change in their number of deaths or mass shootings from during the same time period, from before the ban to after the ban. So you're comparing each state with all other states that don't have a ban.
Is that method used in epidemiology commonly?
Yes, this is in fact the method that is most commonly used to assess the impact of public policies.
What is the role of control variables in that method?
The purpose of the control variables is to exclude the possibility that the changes that you're observing are due not to the law, but to some other variable. And that's why we control for all these other factors, including population density, racial changes, to make sure that whatever effect we're observing is due to the law itself, not to these other extrinsic factors.
So we're not going to put this on the screen in order to allow the court to observe you and your testimony. But if you have your article I'd like you to turn to page 355 of your article, which is on Exhibit 143. And for clarity of the court and observers, it's not a 355-page article. It's 355. It's page 355 of Volume 44 of Law of Human Behavior.
Your Honor, plaintiffs would ask that Dr. Siegel testify from his memory. I think he can look at his study to refresh his recollection if need be. But plaintiffs would object to him reading from an exhibit that is not and cannot be admitted into evidence.
If the court wants me to exhaust his memory on certain factors, that's fine. I mean, and then we can use it to refresh and take away the document and testify from there. It seems unnecessary in this instance, and given particularly that experts are allowed to rely on hearsay, I don't think that refreshing recollection rule of recorded recollection, I'm going to say this wrong, but the recorded recollection refreshed rule applies in the same way to expert testimony.
Your Honor, plaintiffs would assert, I believe a similar objection was made to my historian's references to her expert witness report. It would be much easier for us to have expert witnesses just read their report on the stand. But if Dr. Siegel's the expert that the defendants have proffered, I think he can recite the results of his study.
I'll sustain the objection. Has the differences technique been validated by Oregon courts? Is there a case on point that says this is a type of method that's used and usable and scientifically valid?
Do not have an answer to that question.
Then you have done an insufficient job of explaining to me how this method works. If I'm told it exists, then it exists. If I'm not told it exists, you're going to need to do more than what you've done so far to convince this court that it's valid. And I understand you disagree, sir. I don't approve of lawyers shaking in their heads, just so you know. Okay, go ahead.
Is difference in difference a form of regression analysis, Dr. Siegel?
Yes, it is.
How does regression analysis work?
Essentially, what regression analysis is taking a set of data, and essentially the way to think of it is drawing the best line to connect all the points. In other words, you're developing a linear, or in some cases nonlinear model, but you're drawing a curve that best fits the data. So you're drawing the best line that comes closest to all the points.
And we're using two terms, difference in difference and regression analysis. Can you describe the relationship between difference in difference and regression analysis in the context of your study?
Yes, difference in differences is a specific type of regression analysis. In other words, regression analysis is the broader term. There are many types of regression analyses. A difference in difference analysis is one type of regression analysis. It happens to be the most rigorous type, and that's why it's used in policy research, because before we conclude that a law is effective in, say, reducing an outcome, we want to be very sure of our conclusion, and therefore we use the most rigorous type of regression. There are other regressions one could use that are less rigorous, but I chose to use the one that's most rigorous because we wanted to be as conservative as possible.
Why are regression analyses a useful tool in general?
It's a useful tool because it's an objective way of modeling the data. In other words, one could take the data and one could just draw a line in one's mind. One could say, okay, I think, it looks like it's going in this direction, or it looks like it's going in that direction. But that would be a subjective judgment. we don't do that in statistics and in epidemiology. We use empirical statistical methods to determine what actually is the pattern in the data.
And why are you trying to observe patterns or relationships within the data?
Ultimately, it's because we want to know the relationship between two variables. In this case, the relationship between the presence or absence of a large capacity magazine law and the number of mass shooting events that occurred in a state, or the number of mass shooting casualties that occurred in a state.
Your Honor, I think we are ready to ask him the results of his study based on the record that we have offered to explain the methods used in this study and their general acceptance in the field of epidemiology and social sciences generally. I expect Mr. Aiello may object.
Your Honor, may plaintiffs ask line of questioning in aid of objection?
Yes.
Dr. Stiegel, you stated a number of variables that you controlled for. You did not control for the presence or absence of other firearm laws in reaching your conclusion regarding so defined large capacity magazines, correct?
No, we did control for the presence or absence of 7 other laws. As I testified yesterday, there were 8 laws that we looked at. We controlled for the other 7.
The 8 states that you looked at that had restrictions on so defined large capacity magazines had other firearm laws, correct?
Yeah.
You testified yesterday that causality is something you're looking for in a study, correct?
Well, not necessarily in an individual study, but when you have a group of studies, a number of studies that have been done, you can put all of the evidence together to draw a causal conclusion. I would not likely draw a causal conclusion from just one study. I would want to see a number of studies, and that's why in my in the exhibits which were shown, I reviewed the results of multiple studies before drawing a conclusion.
You stated in this study that you could not draw a causal conclusion, correct?
Correct. I would not draw a causal conclusion from a single study, from one study.
This study looked at other studies in addition to your own, correct?
Well, it cited other studies, but the data is original. In other words, the data is just from this study, but we did cite other studies in the discussion.
So I'm looking here first off at your public significance statement. Isn't it true that the public significance statement states we cannot definitively conclude that implementing a specific law would lead to a change in the incidence or severity of mass public shootings?
Objection.
Yes, exactly.
Outside the scope of the methodological discussion.
Your Honor, if his study cannot conclude that there's a causal outcome determinative relationship, one, I doubt its relevance whatsoever, as well as the scientific rigors to which the witness put his study. I have a few more notes within this line of questioning. I don't see this study reaching any conclusion other than a correlation, which Dr. Siegel testified yesterday. Correlation is not enough. I think any first-year humanities major learns that correlation does not equal causation, and Dr. Siegel's study says that it does not reach a causal conclusion. So what possible relevance does it have to this court or a facial challenge to ballot measure 114?
So we'll argue
Because
questions.
every student in,
I'm not asking you, sir. I'm
sorry.
letting the doctor, I appreciate your activity, but this
I'm
attorneys will
sorry,
figure this piece
I
out
thought that
first.
was, I'm sorry, I thought he was, that was a part of his question. My
No,
apologies.
that's all right. Thank you. Go ahead, please. Mr. Marshall, if you can't in the study come to any causation determination based upon the information he has, why would the court accept it as scientific evidence?
Are you asking me to argue? I'm sorry.
Yeah, I'm just
Oh, I
asking.
apologize. I wasn't sure if you were asking me to resume questioning the
No, I'd
Dr.
like you to-
Siegel
I'd
or.
like you to respond to that because that is a fundamental
So-
question of what this is in terms of evidence.
Yes, Your Honor. So let's start beginning with what is relevant to this proceeding and what we are trying to establish with Dr. Siegel's testimony. We are seeking to establish with Dr. Siegel's testimony that the voters' judgment that Measure 114 would have benefits for public safety was a reasonable judgment. One piece of that evidence is that it is consistent with the academic work in general that studies the relationship between large capacity magazines and as well as between large capacity magazines and their use in mass shootings, along with the number of fatalities in those mass shootings. Another piece of evidence is the relationship between large capacity magazines, bans, and the severity of mass shootings.
Right, I agree that that's what you're trying to show the court.
Okay. So with respect to Dr. Siegel's opinion, there's one piece of relevance is just the fact of these studies existing in the world. Perhaps we don't need Dr. Siegel's testimony to establish that, but the fact that they existed in the world would be a reason for a voter to say, I agree with that, maybe I should vote for it. But in terms of us presenting scientific evidence on this point for the court, given that the plaintiffs appear to be arguing that there are negligible public safety benefits, no public safety benefits, or perhaps that it's counterproductive for public safety benefit, we are calling Dr. Siegel for that purpose. He has a number of bases for his opinion. One of those bases is the research that he's conducted himself. The other bases for his opinion are the 8 other studies that he has reviewed in preparation for his testimony. So they're 4 plus 4. So we haven't gotten to the second chart because you asked me for the fullness of this. So the first chart relates to the relationship between the use of a large capacity magazine and the number of fatalities in those mass shootings. The next chart would have 5. It would have Dr. Siegel's study along with 4 other studies that come to the same conclusion that there is, when you look at changes in state policy, a change between when a change in the number of fatalities from mass shootings over time. We were going through yesterday that there are multiple factors to the way that so first of all, I don't think it's necessarily, I think the fact that there's a correlation is relevant to whether the judgment of the voters was in fact reasonable. But even if the standard were higher and it were causal, Professor Siegel testified yesterday that the way that epidemiologists try to determine causation is they look at the totality of evidence, whether it is consistent evidence, for example, all in the same direction as these 9 studies are, and then look at whether there's a plausibility to that it would not be a spurious correlation as opposed to a real correlation, or as opposed to a causal relationship. Dr. Siegel's opinion is that this does have a causal relationship in reliance on all of those factors.
But doesn't his study say that there's a correlation and not a causation impact? To me, that becomes, but go ahead. Is that what it says?
I need to make sure that I'm accurately conveying. I believe that's right. And my answer to that is first, correlative evidence is relevant for the determination before the court. And my second answer is it's not the full, that this article is not the full basis of the professor's opinion.
Well, first of all, I would say relevance changes when we start talking about scientific evidence. It has to be more than there's this correlation. There has to be causation demonstrated through the studies, or it's not a scientific method that comes to a scientific conclusion. It may be a scientific method, but unless there's a conclusion that can be drawn from that evidence that shows a direct causation, then it is not admissible as expert evidence, expert scientific testimony. So if in fact that is the determination of that particular study, then I would say that it is not scientific evidence as defined by the law. That's not to suggest the doctor is not a scientist, just it does not meet the definitions of Oregon's law around scientific evidence.
Your Honor, may plaintiffs be heard briefly?
You've been heard on that issue. If your evidence today is going to be there's correlations, but we can't demonstrate causation, that's fine. But that doesn't, I'm not going to admit it as scientific evidence.
So the evidence, the testimony would be that the totality of the evidence supports a causal inference. This piece of foundation for that opinion has the limitation in there. What the statement says is we cannot definitively conclude that implementing a specific law would lead to the change in the incidence or severity of mass shootings. However, laws that limit potential shooters' access to firearms by requiring permits may reduce the incidence of mass shootings, and laws that limit the number of shots that can be fired before reloading may reduce the severity of mass public shootings when they do occur.
May.
Yeah, I understand.
Right, sure. It may do that.
And
It
so
may not, but it may. It may decrease the severity of mass shootings. It may not. I mean, I don't see how that gets me to an objectively reasonable determination that this is scientifically based evidence. That's the conclusions that your expert is going to make. I appreciate all of his hard work in this field, but I'm not going to admit it.
So, Your Honor, the difficulty I'm having is that it seems that I don't want this to be based on a misunderstanding of what Professor Siegel is prepared to testify to. Professor Siegel is prepared to testify that in the totality of evidence through these 9 studies, that there's a causal inference that can be drawn, and that totality of the evidence supports a causal inference.
So he's going to testify in front of this court that there's a causation, something that he's never published is true. That's what you're going to have him do under sworn testimony?
Yes.
To come to that conclusion?
Yes, that his belief is that
definitively this proves this policy works.
I would not.
That's what you're going to do. I'm interested to hear the doctor say that on the record, if that's what he intends to do, and you can lay the foundation for it, which you've not done at this point.
So I'm not representing that he will say that he definitively knows with certainty that it will. What I'm saying is that the balance of evidence in his opinion, including all the factors, not necessarily all the factors that you would allow him to rely on, would support a causal inference. So I don't want to, I mean, if the court is.
He's 51% certain that there's a causation. Is that what you're suggesting? Because that's not scientific evidence.
I have not reviewed specific percentages of likelihood with the doctor. I don't know what he would respond to in answer to the court's question on that.
Okay, well, maybe you should have that conversation with them and we'll take a break.
Oh,
You can say it again. I do.
oh, maybe he hopefully knows.
Main Senior Court is now in session.
You may continue, Mr. Marshall.
Your Honor, the representation I can make to the court about what we can ultimately expect the testimony to be is that Professor Siegel would opine that the totality of the evidence supports the conclusion that a causal inference supports a causal inference. He would not be able to testify that causation is certain. In support of the admissibility of this evidence, I can point the court now to Jennings against Baxter Healthcare Corporation, 331 Oregon 285 at 309. In that case, the Oregon Supreme Court said a conclusion about causation is ultimately a qualitative decision, but still nevertheless let it be admitted under 702. The second case I can point the court to is Markham against Adventist Health, 345 Oregon 237 at 248. And in that case,
What was the site again, please?
I apologize.
That's okay. That's fine. I just
No,
didn't
I'm
catch
reading
it
too
all.
quickly.
345.
345 Oregon 237
237. Okay, thank you. That's fine.
and the Penn site is 248.
Thank you.
That in that instance that it was a medical case. This is a medical kind of a medical injury type of case, but that medical causation often cannot lead an expert to conclude with certainty that event A caused condition B. Rather, in many cases, a number of potential causes will be ruled in, each of which has some percentage of likelihood of having caused the plaintiff's condition. I think that this is analogous authority to the type of testimony that Dr. Siegel is prepared to present today to make a qualitative judgment about the likelihood of causation based on the scientific assessment of the correlative literature in totality. If the court disagrees with that, we're prepared to make an offer of proof.
Well, I don't know these cases, so I need to go read these cases. I'm going to take a break until probably 10:20.
Your Honor, can plaintiffs just state one thing for the
Yeah,
record
if
for
you
your
have additional
consideration?
case law you'd like me to consider, otherwise we should read the cases and talk about them.
Your Honor, not case law. What I'd like to point out is that this totality of the evidence analysis on which Dr. Siegel is relying is in part reliant, as Dr. Siegel testified yesterday, on plausibility. Okay, so the plausibility analysis that Dr. Siegel is relying on was excluded yesterday by this court when the court heard Dr. Siegel testify as to two mass shooting events that where the shooter supposedly had to pause to reload. As that is part of the analysis, and this court has already concluded that, for want of a better term, Your Honor, that's not good science. That's plaintiffs just want that. Since it was testified yesterday, just want to remind the court that he's relying on plausibility. Plausibility is two of the north of 100 events that he considered in this study.
Okay. I don't think that's exactly how I thought about it and ruled on it, but what I said was coming in here and talking about two specific events based on collateral information and deriving some sort of analytical scientific conclusion from it was not scientific evidence. I'll review the cases and I'll come back out on the record. Probably talking 10:30 actually. So if y'all want to work on the legal question, we'll get to it and I'll make a decision as to how we proceed from here. Actually, before we go off the record, state again what he is capable of testifying to, Mr. Marshall, so I have it clearly written down.
I believe that Dr. Siegel will testify or would be prepared to testify that based on his review of the totality of the evidence, that it supports that there is a causal relationship between state prohibitions of large capacity magazines and the lethality of mass shootings, and that he would make the same conclusion regarding the use of large capacity magazines in mass shootings and their lethality, that he would not testify that that relationship could be determined with certainty because in his field, effectively nothing is certain.
Well, I doubt that. If that's true, I don't understand the value of it. But okay, we'll go off the record. So what is the limitation on his ability to come to direct testimony on causation?
Your Honor, are you asking what is the limit under 702 or what is Dr. Siegel's what am I predicting Dr. Siegel's testimony will be?
I'm only
Sorry.
interested in 702.
Okay, understood.
Mr. Marshall, is it because of the rate of error, because of the sample size? What is the issue that doesn't allow him to come to a conclusion?
He is able to come to a conclusion that it is the likely cause. The limitation on the certainty of causal relationships, I think that Professor Siegel will say the reason why he won't be able to testify to the certainty of causal relationships just relates to the nature of scientific evidence, and that causal relationships have sort of a necessary uncertainty, that correlations can be determined and calculated. Causation is a matter of judgment. It's a qualitative judgment, as the Oregon Supreme Court explained. And therefore, while it is, highly likely to be causal, that absolute certainty, I suppose, exists in theory, but in the types of epidemiological work that is done with public policy, that absolute certainty is just not available. So I wouldn't say it would be.
I'll walk it back a little bit on that particular issue, but I want to understand what the hesitation and resistance is. You have obligations to the court, to the admissibility of 702 to explain through the case law how and what limitations exist to the decision-making process of how he comes to a conclusion. Certainly under Brown, there's the question of rate of error. There's the question of subjective interpretation. You haven't laid any of those pieces out for the court before I would admit conclusions. And you haven't obviously presented any data on how he came to these conclusions either, with the exception, I guess, of the initial testimony that he looked at some events in Canon from 1984 to 2016. There were 82 mass shootings in America that he looked at. So I just need to understand. I want to understand for this record what the data is before you draw any conclusions. You are sort of jumping way ahead of where you're at in terms of your foundation under 702. I expect you to lay it before I'll admit it.
Okay. Would you like me to do that through examination?
Yeah.
Okay.
I would. I just I wanted to let you know what I'm thinking about so that you're able to confront the questions in front of you in terms of this particular type of evidence.
And in terms of the data, I think we covered some of that yesterday, and maybe that was inadequate. The yesterday, I think Dr. Siegel testified which data set he obtained and used.
Okay.
So maybe I'm misunderstanding the court about what is needed in terms of data.
Sure. I mean, I want to know I want to understand the process that led up to his conclusion from start to finish, that there have been mass shootings. There's no doubt that people die from firearms. There is no doubt that the population of Oregon has increased by 10% since 2000 is in doubt. Look at the census numbers, it's been 20% increase, but we can work through all these numbers together. So I'll have you do that with him to explain to the court how he comes to his corollary determination in his published work, and how he's going to now turn that into a causation in front of this court and on this record that's going to be reviewed by another court. So feel free to begin your process of examination from the beginning. I understand there's this differences on differences analysis. What has not been made clear to me is how you identify the rate of error with regards to that particular process, how qualitative versus quantitative that evaluation is, what level of interpretation is allowed by an expert to come to conclusions, because that qualitative piece is very concerning to the court here. particularly when I hear that in his actual published peer review work, he says they can only pull a corollary, not a causation. So you're going to need to walk me through all of those pieces, Mr. Marshall, before I'm going to admit any type of conclusions. Is that clear?
It is. The difficulty is trying to have him testify from memory, but I will do my best on that, and then I guess point him to that article. Dr. Siegel, I just want to make clear that the court has asked that you not reference your article. If there's something that you don't remember from your article, but you used to remember it, please let me know, and then we'll take it up from there.
Well, let me say he's welcome to reference his materials in making his testimony, and he can rely on out-of-court statements to do that. He just can't read to me out of his article.
Okay, so I want
you understand the distinction under 703, right?
I do, but I thought the objection was to him looking at his article, and I think it's going to be much more difficult to stay on the same page literally.
He can look at his
okay.
article. Here's the thing: he can look at it. You can't be referencing page numbers or asking us to admit that, because I'm not going to admit that.
Okay.
Without other foundation.
Okay.
Go ahead, please.
Okay. Let's look at page 353 of Exhibit 143. We've labeled, Dr. Siegel, your article, The Relation Between State Gun Laws and the Incidence of Severity of Mass Public Shootings in the United States, 1976 to 2018, as Exhibit 143. And I'm asking you to look at 353.
Okay, got it.
Do you see Table 1 on page 353?
Yes.
What are you trying to describe when you describe the average mass public shooting rate and total number of events and deaths by state from 1976 to 2018?
So what this is showing you is for each of the 50 states in our analysis included all 50 states, what the average rate of mass shootings was, how many events there were, how many deaths there were, how many non-fatal injuries there were, and how many total victims there were. And this is the baseline data that we used, that we put into the regression analysis, along with the presence or absence of the large capacity magazine laws. So there's two variables. The outcome variable is the mass shooting rate, or the number of casualties. The independent variable, or the predictor variable, as we sometimes call it, is the presence or absence of a large capacity magazine.
And as you testified earlier, what did you do with these data in order to perform a calculation that you report in this article?
So we used a very standard method in epidemiology called difference in differences. It's essentially a regression technique that looks at the rate of mass shootings, or the number of casualties, before and after an LCM ban went into effect in each of the states in which it went into effect, and compares the change in the number of deaths in all other states during the exact same time period.
On page 355, there's a table 2 that says logistic regression model results. What does logistic regression model results mean?
So we did two analyses. One was to determine which laws, if any, were effective in reducing the incidence, the occurrence of mass shootings. And the second analysis was to determine which laws, if any, were effective in reducing the number of fatalities when a mass shooting does occur. So this table deals with the first question. What laws were effective in reducing the incidence of mass shootings. I believe.
Did you calculate, excuse me, Dr. Siegel, go ahead.
Oh, I was just going to say, I think that table 3 and 4 get to the second question.
What is the second question?
Whether or not LCM bans affect the number of fatalities in a mass shooting.
Did you calculate a confidence interval when you reported these results?
Absolutely, we did. And that is what is often referred to as the error rate in a study. We always report error rates. I always report error rates in all of my studies. And it's routine in the literature.
What confidence interval did you report? At what level of likelihood?
I reported the 95% confidence interval. And that is absolutely a standard level.
Have you described the import of Table 5 yet? Or was that described in your earlier testimony?
Well, we haven't, I don't think we've gotten to Table 5 yet.
What other pieces of the analysis did you conduct other than those we've discussed so far?
I believe, I think we've covered everything. As I mentioned, we controlled for a host of variables, including the presence of other state laws. So it wasn't just looking at these 2 variables. We controlled for, I believe, 8 or 9 other variables.
Did you report a correlation between large capacity ammunition magazine bans and the fatalities in mass shootings?
Objection, Your Honor. Lack of foundation. May I ask a question in aid of objection?
You may.
Dr. Siegel, your report concluded that compounding this problem is the fact that some state laws were enacted in a small number of states, further limiting the effective sample size and reducing our power to detect an effect of these laws if one exists, correct?
Yes.
You also concluded, finally, because we were unable to control fully for confounding factors that could explain the observed results, we cannot infer causality from this study, correct?
Yes. As I said before, I don't think we ever infer causality from a single study. The way in epidemiology that you infer causality is by looking at all of the studies together. It's the only way you can infer causality in epidemiology. You have to look at all of the studies, not just one.
I must have misunderstood his testimony that he looked at all the other studies prior to writing this report. Is that inaccurate?
Are you asking me or the
Asking you,
witness?
Doctor, I understood you to have reviewed the other reports prior to making this report, and that you used it as a part of your base census.
I'm sorry, which report? You're using the word report, but I'm not sure what you're referring to.
Your
Oh, the article.
That you looked at all the other studies prior to creating this report.
No.
Article, excuse me, go ahead.
No, I did not. I had not done a formal review of all the literature prior to writing this report. I did a formal review of the literature in coming to the opinions for this case.
Okay. You have additional questions?
Yes, Your Honor. Dr. Siegel, you cite the reports in this study, correct?
Yes, of course. I mean, it's common when you write a study, it's common to cite other articles that have been written about the same topic.
So you did in fact review the reports that you're testifying now you used to come to your conclusion prior to writing this study, correct?
Well, I had seen, yes, I mean, I had seen them. I had seen those studies, but I had not done any formal, I did not do a formal review of those studies.
And yet you still concluded, that you cannot even infer causality from this study, correct?
Objection, misstates prior testimony.
I'm reading from the report, Your Honor.
It's conflating the gentleman's conclusion of these data versus the conclusion of a review of the entire literature.
And he just testified that he read these studies, he wrote this report, reached the conclusion that causality cannot even be inferred, let alone concluded, not even inferred, which I think is a much lower bar than conclusive. And so he looked at these studies, did his own study, and still can't infer causality, and is now going to testify in court. And now he's going to testify.
Dr. Siegel, please,
Yeah.
please, we have to go through counsel and have the court's ruling about the question.
Okay, but my testimony is being mischaracterized.
That is my objection, that it's being mischaracterized.
Well, you can ask him some questions to clarify his testimony based upon this objection. I'll hear that.
Dr. Siegel,
May I finish, Your Honor? I got cut off by
I'm sorry,
the witness, and
you
then
did get cut off. I apologize. Feel free to complete your testimony, and doctor, please allow the lawyers to do this inartful work that we do.
Thank you, Your Honor. So what I'm hearing is that Dr. Siegel reviewed the studies, at least cited them in his study, performed his own study, and still could not reach a conclusion that that causality could even be inferred, let alone concluded. Now he's going to testify before this court that he's reached a conclusion based on the same studies he cited. Plaintiffs don't understand that. Plaintiffs assert that he lacks a scientific, this study and his conclusions lack any scientific foundation.
Go ahead, please, Mr. Marshall.
may I question the witness, or you were asking for my argument?
No, I'm asking, I turned to you if you wanted to ask him additional questions on clarifying this record, and then you can argue the objection.
Yep. Dr. Siegel, how is your testimony mischaracterized?
I did not review all of the other studies. The fact that they're cited, a citation is simply an acknowledgement that that study exists. I did not review those studies in writing the article. I only reviewed those studies in the context of coming to my conclusions for this case. Prior to this case, I had not come to a conclusion about the causality of large capacity magazines. And so that's why in this particular article, we said we couldn't conclude causality, because in one article you can't conclude causality, and I had not done a review of all of the literature.
.357.
You wrote, I have further questions. On 357, you wrote, we cannot infer causality from this study. That is in the right column of 357 in the final paragraph. When you wrote, we cannot infer causality from this study, were you referring to the evidence presented in this study alone, or the entirety of the scientific literature?
No, just the evidence in this study alone.
And what is the difference between citing a study in an article versus performing a totality of the evidence review?
Well, you would have to present the data from that study. You just, in other words, just to cite a study, it's like a reference. You're just citing the study. But to actually review the data, you would need to actually articulate what the data was. And, typically what I do is put it in a table. And I have all the data, all the studies next to each other in a table so that I can look at the synthesis of all of them together. We did not do that in this paper, and that wasn't the purpose of this paper.
I've completed my examination on this point, and I think I believe, if I'm following the proceedings correctly, that the question I was going to add, that we're on the objection from Mr. Aiello as to what on the report on what this article reports as the relationship between state large capacity magazine prohibitions and fatality rates, and whether the court is going to allow that testimony.
Your Honor, to clarify my objection, I'm objecting lack of scientific foundation. I would like to restate for the record that part of Dr. Siegel's conclusion is the totality of the evidence, which in part includes a plausibility analysis. That plausibility analysis is based, as Dr. Siegel has testified, on 2 events out of many that he reviewed. And there's defendants have not made any showing of Dr. Siegel's background with firearms, his understanding of reload times, or anything that would substantiate Dr. Siegel's plausibility conclusion that reloading, that being forced to reload would reduce fatalities in mass shootings. There's no foundation for the plausibility analysis, which is part of his totality of the evidence conclusion, as Dr. Siegel testified yesterday. I'd be happy to re-question Dr. Siegel on that issue.
We're switching topics. I have a question that I would like the court's ruling on, rather than, I mean, the court instructed Dr. Siegel.
The objection was foundation. So we asked the question and I'll make a ruling. If we've gotten so far down the road now, I'm a little lost myself.
Did this article report the results of your analysis regarding the relationship between large capacity magazines bans and fatality rates in mass shootings?
That's a leading question with a yes or no answer. You can answer that.
Yes, we did.
Yes or no? Okay.
Yes.
What were those results?
Now we have a problem because I don't understand the data. And I don't understand what specifically he was evaluating. You haven't walked through any of those pieces with me. You're sort of giving me broad generalizations about the fact that he looked at stuff, and as a result of that stuff, he came to some conclusions about stuff. I want to know what the data is. And then based upon that data, I'll determine whether or not I'm going to allow him to testify to ultimate conclusions. Are we clear?
I think so. On table 1 of page 353 of exhibit 143, Dr. Siegel, is that the data that you reported as part of your article?
This is the outcome data. In other words, this is the data on the rates of mass shootings, the number of events, the number of deaths, the non-fatal injuries, and the total victims. So this is the outcome data that we used, the summary of the data.
And what is an event?
Event is a mass shooting.
How is a mass shooting defined in your article?
In our article, we define mass shootings as shootings that involved 4 or more victims other than the shooter, and that took place in a public place, not in the context of committing another crime.
Dr. Siegel, I think you may have inadvertently turned off your video feed. At least we can't see you.
I apologize. I had turned it off during the break and I forgot to turn it back on.
So this is your definition. The definition used in your article is involving 4 or more victims. I need you to identify what you mean by victim.
Fatalities. 4 or more
These are-
fatalities.
These are fatalities.
Fatalities, yes, absolutely.
Okay. Okay.
Over the whole course of your study,
We have Spiro, which talks about the fact that saying victim in the context of a criminal case, at least, is impermissible. Vouching is a ultimate fact that needs to be determined. And so I bristle based upon that case law when I hear victim. I'd like you to speak with more specificity and not be argumentative on this record. That is the case law.
Dr. Siegel, are you familiar with the term casualty?
Yes.
What do you understand the word casualty to mean?
Well, casualties would be the sum of the fatalities plus the non-fatal injuries.
How many casualties did you were used to report in your data set?
There were a total of 2,772 casualties.
How many
I
were?
understood that that's not the data he was looking at. You just told me that he was looking at fatalities, not casualties. Again, specificity is required when evaluating this type of evidence under 702. You've just conflated 2 very different concepts. You told me he's relying on one concept. Now you're talking about another concept. Please
I disagree.
articulate to the courts what the conclusion is based on in terms of data. If it's on fatalities, I want to know that. The fact that you have additional casualty numbers that you would like to add to the record, if it doesn't contribute to his decision, I'm not interested. If it does, then feel free to explain it to me and why I should consider it. You understand that you've conflated 2 things, correct?
I disagree, Your Honor. I was trying to comply with the court's ruling to not use the word victim so that I could go through the description of the data that was requested. The court requested that there be data. I was going to walk through the sums of that. With respect to the conflation of 2 issues, I was talking about the total number of data, the mass shooting data being defined, a mass shooting being defined for inclusion in the data set as being 4 or more deaths is a different question than how many casualties were there in the data set as a whole.
I understand.
Okay.
I'm
doing my best to be organized. I
I'm trying
understand.
to be very careful here because I want to understand scientific conclusions.
Okay. In table 1, how many events did you were in your data set?
There were 155.
How many deaths?
There were 1,078 deaths.
How many non-fatal injuries?
1,694.
Well, you already said that. With respect to the relationship between any of those data and large capacity magazine bans, what did you report? Did you report something about a relationship between fatalities or injuries or casualties or all of those?
Both. First, we looked at fatalities. Second, we looked at non-fatal injuries.
Normally, I'm supposed to be the one to be able to point you to this, but can you help me where that where that data is reported in your article?
The fatality data is the results are reported in table 4, and the non-fatal injury data is reported in table 5.
Okay. Table 4 is labeled negative binomial GEE model results. What does that mean?
Well, this is we use what's called the negative binomial model because it is appropriate for analyzing count data. Since the number of deaths is basically a count, the negative binomial model is the appropriate model to use for that type of data.
And in table 5, it says the zero inflated negative binomial number model and negative binomial GEE model results. What are you reporting?
Here we did 2 different models. Again, to test the robustness of the results. The first model was what's called the zero inflated negative binomial model. And what that does is it throws out the zeros. In other words, it only looks at cases where there were deaths or non-fatal injuries in this case. The negative binomial model looks at all cases, including the 0 cases. And we wanted to see whether the results would be similar between the 2 methods. Finding drastically different findings would be a red flag that these results are not robust.
Was this article peer reviewed?
Yes.
What does peer review mean?
Peer review means that it is sent to reviewers who are typically experts in the field of the topic that you're writing about. They review the article, they make comments on it, and then they make a judgment as to the validity of your results. Typically, the editor or the editorial board of the journal will then read those comments, those reviews, and make a decision about whether or not the article is acceptable for publication. Typically, even if the article is acceptable for publication, you will be asked to revise your article based on the comments made by the reviewers. So the first article that you write, the first draft, is never what the final paper looks like. The final paper will incorporate any comments that you got from the reviewers.
How many times have you gone through the peer review process as an author?
Approximately 180.
What about as a reviewer?
Probably 120 or so.
If the peer reviewers disagree with the scientific validity of an article, would they typically recommend publication or not?
No, if the reviewers have any issues with the methodology or the conclusions, very unlikely that the paper is going to be published.
Is publication in a peer-reviewed journal a strong signal that the work has been accepted by a scientific community?
It generally is.
What relationship did you report between the number of fatalities in a public mass shooting and a large capacity magazine ban at the state level?
Objection, Your Honor, lack of foundation.
Sustained.
I think I need to confer with my colleagues. We understand the court has ruled and we've made our record on this point, and I have an offer of proof more broadly on Dr. Siegel.
What you've shown me so far is that there have been 155 mass shootings from 1976 to 2018, and the numbers of deaths and non-fatal deaths have been provided to the court. If that's your offer of proof, fair enough.
Your Honor,
If that's what you're asking me to make a decision on, in terms of coming to a conclusion as to policy, I sustain that the foundation has not been established.
Your Honor, if I can make my record about what I think the foundation was.
Sure.
So in addition to the foundation of that one table, Dr. Siegel testified yesterday about the compilation of a data set regarding the state laws enacted over this period in 1976 to 2018. He then described how he used commonly accepted statistical techniques to show the relationship between that first set of data, the laws, and the second set of data, the outcomes. I asked him, he also has testified that he has reported confidence intervals, which is the equivalent of an error rate in his field for that data, and that it has been accepted for publication in a peer-reviewed journal in the United States. I've asked him what that conclusion is regarding the correlation, and I think that I have I think we've made our record as to the foundation.
Sufficient data for the court to allow a scientific conclusion? That's what you're telling me.
We do.
Okay, well, on that record, I sustain the lack of foundation.
We have, so as an offer of proof,
An offer of proof? Under what theory of offer of proof? Your offer of you've made your foundational record on why you think this is admissible. I have denied it. I'm not going to allow you an offer of proof beyond it. If you have something you wish to continue to provide to the court for foundation, I'll hear you, but you're not getting an offer of proof to tell me that I'm all wet on the policy determinations. I'm not interested in that. You make your record. If you can't make it, then you're not going to get the evidence in. So go ahead, please, Mr. Marshall.
I'm done making the record on the foundation. I was hoping to say what Dr. Siegel would testify to were the court to rule otherwise. If I'm not able to do that, then I understand that.
You're not allowed to do that without laying a proper foundation. I think we all know you've said what you think you would say, and you have not laid a proper foundation for me to allow that type of evidence in. 702 is a very tricky statute. It requires very specific data sets and other conclusions to be made. If it were so simple as an expert comes in and says, I'm an expert and I've concluded this, then we wouldn't even have a need for 702. Just be experts are admissible. That's not it. So I'm not going to let you make an offer of proof. You can either continue your examination or call your next witness.
We have I mentioned yesterday that Professor Siegel is able to testify to other points that the court has excluded. Was what I said yesterday sufficient to describe what he would have testified to on those points?
Based upon your request for a facial challenge and my determination, you tell me what you think. If you think it's sufficient, then I'm fine with it being sufficient.
Well, I would rather just articulate to the court what Dr. Siegel would have testified to on the pieces of the motion in limine that were denied had the court ruled otherwise.
Time for that would have been at the time of the motion in limine.
And then
I set a hearing in advance of this proceeding to allow you an opportunity to be heard. It was given proper notice. You had an opportunity to be heard at that, and you did not present me with any additional information that at that time required me to make a different decision.
As we covered yesterday, Dr. Siegel was not one of the named witnesses that the motion in limine was requested of. So we would be, had the court not decided that the implementation motion in limine also covered evidence of the efficacy of other states, we could have provided more detail about Dr. Siegel's potential testimony on that point.
Anything else?
In addition, Dr. Siegel has published Broadening the Perspective on Gun Violence and Examination of the Firearms Industry, 1990 to 2015. That relates to the public health implications of changes in firearms technology, and all of those pieces of information would be excluded by the court's ruling in response to motion in limine from the plaintiffs to exclude Dr. Cook's testimony. So while Dr. Siegel would be prepared to testify on that, we understand it is barred by the court's ruling. The court also excluded evidence related to the Charleston loophole. Had the court not so ruled, Professor Siegel would have testified that in 2020, at least 2,989 disqualified individuals throughout the United States were allowed to obtain firearms without a completed background check that would have been disqualified had the background check been completed. To the extent we have further information about about anybody about anything that Dr. Siegel would have been prepared to testify to, I think we will be able to provide that in writing this afternoon through a filing.
Anything else, Mr. Aiello?
Your Honor, plaintiffs moved to strike Mr. Marshall's last comments. I believe the court said that the court would not receive an offer of proof and that the appropriate time to make that offer was at the motion in limine unless plaintiffs misunderstood the court's ruling.
I'll strike it.
And Your Honor, plaintiffs also moved to strike the entirety of Dr. Siegel's testimony as a foundation was not laid.
I'm not going to do that. Anything else?
No, Your Honor.
Not for the state defendants, Your Honor.
Okay. Call your next witness then. That's everything, Doctor. Thank you.
Okay, thank you so much.
The state defendants call to the stand Jorge Baez. I think we will be, yes, I think he's on site.
Okay. Stiles, if you would please, sir, up here. Stop right there and raise your right hand. Under the penalties of perjury, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. You're welcome to have a seat up here. Once you're seated, state your name for the record and spell your last.
Jorge Baez, B-A-E-Z.
Your witness.
Your Honor, we have a PowerPoint presentation associated with this witness, and we would like, we only intend to provide it as a demonstrative rather than moving for its admission into the court record. But I will hand a copy up to it and request that it be able to be published on each of the screens in this courtroom.
Have you seen it?
No, Your Honor.
Oh, I'm sorry, your copy's already in that stack. Ray, can you make sure that we have given him, that we know which one of those the latest copy?
Is it marked in my book or no? Okay. Thank you. And you may publish and you may object if you think there's something objectionable to it, but I'm going to wait until the conferencing is done here before you start your piece.
Yeah, this looks like a draft to me.
All right. Are you ready then, Mr. Aiello?
Yes, Your Honor.
Go ahead, please, Mr. Marshall.
Well, I'm noticing that it says September 20th, and we're running a little behind of where we had expected to be. And so thank
Such
you,
an
Mr. Baez,
number.
for changing your flight in order to allow us to examine you in person. Mr. Baez, where do you work?
I work at NERA Economic Consulting.
What is your role at, well, first off, what is NERA Economic Consulting?
So NERA is a firm that does economic consulting and basically does analyses related to economics and quantitative issues for clients in a variety of different industries.
What kind of analyses does NERA do?
Well, NERA does all sorts of economic, quantitative, financial analyses, a lot of data analyses. That's our bread and butter across a wide variety of different areas.
What kind of work do you do personally?
The focus of my work is economic, statistical, and quantitative analyses for clients such as governments, NGOs, corporations, and parties in litigations. Almost all of my work involves analyzing data using scientific methods in a variety of different fields. So for example, I work for the World Health Organization, analyzing the effect of asbestos bans worldwide. I've worked for corporations and boards of directors, analyzing a variety of different data to help them make business decisions. And I've worked for parties in litigation, doing analyses related to financial, economic, and statistical issues.
How many years have you worked at NERA?
I've been at NERA for over 18 years.
What's your title?
I'm a managing director.
Is that a senior position, a junior position?
It's a senior position.
In your role at NERA, have you ever worked on anything related to firearms and crime?
Yes, I've been working on a variety of different cases related to firearms and crime for the past over 10 years at this point.
What is your educational background?
I have a BA in economics and physics from Vassar College and an MBA from Yale University.
Did you study quantitative methods in those educational endeavors?
Yeah, they were the basis for most of my classes, both in the undergrad and in the master's program.
The plaintiffs, the defendants move to under 702 to identify Mr. Baez as an expert in statistics and quantitative social science.
Your Honor, objection, lack of foundation and relevance. I'm not entirely sure what economics has to do with ballot measure 114.
I assume he intends to eliminate the court, but in terms of a foundation, and the court acknowledges that he has expertise in statistics and qualitative social sciences. Is that what you said?
No, I said quantitative, not qualitative. I'm sorry. Or I meant to say at least. Maybe I said it misspoke. Quantitative social science.
I might have added an L where there should have been an N. I acknowledge that that's what it's being presented for, and we'll just see where we go from here.
Mr. Baez, let's look on slide 3 for the benefit of the court. What issues did you prepare to testify on today?
I was asked to analyze two main issues. The first one related with defensive gun use, and in particular, analyze the number of shots fired by individuals in self-defense incidents. And the second one involved public mass shootings, and in particular, analyze the outcomes when large capacity magazines are used in public mass shootings.
Okay, let's first talk about, well, just for clarity, are these separate analyses?
Yes.
let's talk first about your defensive gun use analyses. What sources of data did you look to analyze defensive gun use?
Yes, we performed 3 different analyses based on 3 different data sets. The first one, which I call the NRA analyses, is a study of an NRA database of defensive gun use incidents over a 6.5-year period. The second one, which I call the Factiva analyses, is a systematic and scientific study of defensive gun use incidents from news stories using the news aggregator Factiva. And the third one, which I call the Portland Police Bureau data analyses, is a study of shooting incidents in Portland with more than 10 casings.
Well, let's talk about each of these data sets separately. What is the NRA Armed Citizen Database?
Yeah, so my first analysis used the NRA Armed Citizens Database, which according to the website of the database collects accounts of law-abiding gun owners in America using their Second Amendment rights to defend self, home, and family. So basically, they have stories that highlight the very conduct that plaintiffs claim the law here impedes. And
Objection, Your Honor. I first of all, I don't think the witness is competent to testify as to what my clients are claiming. And additionally, he's concluding without a proper foundation. The stories highlight the very conduct plaintiffs claim Oregon law impedes. I think that's conclusory.
I think the witness is stating his understanding of it. I think the evidence is perfectly fine without it. I think I'm running into an issue here where objections are being made in the middle of answers, and I think it's leading to a lack of clarity in the record. So my request would be that the court instruct counsel on both sides to object in one of 2 ways: either object at the time of the question or wait for the answer to be completed and then move to strike, because I think it creates a very unclear record when we have half an answer, and it creates a lack of clarity.
So the objection was what?
So first of all, I'm going to object to the PowerPoint as leading. The witness is reading from the PowerPoint. Second,
Hold on, that's a new objection. Go back
Yeah.
to the first
Okay.
objection. I'm trying to.
so the first objection was that one, this witness, there's no foundation for this witness to testify as to what my client's position is. 2, that the NRA, the idea that the NRA database highlights conduct plaintiffs claim Oregon law impedes is conclusory, and there hasn't been a proper foundation laid for that.
Let's go back. I understood it was just a question of impede. So the question that's been raised to the court is one of constitutionality. That is a very qualitative and argumentative statement to say impede. So I'll sustain. You can ask your next question.
And
I think at that point, an interruption was appropriate when an expert witness comes and starts making arguments on behalf of the people who have hired him.
Your Honor,
So, go ahead.
Sorry, and Your Honor, plaintiffs have an objection to the continued use of the PowerPoint. It is not evidence, and it is not a demonstrative. It is leading. The witness is literally reading word for word from the PowerPoint. So plaintiffs would ask that the court disallow further publication of the slideshow to the court and the witness, so that the witness may testify from the witness's own memory.
Okay, so demonstrable aid leading. What's your argument?
I think that this is a aid to the court and to counsel to the extent that it is implicitly using to refresh recollection on particular points. I don't think that there's any harm to that. It is simply would be expedited if there's not a figure or something that Mr. Baez doesn't remember, like how many particular observations there were in a particular data set. This would help him. This is something that he compiled, and I don't think that there's any point to exclude demonstratives like this that go to assist the court in following the testimony and its purpose.
Your Honor, I think the court has a copy of the slides. Plaintiff's objection is to the witness continuing to just read from the slides. Why don't we just, the witness isn't needed if we're just going to read from slides.
I should have brought my Ermwinkle with me. I'm going to allow you to use this document so long as it conforms to being demonstrative only. And if it starts to go into, I mean, he's right in the sense that it's hearsay and, he's not allowed to just read from it, but if it helps. You know what? I am going to strike it. I'm not going to allow it. I find that the second piece around the NRA actively opposing gun restrictions is argumentative. So you can work through his testimony without it. Go ahead.
So I'm sorry, the basis of the court's ruling is that that line is argumentative.
It's hearsay.
And
the entirety of it is hearsay. The database compiled by an entity that actively opposes restrictions on magazine capacity is also hearsay and is awfully broad.
Is that the court's ruling with respect to all the remaining 16 slides or only slide 5?
The slightest idea because I haven't seen them.
Okay, understood.
But it's not just demonstrative per se. It's
Understood. Should I
an
confer?
individual through testimony, which is, yeah.
Okay. Okay. So do you have a copy of that at the stand? I don't think you do.
I do not.
Okay. Okay. Are you concerned that the NRA Armed Citizens Database may be a biased source of data?
Not really. So I think if there is any bias, I would expect that, given that the NRA is an entity that opposes any restrictions on firearms and magazine capacities, I would expect that this database would show highlight stories of citizens defending themselves with firearms in the best possible light and with the most number of shots needed to defend themselves. So if anything, I would expect the bias would overestimate the number of shots fired by people in self-defense.
Objection, Your Honor. Argumentative, move to strike.
I'm also confused about this because I granted a motion in limine. It said that was designed to exclude the number of rounds actually fired in self-defense situations, specifically any data derived from the NRA Armed Citizens Database.
Your Honor, my recollection of the pretrial hearing, and I don't have a transcript in front of me, was that the court denied that motion, but said that it would be only allowed to be presented were a proper foundation to be laid. That's my recollection. If I misunderstood the court's ruling.
No, you're right. It's been a long week, so you're right. I did say that. So thank you for the reminder, and you may continue with your direct examination.
What did you do with the NRA Armed Citizens Database?
We looked at every single story in the database during a almost 6.5 year period from, I believe it's January 2011 to May 2017, covered 736 incidents. We looked at every single one of those incidents, and we reviewed the information that was in the database, as well as compiling additional news stories about each of those incidents. And then we reviewed all that information and tabulated certain information to create a database for each of those 736 incidents. The database would include the location of the incident, the city, the state, where the incident occurred. Was it occurring in the home, in a school, wherever it was occurring, and the number of shots fired by the person in self-defense, by the defender.
Did you rely only on the information that the NRA provided, or did you look for other information about those incidents?
No, like I mentioned, we looked at the information provided in the database, as well as independently finding additional articles about each of those incidents.
And what kind of information in total were you looking for?
Well, we were trying to find out how many shots the defender fired in that incident in self-defense.
In compiling this data set, were you the only person who worked on that project?
No, I had a team that worked on this with me. That's how we do things at NERA. We have a team of analysts. We have a whole process of how we do this sort of analyses, where we have two researchers independently read each of the news stories and compile that information that I described, and then they would check the results against each other, make sure they're properly doing this. So it's a very detailed process. We try to make it as reliable, as replicable as possible. So that's the foundation of how we do the analyses. That's how we do things at NERA. It's a common standard.
Did you calculate the average number of shots fired in those incidents, 736 incidents, that were in the NRA database?
I missed the number. You said I have a wrong number written on my form. What was the number of incidents you looked at?
I believe it's 736.
I don't know where I came up with the number I wrote down. Go ahead, please.
Did you calculate or did you catalog how many shots were fired in those incidents?
That's right.
Did you calculate an average?
Yes.
Do you recall what that average was?
Objection, Your Honor. Lack of foundation. May I ask a question in aid of objection?
Yes.
Sir, isn't it true that the number of shots fired in self-defense has not been systematically tracked?
Objection, vague. I don't know whether he's talking about by this database or in the world ever, or including his analysis that he's presenting today.
I'll sustain that. You'll need to be more specific.
Isn't
We're
it
talking
true?
about scientific evidence. Let's be specific.
Isn't it true that the NRA database does not systematically track the defensive uses of firearms?
I'm not sure if it does or doesn't. What we did is try to look at every single incident in that database.
Isn't it true that the incidents in the database come from individuals volunteering their stories to the NRA?
Well, not necessarily. I mean, I think there's always a news article that's related to each of those incidents. So it's not just that somebody calls in the database and says, I defended myself and this is the story. I think there's always some sort of backup supporting that.
Isn't it true that parts of the database include evidence or facts taken from news articles?
Yes.
Isn't it true that the NRA analysis does not collect data from police reports?
I'm not 100% sure about that. I think it's mostly news articles where this information is coming from.
Your Honor, plaintiffs do not believe that defendants have laid a proper scientific foundation. Plaintiffs would object to the reliability of news articles as a source of data for the overall uses of firearms in self-defense. The stories, obviously, newsworthy stories are newsworthy for a reason, and are going to not cover the broad set of data as accurately as does police reports, FBI statistics, or other far more reliable sources than news articles.
Your Honor, may I be heard?
Yes.
The basis of hinging an expert opinion as being based on a news article, that theory of exclusion has been rejected in several federal cases under the Daubert standard, which is quite close to the Brown-O'Keefe standard. Some citations I would offer are Simpson against Socialist People's Libyan Arab 362 F sub second 168 177 at DDC 2005. That was affirmed by the appellate court in that jurisdiction. The Sixth Circuit also rejected the theory offered by plaintiffs in United States against Damra 412 F third 618 625. That was a 2005 case out of the Sixth Circuit.
The last set of numbers, I got 412 F third.
The page number the case starts at is 618, and the relevant section is at 625.
Okay.
Your Honor, plaintiffs would just add that the witness just testified that he does not know whether the number of rounds fired, whether the database from which he's drawing data used any form of systematic tracking of the number of rounds fired. So I think there's a reliability issue there, unless I'm misunderstanding the witness's testimony.
Clarify that issue, please. Or you can ask the question again, because I didn't hear that.
Sir, isn't it true that the NRA does not systematically track the numbers of defensive gun uses?
I do not know the answer to that question. I think the database compiles 736 incidents during this time period. I analyzed every single one of those incidents.
Your Honor, under 702, plaintiffs assert that this lacks scientific reliability. If the witness cannot validate the data source from which he is pulling data that he's relying upon, plaintiffs assert that all he is doing is reporting what the NRA database says, and he cannot independently verify the scientific rigor of that database.
And in our view, that goes to the weight of the evidence rather than its admissibility.
So this database we're talking about is self-reporting by individuals who used firearms in self-defense, verified by newspaper articles. Is that what I understand to be the basis of information upon which he's analyzing?
Mr. Baez knows better than I do. So you feel free to inquire. You may feel free to inquire directly. I think the testimony was that it is compiled by the NRA, and Mr. Baez's belief is that it is based on self-reporting or identification by the NRA, but not necessarily every defensive gun use incident that has happened in the United States over that period.
Got it. Is that accurate?
That's right.
So they come to this information comes through self-report and then sometimes confirmed by newspaper articles.
It's always confirmed by newspapers articles,
Okay.
or at least we, in the instances where there wasn't a newspaper article, we were able to verify that there was this incident and there was a newspaper article that supported it.
Okay. On this issue, I tend to agree that it goes to weight more than admissibility.
And Your Honor, plaintiffs would just like to renew their relevancy objection. I understand Your Honor ruled on that with regard to the motion in limine. Oregon has no common necessity test. That's not an element from Christian, Delgado, Blocker, or any of the relevant cases for the facial challenge. Whether or not, as for example, from Delgado, whether or not a spring and a switchblade is necessary for self-defense is not part of the analysis. Surely the switchblade could, or a knife can be used for self-defense without a spring. That was not the court's analysis. Plaintiffs would just like to renew that objection on the record that there is no common necessity test.
Your Honor, we'll stand on the record that was made both in the written and oral argument of the motions in limine with respect to this evidence.
Yeah, I think I'm going to allow it to come in at this point in time, and I'll make a determination as to what, if any, weight I give to it after I consider the necessity question and more fully in my legal analysis. So you can continue with your questioning. I recognize this is qualitative evidence that he's evaluating to try to glean some type of conclusion from, but you know.
Plaintiffs understand your ruling, Your Honor. Thank you.
Your Honor, I've handed counsel and the court a document marked Exhibit 111. May I show it to the witness?
Sure. I mean, the way I hear this evidence, I just want to make sure I'm super clear for the record. The way I hear this evidence is this man looked at 736 stories, and he's drawn some conclusions from those stories about the rate of ammunition that in terms of trying to offer this for any type of conclusions with regards to rate of error on overall use of self-defensive weapons and the amount of shots fired, that's well exceeding anything that's being offered to the court at this point in time.
We understand, Your Honor.
Is that right? Do I misunderstand?
That no questions about any of the topics that the court just listed have been asked at this point.
Sure.
We have other source, as I think Mr. Baez testified, he did 3 different analyses. This is one of them.
Right. So I just want to make sure I understand this analysis based upon what's been presented to me foundationally at this point in time. That's all I'm saying.
Understood. Mr. Baez, what is Exhibit 111?
Exhibit 111 summarizes my analyses of the NRA database.
And what conclusions did you come to?
So it looked at all 736 incidents and categorized them according to the number of shots fired by the defender in each of those situations. So this table shows these results. So if you look at the first line, it shows that there were 134 incidents, or 18% of all incidents, where no shots were fired, where the defender was able to defend themselves successfully by just waving their gun without firing any shots. There were 587 incidents, or almost 80% of all incidents, where the defender fired 1 to 5 shots. There were 13 incidents, or less than 2% of the incidents, where the defender fired 6 to 10 shots. And there were only 2 incidents, or 0.3% of all incidents, where the defender fired more than 10 shots. And overall, the average number of shots fired in these 736 incidents was 2.2 shots.
Your Honor, I've been alerted that that we are not publishing the exhibits. Maybe when I show the witness an exhibit, maybe we will publish it so that those observing outside of the courtroom may see it on the remote feed. Would you like us to do that?
Are you offering covering it then?
I will be eventually.
Okay,
But I just wanted to address this.
I'm fine with you publishing
Okay.
this. exhibit.
Can we publish 111 in the courtroom? And the defendants offer exhibit 111.
Objection, Your Honor, hearsay. It's not within 803(9). It's an out-of-court statement offered for the truth of the matter asserted, not subject to any exception.
And the exception is 702.
702 does not allow admissibility, as was discussed yesterday. It allows him to rely on the evidence to inform his testimony, absolutely, but it does not allow for admissibility. The court ruled on that issue yesterday.
It does not allow admissibility either. It allows or doesn't allow. Go ahead.
702 does not say it is or is not allowed. Therefore, the rule would be hearsay. This is an out-of-court statement offered for the truth of the matter asserted, not subject to any exception or exclusion. That at least not one that's been identified by defendants.
And our response is that he is a expert witness, and therefore under 702 is entitled to rely on hearsay. Under 703 and under 705, he can offer the bases for his opinions in order to disclose this to the court. And here, the basis of his opinion is based on his review of these other underlying news stories. He's allowed to provide that in summary form, or we're allowed to present it in summary form under 1006. And Rule 703 allows the court to admit the exhibits or to admit hearsay and the underlying 703 allows the court to allow the underlying reasons to be admitted into evidence in order to assist the finder of fact and to complete the record. And I think here it's a very straightforward presentation of data. We can have them read the table into the record, but it seems like a bit of a waste of time to do so.
Okay. Well, he's already read most of the data into the record, frankly. Mr. Marshall, it was a waste of time. I take umbrage. But I doubt that's what you meant to say. I think under 1006, it appears to me to be admissible summary evidence. I'll let you look at that in response before I make a final ruling.
Your Honor, this is 1006 does not state any exception to the hearsay rule. It says the contents of voluminous writings, records, or photographs which cannot conveniently be examined in court may be presented in the form of a chart, summary, or calculation. The originals or duplicates shall be made available for examination or copying, or both, by other parties at a reasonable time and place. The court may order that they be produced in court. None of that goes to admissibility, and I have not heard Mr. Marshall cite to any exception or exclusion under the hearsay rules in the 800 section. I've heard 700s and I've heard 1000s, but none of that is an exception to hearsay. I think it's sufficient that the witness testify to what the report says, and it need not become part of the court's record. And plaintiffs would lastly like to say the court did rule on an identical issue yesterday regarding Mr. Siegel, and plaintiffs would ask that the court adhere to the same logic from yesterday's ruling.
As I read one of our 1006, I don't think a foundation's been properly laid for it, so I will sustain to that. Let me look at 705. All right, I'm going to sustain the objection. He's testified to the content therein, but I'm not going to allow the exhibit. I don't think an exception's been made.
And Your Honor, can I inquire on the 1006 component? What's the piece of the there was a part of the foundation that I failed to lay.
Sure. The rule is self-evident. The originals or duplicates shall be made available for examination or copying or both by other parties at a reasonable place and time, and the court may order that they be produced in court. You've not laid a foundation that you've made that offer to Mr. Aiello and given him an opportunity to examine these voluminous documents.
So
It's a proponent problem.
Yeah, no,
It doesn't mean that it's not accessible to the
Understood.
public. It has nothing to
Understood.
do with that.
no, I understand. The news articles have been provided on that USB drive. That was done 30 minutes ago or whatever, I guess less than that. So it's not super helpful. I doubt he has had time to review 736 records, but that's our understanding of Oregon
Well,
practice on this.
Sure, but that's
But-
not the completion of the data, right? The newspaper articles are a part of the data set.
Oh, sorry.
There's the NRA database totally that I don't know that you've presented to him or given him an opportunity to consider.
I believe all of that is in the expert disclosures. I'm seeing that Mr. Baez is nodding, as well as the coding that Mr. Baez oversaw at NERA to come up with these calculations. But I'm just stating that to avoid any misunderstanding. I understand the court may have a separate basis for exclusion.
Your Honor, I don't know that I could review all those records if the court gave me the weekend to do so. So,
Okay. Well, I mean, it has to be done, and there's a reasonableness component to 1006. That there should be a reasonable time and opportunity to be provided, and I look at that as an exception to the discovery rules around civil proceedings. If you're going to offer take voluminous documents and then consolidate them down into one thing, you need to at least allow the opportunity to the other side to review those voluminous documents before you make this type of exhibit.
Okay.
I'm not saying he can't testify to it. I'm just saying that this exhibit's not admissible because I don't hear that. I would not think in the midst of trial, one attorney litigating is sufficient time, 30 minutes beforehand, for him to be able to determine the validity of the exhibit. So I'm going to exclude it at his request.
Understood. We are about to switch topics to a different analysis, and it is 11:57. Would you like to take the lunch break, or would you like me to proceed?
That's if you're ready for lunch, I'll let you have it.
Okay.
We'll
Thank
get
you, Your Honor.
started at 1:15. Sir, 1:15.
No problem.
Thank you.
Thank you.
We have one live witness. We have one who we think will be excluded. And so.
do you think we'll finish by 3? I'm just trying to decide if I think.
How long are you going to talk? That's the biggest factor. That's a big X factor.
can be seated. Amy, I forgot my glasses on my desk. You're welcome to retake the stand, Mr. Baez. And there is water there for you if you need it. You want to double check to make sure it's got water in it?
I'm good, but
Okay.
yeah, there is water, but I'm good. I had some water during lunch, so I'm good.
Well, I like to stay hydrated around here. Go ahead, please.
Mr. Baez, I was incorrect when I said that we were done with the NRA database before lunch. I've handed to council and will now hand to the court what we have marked as Exhibit 112 and ask permission to show it to the witness and publish it in the courtroom.
Thank you. Any objection to them publishing this?
Yes, Your Honor. Plaintiffs object, lack of scientific foundation. Plaintiffs assert that 11 incidents is too few incidents from which this court can derive any meaning.
Your Honor, this is simply, I think as the court described it, descriptive data or qualitative assessment, not intended to be a systematic or I suppose a better word would be a total accounting of every defensive gun use in the state of Oregon. But we think that it is still relevant information that Mr. Baez collected and can testify to.
Your Honor, plaintiffs would add there's been no foundation for the, are these 11 incidents representative of Oregon's overall trends of self-defense? There's been no foundation laid on that. So the way plaintiffs see this is 11 incidents plucked with no specific representative sampling.
Yeah, I mean, I think that I let the larger qualitative information in. I guess I'm just hesitant to do so with this particular evidence. I don't know what the membership is of Oregonians to the NRA. I don't know any of that. I know that there's a national NRA, sort of cumulatively. I think there's some relevance in allowing it in sort of overall in the country, but this is very minute sampling, obviously. I think that's part of your point. But I don't know how many people there are in the NRA and how many acts of self-defense occurred within the state of Oregon with use of a firearm since 2011 to 2017. If I had that, I could weigh that against this and then make some type of larger determination. Do you have that evidence?
I don't think I'll be able to lay a foundation on those particular points sufficient to satisfy the court. The defendants offer Exhibit 112, recognizing that the court will exclude it on the basis of Mr. Aiello's objection.
I'm going to let that be a part of an offer of proof because I'm going to exclude it. I wouldn't have let the exhibit in necessarily anyhow, but I understand this would be the testimony that you would give under with 112, and I'll let it be admitted just for the court's, the reviewing court's edification of what I'm excluding.
Thank you, Your Honor.
Thank you, Your Honor.
And I forgot my book of evidence in there, so I did that off of memory. So can somebody please, Chris, got my book.
So no more evidence.
I should have just maybe checked what I brought with me before I got back on the bench. I apologize to the parties. Go ahead, please.
I'll lay foundation for a while to give both you and Mr. Aiello a bit of rest on the evidentiary objections. Mr. Baez, before lunch, you mentioned that you had done 3 analyses. Is that right?
That's correct.
And the second of those that you listed is a Factiva analysis?
That's correct.
What's Factiva?
Factiva is a news aggregator. So basically, they collect news stories from over 33,000 worldwide sources. So they're not actually writing the content. What they're doing is collecting it from, the Wall Street Journal, the Oregonian, U.S. News, Reuters. They collect all that information and put it in one database. Factiva is commonly used across the sciences. Academics, researchers use it. At NERA, we use it almost every day in our work. It's a very good tool in order to obtain to do comprehensive searches of news stories.
Can you give me another example, maybe from a totally separate discipline, of how Factiva is useful in your work at NERA?
Yeah. So, for example, at NERA, we use Factiva for analysis such as for types of analysis such as content analyses. We use them for analyses regarding financial issues. So, for example, when we want to understand how stock prices react to different news stories, we'll use Factiva for that. So, it's just commonly used in a lot of our work.
What did you use Factiva for in this case?
So we did a systematic scientific analysis of defensive gun uses using Factiva to search news stories about those types of incidents. So we were trying to, just like we discussed this morning, the NRA, I didn't know exactly how that was compiled, but through the Factiva analysis, we can do our own analysis and do a systematic analysis of news stories covering defensive gun use incidents.
How did you search for those news stories?
Factiva has a feature that allows you to search for specific word items or key searches that you want to. And basically what we were trying to find is defensive gun use is very similar to the NRA incidents that we found. So we were trying to follow those types of news stories to identify similar types of incidents of defensive gun use. So that's what we did.
What time period did you search for news stories during?
We use the same time period as the NRA news stories. So the 6.5-year period from January 2011 to May 2017.
How many news stories in total were in the Factiva database that met your search criteria?
So there were a lot. And so basically what we did is we looked at a random sample of 200 news stories out of approximately, I think it was 4,800 relevant news stories from our Factiva news searches.
Once you identified that random sample of 200 stories, what did you do next?
We reviewed those news stories and tabulated similar type of information as in the NRA analysis. So the location of the incident and particularly the number of shots fired by the defender in those incidents. We also gathered all of the other additional news stories covering that same incident in Factiva and reviewed those news stories as well to help us have the best data that we can find about what we were looking for, particularly the number of shots fired by the defender.
Did you code all of these news stories yourself?
No. Like with the NRA story, I had a team of people at NERA, of researchers that helped us with this. In particular, the way that we do it, we have two people separately review each news story and then compare their results. So that's sort of the process that we do at NERA to try to have as reliable data as we can.
Did you calculate the same types of statistics that you found in the NRA database for this sample of 200 news stories?
Yes.
I'm going to hand counsel in the court Defendant's Trial Exhibit 113 and request that the court grant permission for me to show this to the witness and publish it to the court.
Show to the witness. I'll make a decision before I allow it to be published.
Mr. Baez, what is Exhibit 113?
It summarizes the findings of our Factiva analyses.
What were your findings?
Objection, Your Honor. Your Honor, may I ask some questions in aid of objection?
Yes.
Thank you, Your Honor. Mr. Baez, how many, do you know how many defensive uses of firearms there are per year? How many defensive uses of firearms there were per year from January 2011 to May of 2017?
No, I don't think that number, anybody knows that number.
You don't think anybody knows that number?
Yeah, I don't think there's no statistic that follows that number.
Are you familiar with the CDC?
Yes.
Do they collect that data?
No, they do surveys that touch on that, but they do not collect that data.
So is there any way for this court to assess whether the 200 story or what representative sample size the 200 stories are of the 4,800 relevant stories, as you've characterized it, are represented in the total data?
Objection, ambiguous as to whether he's asking about the relationship between the 200 and 4,800 or the relationship between 200 and all defensive gun uses.
I agree.
I'll rephrase, Your Honor. So is there any way for this court to assess the percentage of news stories about defensive uses of firearms?
Objection, unclear question, ambiguous question.
I'll say it this way. It seems to me that 4,800 could be the numerator, and the total number of defensive uses of firearms could be the denominator, and that would tell this court what percentage of defensive uses of firearms were reported on. Does that stand to reason?
Could you repeat that? I didn't quite understand that.
Started using math and he was thinking
yes.
about whether you know your math or not. Go ahead.
I believe it's called the numerator. So in order, you looked at 4,800 relevant stories, correct? That's your testimony?
That's what we found.
And you actually looked at 200 of those stories, correct?
We looked at a random sample of 200 of those stories.
But you don't know how many total defensive uses of of firearms there were, correct?
That wasn't part of what I was trying to do with this analysis.
So you don't know what percentage of defensive uses of firearms were reported on by news agencies, correct?
Well, I think our analysis was capturing the bulk of defensive gun uses that were reported, that were under the Factiva database.
But what about the defensive uses of firearms that were not on the Factiva database because they weren't reported on by news agencies?
Right, those wouldn't be part of this analysis.
So there's no way for this court to determine, of the 200 stories you actually looked at, whether that's a representative sample size of, whether that's a representative sample of the total number of defensive uses of firearms for 6.5 year period, right?
Well, we did some analysis to deal with the question that you're bringing. We're trying to understand that if an incident is not covered by a news story, what sort of incident is that? And so we did some analysis on that. And what we found was that incidents that are not covered by news stories are likely going to have fewer bullets. That's the conclusion we got with some analyses that I can describe a little, that I can describe if you want.
Your Honor, plaintiffs asked to strike Mr. Baez's last comment about the conclusion. I don't believe we're talking about the scientific foundation at this time. So I think using a conclusion to justify the foundation would be improper here.
May I be heard?
Sure.
Well, I may want to ask questions to help lay an additional foundation before the court rules on this question. But I think Mr. Baez was trying to describe one of the checks that he did in order to determine whether this is missing, whether his analysis is likely to miss defensive gun uses where large numbers of shots were fired by looking at whether those larger number of shots fired had more articles written about them. And I think that that is part of the court's analysis. I think to the broader question, I think it's very similar to the NRA database question. Is it true that the news articles don't cover every single defensive gun use in the United States? That's true. Is it still probative evidence to an issue before the court? Yes, it is, and therefore the objection goes to the weight of the evidence rather than its admissibility.
Your Honor, may I ask one more question in aid of objection?
Yes.
Mr. Baez, are you familiar with the CDC study stating that there are upwards of 2.5 million defensive uses of firearms per year?
I am.
So when I asked you whether or not you were aware of the number of defensive uses of firearms and you testified that the CDC does not keep that data, you were mistaken, correct?
No, what I was referring to is that the CDC does that analysis based on surveys to do estimates. They do not, nobody, to my knowledge, there is no database of actual defensive gun use incidents. I think what me and my colleagues at NEAR have compiled is the closest thing to a database on defensive gun uses of actual real life defensive gun use incidents.
So you looked at 200 stories out of, according to the CDC, upward of 2.5 million defensive uses of firearms per year over a 6.5 year period. Some quick math from me would say that that's over 12 million. So you looked at 200 out of over 12 million uses of firearms. Is that correct?
Objection. The question assumes facts not in evidence, namely that the 2.5 million number is accurate.
I just asked the witness if he was familiar with that number, and he said
Let me
yes.
just answer that question. I mean, the defendants have asked me to consider data from the CDC on a number of occasions today and yesterday, and this witness affirmed that that is what the CDC says. I think what I understand him to be saying is he disagrees with the methodology of the CDC in terms of survey as opposed to evaluation of newspaper articles. But I think you've asked me to look at the CDC's records, and I'm going to continue to do so here. He affirmed that that is what the CDC's findings have been. Is that right?
There's a lot of surveys out there. The CDC has been doing some work regarding this for many years. There's been other surveys that have been done. So I don't know the exact numbers off the top of my head. I know there's a lot of studies out there and a lot of surveys that have tried to look at this question, and they've been heavily criticized in the academic literature, but I'm not exactly familiar with the numbers sitting here today. I don't have those numbers off the top of my head.
He was saying yes to the question because he figured that was, you were telling him the truth about the number. But yeah, okay. Well, I'll consider the CDC information as has been requested of me on a number of circumstances by the defendants, and I have considered that evidence by the defendants.
And Your Honor, so plaintiff's objection is that an analysis of 200 stories selected from among only the 4,800 that were reported on over 6.5 years out of upward of 15 million by my math, potential defensive uses of firearms isn't my calculator will not calculate how small that percentage is.
Okay. Did you want to respond any further, Mr. Marshall?
Only to say if the court were to sustain the objection, we would attempt to lay additional foundation.
Yeah, I think I'd like you to do that. Lay further foundation for the conclusion.
Mr. Baez, are you familiar with any academic studies of defensive gun use that use news stories as the basis for their analysis?
Yes,
Can you give me an example?
sure. So Hemingway at Harvard, he's a very renowned academic on the areas of economics and public policy. He recently published a study in a peer-reviewed journal in the Journal of Injury Epidemiology that dealt exactly with defensive gun uses, and he relied entirely on news reports to do his analyses. News reports are used across many fields and commonly used by academics, researchers, including in areas exactly like this.
Is Injury Epidemiology a peer-reviewed journal?
It is.
I would ask permission to show to Mr. Baez and publish in the courtroom slide 9 of the presentation that we've been asked not to show Mr. Baez as a demonstrative for this piece of my examination.
If you think it'll refresh his recollection, you're welcome to use it in that regard.
And Your Honor, if I may, is there a question that he's refreshing his recollection on?
Yeah, he hasn't asked one. Now everything's up on the screen. It's just, anyhow, go ahead.
Does this refresh the details of the analysis that you did, that you were trying to describe to Mr. Aiello about why you think, what you think about what bias, if any, those defensive gun uses that are covered by the news has?
Yes, that's exactly right. So this analysis, what we did is I think one of the things I mentioned is when we were doing our analyses, we also looked at all of the different articles that were within Factiva for each of these 200 incidents that were covering that specific incident. And then analyzed that relative to the number of shots fired by the defender in each of those incidents. And what this chart shows is the result of that analysis. And it shows that there's a strong relationship between the number of shots fired by the defender and the number of articles covering that incident. So for example, you can see that here when there's 0 shots fired by the defenders, there's only 2 articles on average covering that incident, while when there's more than 6 shots fired, there's 10 articles covering that. So I think what this tells us is that if there are any incidents that are not being covered by the news stories, there are likely going to be incidents where there's fewer shots fired. So that's what this analysis tells us.
With respect to the CDC data, is that the only estimate of the number of defensive gun uses that you're aware of?
No, there's a lot of literature on this, and you know, my recollection is the CDC has a few different numbers. I think they have a much lower estimate as well. And other academics have looked at this and come up with lower numbers, and others have come up with higher numbers. So it's a little bit all over the place.
In the estimates of defensive gun uses that you're familiar with, do those defensive gun uses include defensive gun uses in which no shots are fired, that is by brandishing a weapon?
Sometimes no, sometimes yes. I guess I have to refresh my memory on each of those.
Okay. Those are the questions that I wish to ask Mr. Baez before the court rules.
Okay. What are you asking me to do? What are you asking me to do?
I was asking whether I could examine Mr. Baez on the results I think when the objection came through is when we handed him 113, and so I would be intending to have Mr. Baez report the results of his analysis of the Factiva articles through Exhibit 113. I didn't think I actually asked that question, but that was what I was going to ask, and Mr. Aiello objected to tee up the question for the court as to whether or not he would be allowed to report those results.
Go ahead, Mr. Aiello.
Yes, Your Honor. Plaintiff's objection is still that this is, the court does not know what sample size the news stories represent of the total number of defensive uses of firearms. I recognize that Mr. Baez does not know that number and that number may be debated, but there's no way for this court to determine the scientific reliability of the number of stories surveyed as a representative sample size of the total numbers of defensive uses of firearms. So the way plaintiffs see it is if we don't know the denominator, we don't know what percentage of defensive uses of firearms were reported in the news. And then of that small number of 4,800, there's an even smaller number of 200 that was surveyed, and that's statistically insignificant.
I think there's a number of pieces to this analysis that I don't think I understand in the record. I don't understand what the search terms were. I don't understand specifically what the Factiva. I understand that's a source of 300,000 different newspapers. Is that right?
33,000
33,000
different sources.
different sources, and those are all newspaper sources.
Yes.
Okay.
Or like Reuters, like news agencies.
I guess I don't understand the rate of error by making the sampling size either. I understand the technique. So I'd like a little more information before I allow them to draw conclusions.
Did you calculate the margin of error for the sampling error of the 200 out of the 408, roughly 4,800 news stories that you read?
Well, here what we have is a random sample of 200 news stories, and we're just reporting the results of the 200 random samples. So we could have calculated statistics on the error rates, but that wasn't our objective. We just wanted to present the results of this random sample of 200 stories and show what's the distribution of the shots fired under that random sample.
Did you calculate the margin of error?
I think at some point we might have calculated it. We've been doing this analysis for a lot of years. That's generally my recollection, but that wasn't the intention, is to have this analysis be something that tells you the margin of error. It's supposed to be a random sample of 200 of the 4,800 stories that we looked at.
With the do you remember the precise search terms that you used in order to pull the random sample?
So I don't remember all of them exactly. The intention was to try to recreate or capture the stories that were in the NRA database. So we used search terms that would be consistent with the type of stories that were in the NRA database. So for example, one of the terms we used was shot, or variations of the term shot. So it would include shooting or shooter or things like that. So there were several different terms. I just don't remember them off the top of my head, but there were several different terms that we used in order to recreate that. And then what we found was that we were able to match over 90% of the stories in the NRA database we were able to find with our search terms. The remaining percentage that we didn't find was likely because they were coming from sources that weren't covered from Factiva, but otherwise they would have been captured by our search terms.
Mr. Baez, who is Lucy Allen?
Lucy Allen is one of the colleagues I have at NERA.
Have you worked with Ms. Allen on the types of analyses that we are presenting today?
Objection, Your Honor. Relevance. This seems vouching because he's worked with
No,
Ms.
no,
Allen.
that is not the purpose. I apologize for interrupting.
Relevance
Seems fairly
as,
affirmative that wasn't his purpose. I'll overrule that you complete. I don't think it's gotten to a place where there's something objectionable.
yes, Your Honor.
Would Ms. Allen's prior declarations refresh your recollection about the search terms that were used in this analysis?
They would. I've worked with Miss Allen very closely for the last 10 years on exactly this work. We've done it together.
Okay. I would like to show to council first and then to Mr. Baez paragraphs 14 and footnote 17 of ECF 116 in case number 2:22 CV 01815-IM in order to refresh Mr. Baez's recollection about the search terms.
Footnote what?
This is the paragraph one. So this is one set of search terms. I think actually it might be misinterpreted. Hold on.
So you're allowed to review that and only testify to it if it refreshes your independent recollection. Does that make sense?
Yes.
So it's not allowed to make fun of it. You can use it to refresh your recollection as to the question of what the search terms were. And if it does that, you're allowed to testify to it.
Mr. Baez, does that refresh your recollection about the search terms or types of search terms that were used to draw the Factiva sample?
It does.
And what were those search terms?
Sure. So we had a precise search string. I'm not gonna read it here, but basically it covered gun, shoot, fire, whether it's a robbery, terms related to a robbery. So if there was broken into a home, terms like that. This particular analysis focused on incidents that were occurring in the home. So the search terms would also include home, apartment, house. I think that, and there's variations on all those terms. So for example, the way you can do it in Factiva is you search for the term shot with a star next to it. And so that means it's gonna look for terms that would encompass that and other additional letters. So shooting, for example. So when you do shot star, you're going to include shooting, shooter, things like that. So we would do that star for all of these terms as well to try to, gather, as much information as we can.
Okay.
And I'll also add that Factiva is something we use in our everyday work at NERA. We're very familiar with it, and these are the types of searches that we use, and we're very familiar with how to use these techniques in order to be able to find news stories that cover these certain terms in the best possible way and not miss anything.
Okay. Go ahead.
Do the range of acceptable estimates for defensive gun uses range from 60,000 to 2.5 million?
That's right. That's I think that the general recollection of where that literature is at. So like I said, it's all over the place from 60,000 to 2.5 million. So
Your Honor, plaintiffs object and move to strike. I didn't hear a source for that.
It's testimony.
So lack of foundation then.
Yeah, I mean, you gave him a number, he repeated back the number. I'd like to know what the source was for your estimation. I know his estimation was from the CDC, and the 60,000, I don't know where that's from.
This may be subject to a motion for judicial notice later this afternoon, because I think that there's some, I don't think we'll ultimately be able to agree that, anyway, I think the court will be able to find that the CDC maybe has a range of estimates.
Oh, so you're saying that 60,000 is within the CDC's range?
I don't want to get into a lot of like that level of detail. I know that there's a very broad range of this. I want to look at the underlying documents, and hopefully before the close of evidence, we'll be able to present something that the court will be able to rely on. I think 2.5 is the higher end of the CDC of ranges that the CDC has reiterated others' estimates.
Your Honor, I
Hold
will,
on. I'm going to strike the 60,000 until I
Sure.
have further
Okay.
information to give me an identifiable source for that number.
and
But
Your
I
Honor,
understand, yes.
I just want to note for the record, I did say upward of 2.5 million. So plaintiffs do recognize that there's a range.
Okay, thank you.
So I think at this point, we have laid the foundation for Exhibit 113 and wish for Mr. Baez to be able to report the results.
Right, and this is data about defensive use of firearms in a home setting. That's how I understand the data at this point in time, not as an overall survey of all defensive uses of firearms, but in a home setting. Correct?
That's correct.
Okay, go ahead.
Okay.
You can object if you'd like to, but I'm going to let him do it. I think he's acting within his analytical structure. I understand how to weigh that. I mean, he's looking at something, he's surveying a common source of knowledge and information. He's deriving a statistical analysis from it based upon the confines of the searches that he made. And there are numbers associated with that. That's what he's here to do. So he can provide those numbers, but you're welcome to object to my analysis if you'd like to, Mr. Aiello.
Your Honor, just one quick objection. I would like to just note for the record that I believe the answer was no, they did not calculate an error rate. And I think that we still lack a scientific foundation, but I understand Your Honor's ruling.
Well, I understand how I weigh it. There's 4,800 articles in the 6.5-year period, 200 of which were gleaned based upon the search terms of defensive use in the home-like setting, including, I think you said robbery as a part of it.
Right.
So was that right? So it was in reflecting an attempt to invade a property. Did you guys use the phrase burglary as well?
Yes, I believe so. So the idea was that in an incident where somebody is invading a home and
This is
a person is
stranger,
defending
right,
themselves.
A stranger on stranger event where somebody's trying to break into a home and commit a burglary or robbery.
That's exactly right.
Okay. That with that limitation in terms of the numbers, I'm happy to have them introduced. We don't use robbery typically for home invasions in Oregon. Just legally, that's just, we use burglary, but I understand what you're trying to accomplish. So go ahead, please.
Mr. Baez, what were the results of your analysis of the Factiva database?
Sure. Similar to the NRA analyses we did, we found that in 12% of the incidents, 0 shots were fired. So the defender was able to defend themselves, but just waving their gun and not firing any shots. In 86% of the incidents, we found that the defender fired 1 to 5 shots. In 3% of the incidents that the defender fired 6 to 10 shots. And in none of the incidents did we find that the defender fired more than 10 shots. And overall, on average, consistent with the NRA analyses, we found that the average number of shots was 2.3 shots.
The state defendants move admission of Exhibit 113, recognizing that the court has already ruled and will stand on our, about the admissibilities of Mr. Baez's tables, and will stand on our prior record on that point.
I'm not going to admit it, but he's testified, and it'll be in a transcript.
You said that you had done a third analysis. What was the third analysis that you did of defensive gun use?
Sure. The third analysis relied on data from the Portland police.
What data did it rely on from the Portland police?
So in particular, relied on 2 databases that the Portland police makes publicly available. The first database is what I call the Portland police shootings database, and basically has incidents when a firearm is discharged and it's reported to the Portland police. So every incident that covers that. And it's a 4-year period that we looked at. The data only starts in 2019. So we looked at the data from 2019 through 2022, covers about 4,000 shooting incidents. And for each of those incidents, it'll report the location, time of the incident, as well as the number of casings in each of those incidents. The second database is what I call the Portland crime database, which basically has all of the crimes that occur in Portland according to the police. And again, for each of those incidents, it has the location and time and the type of crime that occurred, whether it was an aggravated assault, murder, robbery, or burglary, whatever the category of the crime is, or it could be several different crimes for one incident.
Did you do this type of analysis with data from any other law enforcement agency in Oregon?
No, we looked around and we couldn't find any other police department or jurisdiction that had this level of data, particularly showing all the shooting incidents with the number of casings. And we've been doing this for a long time, over 10 years, and we've worked for many different states and looked at data all over the country. And we actually had never found this level of data until we looked at the Portland police.
Do you recall the specific name of the shooting database? Don't guess.
I do not remember exactly.
Do you recall the specific name of the crime database?
I do not.
Would slide 10 of the presentation you prepared refresh your recollection about what the formal names of those databases are?
It would.
I'd like to show Mr. Baez slide 10.
He can look at here and
Okay.
see if it refreshes his recollection. If it does independently, you can answer his question.
It does.
Mr. Baez, what was the shooting database called?
It's called the Portland Shooting Incident Statistics Database.
And what's the crime database called?
The Monthly Portland Neighborhood Offense Statistics Database.
Are these publicly available databases?
They are.
Did you get any records from the Portland Police Department through a public records request or something like that?
No.
What did you do with the Portland police data that you obtained?
So we wanted to focus on a particular set of incidents. We wanted to focus on incidents that from the start with the shootings database, the 4,000 incidents that we talked about, focus on incidents that related to crime. So not all incidents are going to relate to crime. If you remember how I described the Portland shootings database, was that it has all incidents where where a firearm is discharged and it's reported to the police, but it's not always related to a crime. So for example, and we talked with the police, with the Portland police, about how they compile these databases. So I got a better understanding of exactly what was going on and what's being reported in these databases. And one of the things they informed us is that a lot of times there's no crime associated with a shooting that's in that database. So a situation they mentioned was, if you, for example, somebody's doing target practice in their backyard and the neighbor calls the police comes, investigates, there's no crime, but that's been reported to the police. So it's going to show up in the database, even though it's not associated with any crime. So what we wanted to do is focused on the shootings that were associated with crimes. So that's when we're matching up the two databases, and then focus on incidents where there's more than 10 casings. And then within that, we wanted to look at all those incidents and find out if any of those incidents involved a defensive gun use. And then if there was a defensive gun use, how many shots did the defender fired?
Mr. Baez, did you create a flow chart in order to describe, to show this process that you just described visually?
I did.
Council and the court have slide 12 of the presentation that we would request that we can show Mr. Baez and publish to the court as a demonstrative.
No objection as to a demonstrative.
I'll allow you to publish it.
Does slide 12 demonstrate the methods that you used to analyze the Portland police data?
Yes.
And how many shootings in all were associated with crimes?
So of the 3,956 shootings in the Portland Police Shooting Database, 2,632 were about 2/3 were associated with crimes.
Your Honor, plaintiffs object on relevancy grounds and move to strike. The city of Portland is not representative of Oregon broadly. And so plaintiffs, this is a statewide measure, and plaintiffs assert that this evidence is not probative of a fact at issue regarding statewide.
Fighting off wolves is probative. This is probative as well.
Understood, Your Honor.
I'll overrule that objection. It was a lot of wolves. Go ahead.
Of those 2,632 shootings, how many did the Portland police data show had more than 10 casings?
398.
And how many had 10 or fewer casings?
2,234, so about 85%.
What did you do to find out more about those 398 shootings?
So we reviewed all the news stories that we could find on those incidents.
How many of those 398 shootings did you find a defensive gun use?
We only found one that was associated with a potential defensive gun use.
In that incident, how many shots were fired by the defender?
Only 4 or 5 shots. And so what happened in that incident is there were additional shots fired by the attacker. And so that's why it fell in the more than 10 casings category, but the defender only fired 4 or 5 shots.
Did you do any, actually,
I'm sorry, I'm going to object and move to strike on scientific foundation here. I didn't hear a number of the 398, how many were reported on. I heard Mr. Baez testify that he looked at news stories, but I don't know how many of those 398 had news stories produced.
You want to clarify that?
Mr. Baez, well, I'll ask that question and then I'll ask a few more.
Sure.
Mr. Baez,
I'd imagine you have more.
well, that are related to laying the foundation of the reliability of this method. Mr. Baez, did you find news stories associated with all 398 shootings?
No.
Do you recall roughly how many you did find news stories about?
About 60% of them.
Were those 60% similar to the 40% where there were no news stories about, or were they different?
They were different. We analyzed exactly that question. How did those incidents where we were finding news stories compare to those incidents that we were not finding news stories for?
And how did you, and what were your conclusions, or what did you find when you analyzed the difference between the 60% where you did find news stories versus the 40% that you didn't find news stories?
Sure. With the data that we had from the Portland police, we could analyze certain factors about these two sets of incidents. And what we found is that the incidents that were covered were news stories had generally worse outcomes. So they were usually more likely associated with murders, with injuries, and with a larger number of casings.
So how did you know that if there were no news stories?
Well, we had the data from the Portland police on those specific facts. So the data provides whether the shooting was associated with a murder or whether the shooting was associated with an injury, and obviously what we discussed, the number of casings for each of those incidents.
Did you do any other sorts of cross checks among for other sources against other sources that catalog defensive gun uses?
I did.
I would ask permission from the court to show the witness slide 13 as a demonstrative and publish it to the courtroom.
Yes. Okay. I guess I'm just going to say what I'm looking at, that There were 3,956 shootings. 1,324 were ruled out as not crimes, according to the analysis, giving 2,632 shootings. 10 or fewer casings with 2,234 of more than 10 casings at the scene, 398 shootings. That's the information that I think was essentially testified to. There's other things regarding the different types of crimes, but only one DGU according to the police. Right?
That's right. And we're going to, and I wanted to do one, I'm not moving on to another topic. I have more information to demonstrate the reliability of the method. And then I have a similar exhibit that I have prepared as for the other two analyses.
Go ahead.
I'm going to show Mr. Baez slide 13 and ask that it be published in the courtroom.
Okay.
Plaintiffs do not have an objection to its use as a demonstrative.
Understood.
Mr. Baez, what kind of additional cross-check did you do to see whether you were missing defensive gun uses?
Sure. So we looked at another database, which is called the Gun Violence Archive, which is a database that tries to identify all of the shootings that are occurring in the United States, all types of shootings. And one of the categories that they look at are defensive gun uses. So we looked at the defensive gun uses in the GVA, is what we call the Gun Violence Archive database, that occurred in Portland during this 4-year period. And we found that there were six incidents in the Gun Violence Archive database. And then we compared those incidents to the Portland police data to analyze where they fit within that data. And what we found was that 4 of those incidents, as you can see in the table here, 4 of those incidents fall within the 10 or fewer casings. So under the 2,234 shootings that are associated with crime, but had 10 or fewer casings. So those are incidents where the defender did not fire more than 10 shots. One of the incidents fell within the 398 with more than 10 casings, but it's the exact same incident that we found through our analyses. It's the incident where the defender fired only 4 or 5 shots and the attacker fired additional shots, and that's why that's why it was in the more than 10 casings. And it also included one incident where there was no shot fired by either the defender or the attacker. So basically the defender was able to defend themselves just by brandishing their weapon without firing any shots. The attacker hadn't fired any shots. So by definition, that wouldn't be in the Portland shootings database, because the Portland shootings database only has incidents where shots are fired.
Does the Gun Violence Archive report the number of shots fired in each of the defensive gun uses that it identifies as?
They do not.
So based on your analysis, how many defensive gun uses in Portland from 2019 to 2022 was your analysis able to find that included more than 10 shots being fired in defense?
Objection, Your Honor. Lack of scientific foundation. May I ask a question in aid of objection?
Yes.
Mr. Baez, do you know how many total defensive uses of firearms there were in Portland from 2019 to 2022?
According to the GVA database, there were 6.
So the GVA database only covers those that are reported to the database, correct?
Well, the GVA is a database. What they do is they go out and try to find all the incidents related to shootings. So the ones that they found were 6 during this time period.
Do you know whether they obtain all defensive uses of firearms or not?
I don't know.
Your Honor, I believe we have the same issue here of what I described earlier as a numerator denominator issue. We don't know what statistical sample size these 6 defensive uses of firearms represents, or the error rate.
I am interested in the question of these shootings. How many of these were shootings with cross shooting? So gunfire and then gunfire back. How many of those were those types of incidents? Because really the defensive use of guns is a term defined by law enforcement in this circumstance, as opposed to what it may or may not have been. How many were shootouts?
So I think one of the things, I don't know the exact numbers. I think we looked very closely at each of these news stories. I think how we thought about defensive gun use is based on all of our prior research that we've done and reading all these different news stories that have been identified, by the NRA, by our effective analysis of defensive gun uses, where there's some crime that's occurring and somebody's defending themselves with a firearm. That's how we define the defensive gun use situation, and that's what we were reading these news stories to try to identify. I think maybe what you're referring is if there's a shootout between two gangs, that wouldn't be a defensive gun use. That would be criminal activity occurring between two sides. So things like that would not be part of what a defensive gun use is. I think we didn't, in this particular analysis, we didn't look at how many were shootouts. We could have looked at that closer. I mean, I think in the NRA and Factiva analysis, we showed that there's many instances where the defender doesn't fire any shots when defending themselves. I think this analysis was more focused on trying to identify situations where there's a defensive gun use and more than 10 shots are fired. So we're not trying to identify how many defensive gun uses are occurring overall in Portland. That wasn't the purpose of this analysis. The analysis was trying to find defensive gun uses when there's more than 10 shots fired.
And defensive gun uses is a person who's clearly identified by the police as defending themselves against some type of in-home invasion or criminal activity at their home. Is that what this is?
Right. So we try to make sure that this is why we did the first part of the analysis, where we're narrowing it down to criminal activity, where there's a crime that's being reported with this incident. And then whether there's a situation where somebody's defending themselves against this crime that's occurring.
I understand the limitations of this information then, and I'll tell you what I think limitations are. I understand what he says by gangs, but if a person is is shooting back after being shot at without any type of initial aggression, that is an act of self-defense that's not captured here. You can use deadly force against another one that presents deadly force. I'm also recognizing that these are alleged crimes or criminal conduct. I don't have any data that tells me that they were convicted of any type of crime, or if they raised the question of self-defense in their case and were successful in getting acquitted. I just don't have any of that data. I understand that the way they're defining defensive gun use is a very conservative way, where the police identify the person as a victim of an active crime, an invasion into their home, and they are using the firearm back. With that limitation, I'll allow them to speak to it now that I understand what the data means.
How many defensive gun uses did you identify in Portland between 2019 and 2022 as part of your work on this case?
Where there was more than 10 shots fired.
Where there was more than 10 shots fired in
Zero.
defense. I'm going to hand to counsel and pass to the court Exhibit 114. The state defendants offer 114, recognizing that it will be excluded on the same grounds previously relating to hearsay.
I assume that's your objection.
Yes, Your Honor.
I will exclude it.
Mr. Baez, are you aware of any more complete data sets of the number of shots fired in self-defense than the 3 that you presented today?
No.
Did you also look at public mass shootings?
Want to make sure we're clean on this. It's defensive gun use as defined by these folks, not necessarily self-defense, which is a broader term than what is being offered as the state's definition of defensive gun use.
So thank you, Your Honor. So with respect to your understanding of defensive gun use as you've described it today, are you aware of any sources of information that catalog the shootings in a more complete, the number of shots fired in self-defense in a more complete way than those you presented today?
No.
And what about with the court's different or broader definition of self-defense? Are you aware of any source that catalogs the number of shots fired in self-defense under that definition?
No.
Did you also do work in preparation for your testimony today regarding public mass shootings?
And that, I'm just telling you what I believe the law is on that issue, not what I believe the law is. What I think the law requires for self-defense is how I just identified it. It's not my definition. Mr.
The court defines the law, so.
Well, there's
And
that.
so that was not pejorative. I'm not disagreeing.
Legislature defines the law, we just interpret it. We have no power to define anything. Go ahead, please.
Mr. Baez, did you also look at public mass shootings?
I did.
What sources did you use to identify public mass shootings?
So we used 4 different sources to identify public mass shootings. The first one was the Washington Post, so the nationwide newspaper. Second one was Mother Jones, which is an investigative news organization. The third one is the Citizens Crime Commission, which is a nonprofit, not partisan organization. And the fourth one is the Violence Policy Organization, which is a nonprofit research or nonpartisan research organization.
Do you think it's Violence Policy or Violence Project?
Sorry, thank you for the correction. It's Violence Project.
How for the purposes of your analysis today, did you define a public mass shooting?
Well, I used the definition from all 4 sources, which was very, very consistent, which is 4 or more people are killed in the incident, excluding the shooter, that it's occurring in a public location, and that it's not related to other criminal activities such as robberies or gang violence.
Do you remember the dates that you looked for public mass shootings in?
Yes, we've done it. We did this analysis basically covering a 40-year period from 1982 through October 2022.
And how many mass shootings did you identify that met your definition of public mass shooting during that period?
179.
Once you had the list of 179 public mass shootings, what did you do next?
We try to gather as much information we could on all 179 mass shootings, from news stories, from public police reports, from these 4 databases, and we were particularly interested in understanding what were the number of fatalities, the number of injuries, the types of weapons that were used by the mass shooter, including the magazine capacity, and the number of shots that were fired by the mass shooter.
Did you code all of those incidents yourself?
No, I had a team of people at NERA that helped me doing this coding. Like I mentioned before, we have this whole process at NERA where we have 2 researchers independently do the analyses and then compare it to try to have the most reliable analyses and reliable results and data.
I am going to show to council and to the court Exhibit 107 and request that I can show it to Mr. Baez and as well as publish it in the courtroom.
Your Honor, plaintiffs renew their objection. I believe this data is very similar, if not potentially identical to that this court excluded earlier this morning with regard to Dr. Siegel.
That's not what I excluded from Dr. Siegel.
Okay.
A completely different reason I excluded Dr. Siegel. I'll give you some time to look at the data. And then we'll talk about it. this is a harder one to do through direct testimony. This would definitely be something that would normally be included in under 11006. You can talk to the doctor about data sets that are available to you for that. We can talk about admissibility from there.
Thank you, Your Honor.
No, this is not why I excluded Dr. Siegel. All right, thank you. We'll go off the record. I'm going to give him, Doctor, you need, if you need, Doctor, Mr. Lyons, if you need a break, go ahead and take one, and then I'd ask you to talk with Mr. Aiello if he has any questions, okay? Thank you. 15 minutes, if you're not ready in 15 minutes, we'll take more time.
You can remain seated. Court is now in session.
Okay. We were at 107.
Your Honor, the witness doesn't have Exhibit 107. And so I think the first question before the court is, may I show it to the witness and publish it in the courtroom?
Your Honor, may plaintiffs just make a quick statement for the record?
You may make your objection.
Your Honor, my objections under Rule 1006. I have been given a set of data. This data is in the one PDF is 9,412 pages, which plaintiffs understand to underlie this report. Plaintiffs would assert that this is not a reasonable time and place to be given nearly 9,500 pages of data in order to independently verify the veracity of the data compared in this report. And so plaintiffs would ask that the evidence be excluded on that basis. Oh, and I'm sorry, Your Honor, that's just the one PDF. There's also 3 Excel spreadsheets, about 500 lines in total. Plaintiffs' counsel could probably review those 500 lines, but the 9,412 pages, plaintiffs' counsel will not be able to do that this month.
Your Honor, at this point, we haven't offered Exhibit 107, and so I think the objection seems premature in that manner. In terms of the timing of the disclosure, I think that we kind of underwent the conversation on Monday about the nature of and timing of expert disclosures, and I don't think that exclusion. I mean, this is the conventional time under Oregon practice. It was attorney work product in this case until the time that we had called Mr. Bias to the stand, and that in light of that background rule, it is in fact a reasonable time to provide it. And to the extent that there is, I think that exclusion of this data for us complying with that is not justified.
Well, I agree that under Oregon's rules, you can dump 9,400 pages of information on a litigant the moment you're going to call that particular witness. I'm a little less convinced. In fact, I'm actually convinced of the opposite being true, that under 1006 you can introduce a chart if they haven't had an opportunity to review the data in advance. So I guess what I'm telling you is litigants have 2 choices. They can either provide voluminous documents in advance of the trial, give a reasonable amount of time for the individual attorney to review the data against whatever's being offered, and then offer it, or we have to go through it piece by piece. And you can't offer a summary without giving them a reasonable opportunity to consider what the summary says and whether they can verify the information is true. I'm sure there's a statistical way for him to review those, particular that voluminous amount of documentation to find out if there's veracity in the chart. But he hasn't been hired to help Mr. Aiello do statistical analysis of how to divine through that much information, how to determine what's accurate and inaccurate. I'm not suggesting it's inaccurate. I'm just saying he has a right to know and to prepare.
So can I show Mr. Baez the chart? I mean, to me, it sounds like we're discussing the question of whether 107 is admissible.
Right.
So I was going to show.
That's what we're just, that's what I understood.
Yeah. And so I'm going to ask Mr. Baez about the information he collected. It sounds like I have a very low likelihood of success of getting the court's admission of this document. But I would still like to show it to Mr. Baez and examine him on the document and the data collection process that underlies his opinions in this case.
I'll give it to you guys. You've just created all kinds of interesting evidentiary issues for the court to consider this week. I really appreciate it. Most of the time, I'm just thinking about who gets what couch. So I appreciate that. I need to think about whether you can do what you just said using the document. Go ahead, please, Mr. Aiello.
And I'm sorry, Your Honor. Plaintiffs would
Big
like
plans
to.
with your life, I see. Go ahead.
Yeah. Your Honor, plaintiffs would like to bring to the court's attention a recent decision. Plaintiffs would first like to state that plaintiffs understand that federal court rulings have no bearing on this court's decision, especially not on evidence, as this court has previously ruled. However, plaintiffs would like to draw the court's attention to a case that was decided, I believe, about an hour ago. This is Duncan v. Bonta, case number 17-CV-1017-BEN. We would just like to bring that to the court's attention as a notice of authorities, specifically with regard to this witness and the evidence presented. My understanding, though I have not read the entire opinion, is that the opinion does address this type of data. And so plaintiffs just want to draw that to the court's attention and don't expect any evidentiary ruling on the basis of federal court's determination, but just wanted to state that for the record.
Yeah, I'm not going to consider that.
Understood, Your Honor.
What I'm reading in Kirkpatrick at page 1025 is what I figured the logic was, but I was looking for it. It says a chart, summary, or calculation may be excluded where the underlying documents were not made available to the opponent for examination. And there's a site in there, a federal case site. The chart, summary, or calculation should also be made available in advance of trial in order to make the examination of the underlying documents meaningful. If the summary is likely to confuse or mislead a jury or create an unfair prejudice, it may be excluded under Rule 403. So there's a suggestion in the rules that the normal discovery by ambush rule should not apply when you're trying to bring in a summary of data, that the data should be provided in advance of trial. And I would note, again, that Mr. Aiello is trying this case on his own for the plaintiffs. The state has 8 attorneys that have been present throughout these proceedings along with staff. He has not had much of an opportunity to review and consider all of the things that are being filed with the court. And certainly he was not given an opportunity, it sounds like, to review the underlying 9,400 pages prior to trial. You're not required to do it, but then When you don't do it, it leads the court to make certain determinations about what exhibits can be admitted or not admitted. And I would say that based upon the evidence here, that it would be excludable under 403 because it creates an unfair prejudice to the plaintiffs.
Your Honor, may I be heard on this topic further?
Of course you can.
Thank you, sir. The one piece of additional information I'd like to provide to the court is that this chart was made an exhibit in the federal trial. Mr. Aiello filed motions in limine that seem to be related very similarly to the federal trial. For example, moving for exclusion of Dr. Cook, as well as another witness related to victim testimony, suggesting that the plaintiffs and their counsel had actual notice of those proceedings. Ms. Allen was a witness in that proceeding. The plaintiffs moved to exclude her testimony, meaning essentially the first half of Mr. Baez's testimony here, on the theory that Ms. Allen, or as it turns out, Mr. Baez would be presenting this type of evidence here today. So in terms of this document, I think that it was publicly available. It was likely to appear here, and there was no request from the plaintiffs for the underlying records in advance of trial. And so I think that would be an additional factor. I think the other, I guess, just practice and discipline rule is that I think, in our view, the practice of the work product protection trumps the 1006 fair notice in all respect to Professor Kirkpatrick and the court's ruling.
Well, I think what the rule does is protects that right. The question is whether or not you want to use a chart or not. And as a proponent of the evidence, you have a choice to make. I'm going to preclude distribution of this information and not be able to present a chart, or I'm going to provide the information, then have it consolidated down into a chart. As to what happened in the federal case, again, he was not a party to that. The proponent has the obligation to provide sufficient evidence, information, so that the defense or that the opponent can have an opportunity to review underlying data. Finally, I would say I saw a chart very similar to this chart in the December documents, but we're not including that information here. So I'm not unfamiliar with this type of documentation. I don't remember which of the exhibits it was.
That's a far better example, Your Honor, than the one that I cited to you. So Matt, I would actually need to go back and refresh whether that was submitted. And so I think that would actually be another.
This was submitted, something very similar in style was submitted
to
the court. I don't know.
Think Ms. Allen's declaration may have been submitted to the court. I would have to go back and look at it. But I suppose that raises the same issue as to whether or not there was notice to Mr. Aiello of the fact of the chart.
Yeah, but that's not what the rule says, is it?
No, but
there's notice that there's going to be a chart that says you provide the documents and then you can admit the chart.
But upon request, if I'm not mistaken. So the question is whether Mr. Aiello had a reason to request the documents ahead of time to put us to this choice.
The originals and duplicates shall be made available for examination or copy, or both, by the other parties at a reasonable period of time. It doesn't require a discovery request.
So I understand that language to suggest that, not to suggest that it is an affirmative obligation. It's an affirmative obligation upon request. Obviously, the word isn't upon request isn't in the text of the rule.
I'm not going to hold the state to that interpretation of shall. Go ahead, please.
Okay. Can I show Mr. Baez Exhibit 107?
For what purpose?
For him to describe in more detail the research that he had done in order to come to his opinions today.
You can ask him questions, and if he needs the chart for purposes of refreshing his recollection, I'd let you do it that way, I guess. Because there's no foundational requirement for documents of refreshing recollection, but I'm not gonna over the objection of the plaintiffs, I'm not gonna let it be admitted or used as a descriptive form.
Okay. Mr. Baez, you said that you and your colleagues tried to categorize which I'm sorry, I need a moment.
It's okay.
Your Honor, maybe I have 5 minutes to consult with my colleagues.
Sure, of course you can.
Okay, thank you.
We have procedural safeguards that happen in these cases. It has nothing to do with your veracity or otherwise, credibility or otherwise. It's just procedural protections under the law, and I need to maintain those. So We're going to finish this witness no matter what today, because I know he flew in from a long distance, and the weekends are great in Harnett County, but I'm certain he probably wants to get home.
Even better, if you can talk to him about it after. Did you calculate the number of fatalities that had occurred in these 179 mass shootings?
I did.
What was the total number of fatalities?
I don't remember it off the top of my head.
Would Exhibit 107 refresh your recollection?
It would.
What was the total number of fatalities and the overall number of incidents?
So on overall 179 incidents covering this 40-year period, there were a total of 1,272 fatalities.
Your Honor, plaintiffs object pursuant to 1006 that plaintiffs have not had the opportunity to review the underlying data.
Your Honor, we're not offering the chart with this question. We're offering the expert's opinion. And under the work product rules, there was no obligation to provide the reliance materials prior to Mr. Baez being called to the stand. When Mr. Baez was called to the stand, we promptly provided those to counsel.
Yeah, I'll overrule the objection. Go ahead, please.
Mr. Baez, how many fatalities were there in the 179 incidents that you identified?
Yeah, 1,272 fatalities,
How many injuries?
1,417 injuries.
Did you and your colleagues determine which of these were in which a large capacity magazine was involved?
We did to the best of our ability.
What was the average number of fatalities in an incident where there was a large capacity magazine involved?
10 fatalities,
What about ones that were without that?
6 fatalities.
And then what about injuries?
There were 16 when large capacity magazines were used by the shooter, and only 3 when the shooter did not use a weapon that had a large capacity magazine.
What about the number of shots fired? Did you look at that question?
I did.
How many of these, or what was the average number of shots fired when a large capacity magazine was used?
99 shots.
And what about when a large capacity magazine was not used?
16 shots.
Do you recall the total number of incidents in which a large capacity magazine was used?
I think it was 79, but I don't remember the exact number.
Would the chart you prepared refresh your recollection of the exact number?
It would.
I'm showing to counsel and providing to the court Defendant's Exhibit 109 with the request that I can provide it to the witness to refresh his recollection and publish it to the courtroom.
You can use it to refresh his recollection. You can't use it. You cannot publish it. That's an inappropriate use of a document for refreshing recollection.
Your Honor, may I be heard on one quick matter?
Sure.
I'd just like to state for the record regarding 109 and 107 that plaintiffs have also made a hearsay objection that the court has previously sustained regarding these documents when it goes to admissibility. I understand Your Honor has also ruled on admissibility under 1006, but just so the record's clear, I believe, well, plaintiff's objection to the admissibility would be hearsay for both of these, for both exhibits 107 and 109, and plaintiffs would ask that the court's ruling on admissibility reflect the court's ruling on hearsay as well.
You want to respond? I mean, what's been admitted, it's been admitted without objection. So I guess he's objecting to the information in 109,
And
answering the question around mass shootings and yeah.
under 702, 703, and 705, the witness is allowed to rely on hearsay for calculations and so forth related to his opinion.
Plaintiffs don't disagree, Your Honor. What plaintiffs are stating is that Your Honor has, plaintiffs understand, ruled that these documents are inadmissible under 1006. Plaintiffs are also asking, just for the record, that this court also find that these exhibits are hearsay. We've had quite lengthy discussions
Sure,
about.
hold on, let me stop you there. He's not offered it.
But understood.
Using it to refresh his recollection based upon how he calculated his data. I'm allowing him to do that if it refreshes his recollection. He can't read from it. He can look at it to see if it refreshes his recollection. The remaining pieces of your objection would be if we were talking about admissibility, and I would consider them then. But for now,
I'm sorry, Your Honor, didn't you rule on admissibility regarding 107?
yes, I said it was not admissible
Under 1006.
under 1006.
And plaintiffs are just stating for the record the hearsay objection as well, and asking that the court rule on the hearsay objection regarding exhibit 107.
Yeah, it's not a ripe issue, so I'm not going to rule on it.
Understood, Your Honor.
That's what I was trying to say. And so in too many words. Go ahead, please.
Overall, in the 179 mass shootings that you identified, how many were you able to confirm used a large capacity magazine?
73.
How many were you able to confirm that no LCM was used?
42.
How many were you not able to confirm one way or another?
64.
And with respect to those that you were not able to determine one way or the other, what was the average number of fatalities?
5 fatalities.
And what was the average number of injuries?
3 injuries.
Did you do any work to determine the trend in the number of public mass shootings over the time period you studied?
I did.
Mr. Ayala has previously been provided, not that long ago, defendant's trial exhibit 108, and I am now going to provide it to the court. Well, maybe I'll ask one question first. Do you remember what those trends were?
Generally, yes.
And what were they?
Over the last 40 years, which my data covers, there's been an upward trend in the number of mass shootings occurring.
So I'm going to provide to the court exhibit 108. Defendants move admission of 107, 108, 109, expecting that the court will rule that they are barred under 1006 for the since previously stated on the record, and that other issues of admissibility are not ripe.
Plaintiffs renew their hearsay objection as well, Your Honor.
So you're adopting what he says you're going to say as the objection and then also for hearsay purposes.
Hearsay and 1006, yes, Your Honor.
I think under 1006 is sufficient basis for me to deny admissibility without further.
And for the clarity of the record, we're standing on the previous record we made, of course. Okay, we're getting faster.
It's a little late in the week to get fast.
Better late
Come
than
on ahead.
better very late than never. Did you consult any other sources of information to look at the question of whether there was a trend in the number of mass shootings?
I did.
What other source of information did you consult?
The Gun Violence Archive, which is a database that I mentioned earlier, which collects the shooting information from all across the country in a variety of different aspects. And they also have they use their own definition of mass shooting and have categorized certain shootings as mass shootings.
What definition do they use?
So they use a much broader definition. So definition is 4 killed or injured. So for example, my definition had 4 people had to be killed. Their definition is 2 can be killed and 2 can be injured. Then that would qualify as a mass shooting. Additional.
No fatalities, just 4 injured.
Could be a mass shooting. That's correct. In addition, they also include shootings that occur in the home, which my analysis was particularly focused on public mass shootings. So they include that, and they also include shootings that are associated with other crimes. So it's really any shooting that has, at least four injuries or a combined, 4 of.
Thank you.
Did you consult that data also for Oregon alone?
I did.
Do you remember the number of shootings with 4 or more fatalities or injuries in 2022 in the United States?
Not at the top of my head.
Okay, I'm going to provide Exhibit 110 to counsel in the court with the request that I can show Mr. Baez that document to refresh the recollection.
I mean, you can, yeah, I mean.
Mr. Baez, does Exhibit 110 refresh your recollection?
It does.
How many shootings with 4 or more fatalities or injuries under the Gun Violence Archive definition did you find in 2022?
645.
And what about in 2021?
689.
Let's look at, well, I'll ask you the question, another question you will not remember the answer to. How many total fatalities were there in 2022?
I don't remember off the top of my head.
Would looking at page 2 of this exhibit refresh your recollection?
Yes.
Let's look at page 2. Does it refresh your recollection about the number of fatalities under the GVA definition in 2022?
It does.
How many?
3,298.
And is that the number of fatalities and injuries in total?
That's the combined fatalities and injuries.
Okay, let's separate it out. How many injuries?
2,657 injuries.
How many killed?
641.
And then for 2021, how many, let's just start with how many killed?
668.
How many injured?
2,785.
And
Our plaintiffs object on scientific foundation. May I ask a question in aid of objection? Mr. Baez, do you know how much Oregon's population increased between 2014 and 2022?
I do.
How much did it increase?
6%.
What is your source for that data?
It's census data. And I'm sorry, I think that
From when to
number
when?
It's from 2014 to 2020 is what I know. That's the numbers I know, and it's 6%.
Do you know?
I
how
don't know
many-
it through 2022. I have not updated that or looked at the updated numbers.
Your Honor, plaintiff's objection is scientific foundation.
I understand this not to be Oregon specific, correct?
The numbers that I have asked Mr. Baez for are United States wide. I think
National, these are
very
national
soon
numbers.
we will be moving to Oregon numbers.
So these numbers are all related to 4 or more injured or deaths together in 2022. Okay, I got it. Now I've got it. I understand. I understand the numbers. Go ahead.
Did you also look for these numbers in Oregon?
I did,
Do you remember the particulars?
not off the top of my head.
Does page 3 refresh your recollection?
It does.
How many shootings in Oregon were there with 4 or more fatalities or injuries in 2014?
Your Honor, plaintiffs renew their objection based on Mr. Bias's same answers regarding the population increase from 2020 to 2022.
I mean, this is just statistical data that he's deriving. I give the weight to it that I choose to give to it based upon the information provided. It's a statistical analysis. It's not some type of policy determination, or he's not even really looking at, he's not analyzing the data in terms of policy. So allow him to testify to it. It's statistical. If you want to poke holes in that statistical information, you're welcome to do so.
Understood.
Go ahead, please.
How many shootings with 4 or more fatalities or injuries were there in Oregon in 2014?
2,
How many in 2015?
2,
How many in 2016?
2,
How many in 2017?
0,
What about 2018?
0,
2019?
1,
2020?
2,
2021?
7,
2022?
6.
Did you also look at the total fatalities or and injuries from these events in that time period?
I did.
How many were killed in 2014 in these incidents?
I don't remember off the top of my head.
Would page 4 of this exhibit refresh your recollection?
It would.
How many were killed in Oregon in 2014 in shootings with 4 or more fatalities or injuries?
1,
How many were injured?
8,
In 2015, how many were killed?
10,
In 2015, how many were injured?
13,
In 2016, how many were killed?
3,
In 2016, how many were injured?
5.
You said there were no shootings in 2017 or 2018, right?
That's correct.
In 2019, how many were injured?
5.
Were any killed?
No.
In 2021, how many were, sorry, in 2020, how many were killed?
1,
How many were injured in 2020?
7,
How many were killed in 2021?
5,
How many were injured in 2021?
32,
How many were killed in 2022?
5,
How many were injured in 2022?
23.
No further questions.
Go ahead, Mr. Allen.
Thank you, Your Honor. Let's stick with Exhibit 110 here for a moment. You can look at page 3 of that exhibit. Did your study look at any specific causes of these shootings?
Objection ambiguous as to whether it's his study of as the whole or just with respect to this data in Oregon.
I'll sustain. So,
Mr. Baez, in reference to exhibit, defendant's trial exhibit 110, so this portion of your analysis, did you do any analysis regarding the causes of the shootings identified in this exhibit?
We reviewed the news stories and the incidents, but I don't think we did any specific analyses on that.
So you don't know what the causes were?
No, I said we reviewed the news stories and we would have seen what some of the causes were. I don't think we did not do a particular analysis of that, but I think we did know the causes.
Mr. Baez, from your personal knowledge, you do not know what the causes of these mass shootings were, correct?
I don't understand what you mean by causes.
You don't know what prompted the shooting, right?
Well, in some instances, the news stories described what might have prompted or theories on what might have prompted that, so I would have
Actually,
reviewed
that's
that.
outside the scope of the direct testimony, Mr. Aiello. I don't think that's what this is offered for. It's really just a numbers piece, fatalities.
I join the court's objection.
I'm just saying.
No, and I was
don't
late on
want
the
him-
objection.
I don't want him to speculate about causes or non-causes. It's not part of the evidence.
Have you watched this trial over the last 5 days?
I've watched little pieces here and there, but not all of it by
Were
any
you-
means.
Did you observe Sheriff Bowen's testimony?
I'm not sure.
The NRA study covers 736 incidents over 6 years, correct?
It's almost 6.5 years, but yes, 736 is the number.
So that'd be fewer than 122 incidents of defensive use of firearms per year, correct?
I can't do that math in my head that quickly. It sounds generally about right.
You understand that there are more defensive uses of firearms per year than 120, correct?
Yeah, yes, that analysis wasn't supposed to cover every single incident of defensive gun use. It was looking at all of the incidents within the NRA database.
Does the NRA database include reports from non-NRA members?
It does, because a lot of it was based on news stories. A lot of the information in there is based on news stories from different sources that I don't think have any connection to the NRA.
How the NRA receives its data from self-reporting, correct?
It's a little unclear how they decide what they put into their database. They're not very clear in their description of the database how they do that.
The you testified that you used Factiva, correct?
That's correct.
Factiva explains how they gather their data, correct?
Yes, they compile their data, their sources from, I mentioned over 33,000 sources worldwide.
There's no control with the NRA data for rural versus urban uses of defensive uses of firearm, correct?
I don't know what you mean by that.
Does the NRA data does not, you know what a control is, right?
I guess I don't understand in what context you're using it. A lot of times when I use the word control, it can mean something very specific regarding some of the analyses that I do.
The NRA data does not does not, for instance, capture defensive uses of firearms for wild animals, correct?
It does,
It does?
yes.
The NRA data does not cover defensive uses of firearms outside of the home, correct?
No, it absolutely does.
And inside of the home?
Yes, both.
Does the NRA database tell you the number of assailants?
Well, the NRA database just gives you a report of what the incident was, and sometimes there'll be enough information to determine that, and sometimes there won't. I think in most cases, there would be enough information to determine that, according to the news stories and the information in the database.
The NRA database reports are anecdotal, correct?
So no, I would say they changed a little bit how they reported over that time period that I looked at. So at the beginning, they would have a paragraph that was written by somebody, I'm guessing at the NRA database. Later on, they just started directly just putting a link to a news story. Also, what we did is we always tried to find at least one additional news story, and we did for, I think, almost all of them. We found an additional news story that supported whatever was in the NRA database.
The NRA database is not peer reviewed, correct?
I don't understand what that means in this context.
Do you know what peer review is?
You mean peer reviewed as in a journal?
Correct.
It's not a journal, so it wouldn't be peer reviewed.
No further questions, Your Honor.
Any redirect?
No, Your Honor.
All right, sir. Thank you for your time. If you're going back through Boise, they have very nice Basque food there.
No, I'm going back to Redmond, flying out of
Oh,
Redmond.
there's no Basque food there.
You recommend anything there? Happy to.
You'll notice I'm sitting quietly. Anyhow,
Thank
there's
you.
some nice food pods. There's a brewery and some food pods in Redmond. It's pretty nice. Have a good day and a safe travels home. Thank you.
Your Honor, we'd like to address two exhibits we'd like to move into the record, and Mr. Jindal will be handling that.
Okay.
Thank you, Your Honor. Defendants will move for exhibits 104 and 105. Move for the admission of 104 and 105. Now,
Let me get there.
Of course.
Before you get started.
do you mind if I sit?
I don't.
Thank you.
Too tall to just talk into that thing.
Thank you. I believe they should be in everyone's binders.
Okay, I have 104 in front of me.
Thank you, Your Honor. And I suspect that this is going to fall under your relevancy objection or relevancy rulings from the motion to eliminate hearing and throughout these proceedings. But given the disdain that the appellate courts have for standing objections, I thought we would make the motion.
That.
Yeah.
I think that's a good idea.
Thank you, Your Honor. This is the plea allocution in a federal criminal case. It's U.S. versus Ernest 319-CR 1850 AJB. And just for context, this is the plea allocution for the Poway shooter in Poway, California. We're specifically interested in pages 14 to 16, where the perpetrator of this shooting admits that he had a 10-round magazine loaded in an AR-15 style rifle. He brought 60 rounds of ammunition with him and was stopped by worshipers when he stopped to reload his firearm. And he specifically said in his public comments that his intent that day was to kill more individuals, and he would have killed more individuals if he hadn't been stopped while reloading.
Okay.
So we move for the admission of 104.
Your Honor, may I have a moment to look at my notes?
Sure.
I took notes on this issue.
The door locked on him. It wasn't intentional, Mr. Wilson, I promise.
Thank you, Your Honor.
Mr. Aiello,
I cannot find my notes, Your Honor, but that's okay. So plaintiffs object. One, plaintiffs do assert that this was covered by the court's motion and the court's rulings on plaintiffs' motions in limine. Further, it has no relevance to this case, and most importantly, it is hearsay.
I'd like to respond to the hearsay objection. I think on first, at least, we believe it is admissible under 804.3c as a statement against penal interest, and also under the residual exception. It's a statement against penal interest because it's a plea colloquy, and Mr. Ernest is admitting to violently killing multiple people and desiring to kill more. And it's subject to the residual exception because it was made in a court proceeding. It was heard by a magistrate judge. The shooter would have been under oath. It was transcribed by an official court reporter.
I think 804.3 is directly related to the penal interest of a party at issue in the case.
I don't think that's right, Your Honor.
Okay, well, tell me why it's not right.
Let me pull up the rule here. It says the statement which was at the time of its making so far contrary to the declarant's pecuniary interest or proprietary interest. That a reasonable person in the declarant's position would not have made the statement unless the person believed it to be true. And I have a Seventh Circuit.
Need to call him as the declarant as a witness for you?
No, Your Honor.
Okay, well, that's the first line of the rule on page 119, so.
Well, I believe we just have to show that he's unavailable, and he's unavailable because he's currently serving 2 consecutive life sentences for the crime he described in the transcript we're trying to get admitted.
Clever, but no.
I'll move on then, Your Honor.
I have absolutely no foundational basis to believe that you would have called him as a witness. If I were to allow this in, I would be in a position of allowing every colloquy ever made within the states on incidents regarding mass shooting, which to me is not particularly valuable evidence. I also don't think it meets the rule. So the answer is overruled, but I'm going to sustain the objection. Go ahead, please, Mr. Jacob.
Understood, Your Honor. The next one we will move to admit is Exhibit 105. This is the police report from the Las Vegas shooting, which is I believe, the largest mass shooting in the country's history. The killer killed 60 people and wounded hundreds more. Here, we're particularly interested in pages 84 to 107. Before you turn to them, I just do want to warn you, this is a police report, and I believe it includes a picture of the shooter dead at the scene of the crime. I just thought that you deserved that warning before turning the page. And those shows crime scene photographs, as well as cataloging the evidence found at the crime scene, which includes many, many large capacity magazines, including 25 round magazines and many, many 100-round magazines. So we move for the admission of Exhibit 105.
Your Honor, plaintiff's objections are, first, that plaintiffs believe this is covered by this court's rulings on plaintiff's motions in limine. It is irrelevant. It is irrelevant to Oregon. It is hearsay, and it is unduly prejudicial.
Your Honor, I'll start with the hearsay exception. We believe it's admissible under 803(8)A and C. It's a public record, in this case, the Las Vegas Police Department's official record. It describes the official activities of the agency under 8A, and it describes the results of an official investigation under 8C.
Okay. So do you want to respond to the question under 803(8)? 803(8). I mean, I think there is a balancing question under 403 that I need to make a decision about as well. Statistically, that it happened. Not sure what additional indicia it brings to the court. Its relevance is I guess of some interest to the court.
Your Honor, I'm sorry, Your Honor, I do not have case law open on this, but my understanding is police reports are not routinely admitted under this exception without testimony from the officer.
Your Honor, I believe the rule he's describing is a confrontation clause problem in criminal cases, which isn't what we're confronted with here. Apologies for the ambiguous use of confronted there.
Also, plaintiffs would add that plaintiffs believe there needs to be a custodian of records.
Your Honor, if I may be heard, my understanding is that he's challenging the authenticity of the document. We pulled it from the Las Vegas Police Department's official website. My reading of the rules is that a public record can be offered with a copy. If necessary, I'm happy to have the paralegal that helped pull this document authenticate it by describing the act of going to a publicly available website and downloading it.
If that was the case, Your Honor, then the Oregon Secretary of State website article would have gotten in.
Which article was
I don't.
that? Plaintiffs sought to introduce one Oregon Secretary of State's state article, and it was turned away on hearsay grounds.
I thought I admitted those. Maybe I misunderstood.
No, Your Honor, the court did not admit the article itself. The court did admit the source documents under the ancient document exception to hearsay.
Your Honor, I believe that that's a slight mistake there. We stipulated to the authenticity of the document as appearing on the Secretary of State's website.
Uh, I'll think about it. I need to read it and think about it a little bit more. I haven't looked at this rule. Since most of the stuff I deal with criminal cases where it would absolutely not be admissible, but that isn't, the subsection B doesn't apply in these circumstances.
Understood, Your Honor. I just want to point out one thing that I missed is that in C, it specifically says that in civil actions, it's permissible. It says in civil actions and proceedings and against the government in criminal cases. And so the requirement that I think that makes clear what I was describing earlier, that in civil proceedings, the report comes in. The problem is when it's against the defendant in a criminal case.
Yeah, I need to think about what that means and what reports mean, and I need to look at the specific case law around that question before I make this determination. Another one of these doors, when opened, that creates significant evidentiary challenges for the court, just in terms of 179 police reports, right? I'm just not sure that that's something that I'm prepared to do on this record. And I'm not sure it's relevant to the court's inquiry at the end of the day.
Understood, Your Honor. One housekeeping question. What was the basis on the 104 denial? I'm not trying to relitigate it. I just didn't have it. And I want to make sure the record's clear.
I don't know what you're saying right now.
I'm sorry. What was, I believe you sustained the objection to the admission of Exhibit 104. I didn't catch the basis for the.
104, see, because I've been doing 104 hearings all week.
Oh, understood, Your Honor.
I don't think the rule provides a hearsay exception for what you're trying to introduce.
Understood, Your Honor. Thank you.
Did you want to respond to the question of relevance as well on 105, since we've just sort of plugged into the question of hearsay, is of relevance?
Yes, Your Honor. I think that this is
inartfully a 403 objection along with that, which how I read it, understood it.
Can I confirm my comment? Oh, yeah. Yes, Your Honor. I think we've briefed this a bit, but both in our motion and limine briefing and in the brief that we filed yesterday, we believe that part of the inquiry includes inquiring into the reasonableness of the public policy.
Agreed.
And the public safety interests, and here the use of large capacity magazines in one of the most significant mass shootings in the nation, including one that happened very recently, is relevant to the public safety implications, and it would have been information available to the voters and on the voters' mind. And it also goes to magnitude of the harm that the law tries to guard against. This was the most significant mass shooting in the nation's history.
like to respond, Mr. Ayala?
Yes, Your Honor. So this is a tragic mass shooting in Las Vegas, Nevada, not in Oregon, not in Harney County, not in Multnomah County. So plaintiffs would assert, first of all, that this is irrelevant to Oregon, and then also that it's irrelevant under Your Honor's prior ruling regarding the motion in limine. I think as far as public safety goes, defendants have been allowed to show statistical data regarding public safety. One mass shooting, although tragic and extreme, is not indicative of, it does not help this court determine whether ballot measure 114 will further public safety or not. It's for humanity, it's significant. For determining public safety, it is not. For Oregon, it is not.
You're, sorry.
Go ahead. You're welcome to respond.
Thank you, Your Honor. I just have two quick responses. I don't want to belabor the point because I do think we've briefed and argued this a bit. The first was that both the legislative history that's been presented in this court, including the testimony of Mr. Paterno and the preamble itself, indicates that the people of Oregon, when they passed Measure 114, were concerned with and affected by news reports of, or not just the reports, but the actuality of mass shootings nationwide. And the second point was just that plaintiffs were permitted to put on copious amounts of anecdotal testimony regarding their self-defense needs. As you indicated earlier, we heard many stories about wolf hunting. I think that the same type of example evidence is fair for us to put on.
And Your Honor, again, plaintiffs reiterate that defendants have alleged, have put forth before the court that so defined large capacity magazines are not useful for self-defense. That is the plaintiff's evidence went to rebut that, not to make some broad claim about public safety based on plaintiff's evidence. Plaintiffs understand that this court has, to a certain extent, altered the court's ruling on the motions in limine. But plaintiff's evidence did not run contrary to this court's ruling. Plaintiff's evidence went to rebut a specific claim on a motion in limine that was denied by the court, which plaintiff said relevance regarding the 2.2 rounds issue, and this court said that the court would hear the evidence. So plaintiffs presented evidence on the usefulness of so defined large capacity magazines, and in doing so, they did not open the door to broad claims regarding public safety. Plaintiffs did not, for example, put on statistics about how many wolf attacks there are per year. Plaintiffs showed that firearms, including firearms armed, utilizing as many rounds as possible, are useful for self-defense in these situations.
I'll think about it. I'm going to think about it first on the hearsay exception. And if I allow it past the hearsay exception, I'll make a determination about it under 401, its relevance under the guise of Christian. And then after that, if I decide it's relevant there, I'll make a balancing determination under 403 and give you an answer. I want to think about it. I wasn't anticipating this type of evidence. And just because I wasn't anticipating doesn't mean I shouldn't be available to make a ruling, but I want to make the right call here. I mean, I recognize that the Las Vegas shootings is the most horrific act of domestic violence involving a mass shooting in American history. So it's interesting in that respect, but I just need to think about whether it's relevant to the court's inquiry under Christian. That's what I'm bound by, right? Is there anything else you want to argue on it?
Nothing further from defendants.
Anything else?
Nothing further.
All right, I'll think about it over the weekend.
Thank you, Your Honor.
because we're obviously going to go on Monday. So go ahead.
Your Honor, can we take a brief recess before defendants call their next witness so I can get my expert on the line? He may already be on the line. I just want to call and check with him.
All right, let's just get it. We'll give another, I'll come back on the record at 3:55. All right. So I think it's pretty clear we're going to go into Monday. How many more witnesses does the defendants intend?
This will be the last witness, Your Honor, and then we'll have one brief motion for the court, and then I expect that we will rest.
Okay. And rebuttal wise?
Plaintiffs do anticipate, largely dependent on this last witness, Your Honor, brief rebuttal case on Monday. And then closing.
We'll start at 9 on
Yes, sir.
Monday. I'm willing to go up to the 5 o'clock hour. And if this witness is going to take much more than that, I really do have to be home with my kids because my wife's coming down here for orthodontia work. So going past one another. But I understand the state has paid for someone to be here, and I want to get it done if I can. Go ahead.
Thank you, Your Honor. The state calls James Yorgulaitis.
Yes. Hello. Raise your right hand, sir. Under the penalties of perjury, do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth? I do. Thank you. Have a seat up here, sir. Once you're seated, please state your name for the record and spell your last.
James Yorgulaitis. The last name is spelled Y-U-R-G-E-A-L-I-T-I-S.
All right, go ahead, please.
Good afternoon, Mr. Yorgulaitis.
Good afternoon.
Could you tell the court what your current professional position is?
I currently am self-employed as an independent consultant, and in that capacity, I provide firearms-related technical assistance or expertise to legal counsel, corporations, and other entities in the public and private sector.
Where did you go to college?
St. John Fisher University in Rochester, New York.
What is your degree in?
I have a Bachelor of Arts in political science with a minor in psychology.
Could you describe for the court briefly your employment between college and your present position?
Yes. After I graduated from college in May of 1986, I took a position with the U.S. Department of State as a special agent in the Bureau of Diplomatic Security, where I served in the Washington Field Division for 2 years. I'm sorry, a year and a half, then on the Secretary of State's protective detail for 2 years, and then 2 years after that in the Washington Field Division again. After that, I accepted a position with the Bureau of Alcohol, Tobacco, and Firearms in 1990 and was assigned to the Baltimore Field Division, where I, after training, basically worked on large task force operations with other federal agencies that targeted violent narcotics trafficking organizations as well as other violent crime organizations.
Could you describe for the court briefly your employment as it relates to firearms between college and your present position?
Well, in terms of employment, obviously after going through basic special agent training for both Diplomatic Security Service and ATF, which involved a significant amount of firearms related training, I also was chosen at one point in ATF in 2001. ATF decided to create a cadre of special agents who could testify to the interstate movement of firearms and ammunition so that they could testify as expert witnesses in federal criminal trials where that was an element of the offense.
What practical training on firearms did you receive during your career?
When I first started with diplomatic security, we had some obvious basic firearms training to familiarize ourselves with the firearms that DSS utilized. And we also had a good portion of training in foreign weapons that we might encounter overseas while we were working either protective details or working out of embassies as assistant regional security officers. et cetera. Also, when I went to ATF, there was a significant amount of training in terms of firearms classification in order to be able to identify and classify the different types of firearms that we would encounter in criminal investigations.
Were you assigned at ATF, were you assigned duty weapons?
Yes,
How often did you have to qualify on each duty weapon?
quarterly.
What law enforcement trainings regarding firearms have you taught?
While I was an agent with ATF in the Baltimore Field Division, I taught firearms classification training to in-service classes for the Baltimore City Police Department for a period of over 1 year. I was teaching one of those per week. Later, when I left the Baltimore Field Division and I went to the ATF Laboratory Center to run their forensic firearms training programs, I taught some part of some of the courses in the National Firearms Examiner Academy, which was a 1-year forensic firearms training program that I was responsible for the administration of. I also taught firearms identification and firearms trafficking training at the International Law Enforcement Academy in Budapest, as well as serial number restoration training for forensic laboratories in Canada, and classes for students that had come into the United States from Central and South America.
During time at ATF, did you tour firearm manufacturers?
Yes, as part of the training to establish a group of agents who could testify competently to the interstate nexus of firearms. ATF provided, in conjunction with numerous firearms factories in the United States, the opportunity to tour their facilities and gain, some insight as far as how those firearms were manufactured, what markings were on those firearms, and the history of those particular firearms manufacturers. So we visited quite a few in the United States, to include, Colt, Mossberg, Marlin. Gosh, I'm drawing a blank here for a second.
Did you visit Springfield?
Springfield Armory National Historic Site we visited in order to look at the reference collections there. We also visited a number of other reference collections in the Connecticut Valley region that were associated with some of the firearms manufacturers.
Did you tour firearm manufacturers in Europe?
Yes, as an expansion of part of the training that we received in the United States, we also toured 2 weeks, or had 2 weeks worth of tours of firearms factories in Europe, and visited Heckler Koch, Fabrique Nationale, Glock, Česká Zbrojovka in the Czech Republic, as well as some of the European proof houses.
When you went on these tours, who did you meet with?
Not quite used to talking so much.
I understand.
The tours that weren't along the lines of regular public tours that some of these factories would actually, bring in or open up to for the public. We were accompanied on those tours or guided on those tours either by corporate historians, manufacturing engineers, production engineers, other custodians of records, in those firearms factories, as well as managerial personnel, sales personnel, marketing personnel. And they consisted mainly sort of a stem to stern approach, where they would start mainly where the raw materials came in. You would see all the production processes. You would see, and those would be explained by obviously the production personnel and the design engineers. And you would basically follow the production processes for these firearms from raw material to, finished inspected firearms that were packaged up and ready to be shipped out to wholesalers.
When you met with historians at those manufacturers, what did you talk to them about?
Essentially, they would explain the differences in production processes that they had gone through over the years, the different types of firearms that were manufactured by them over the years, the difference in markings on those firearms that would help determine their place of manufacture, which was an important part of that expertise that ATF was trying to build. And basically showing us, in addition to the production personnel, how their production methods had changed and how that affected, the way the barrels were rifled, the way that frames were manufactured, forged, or, investment cast, or manufactured from bar stock, things like that.
How many times have you testified as an expert over the course of your career?
In a trial setting like this, as an expert, approximately 10 times. However, as an expert in federal grand juries, over 100 times.
Have you examined firearms?
Yes.
How many firearms would you say you have examined?
Conservatively, I would say in excess of 5,000 as part of that responsibilities for being trained to be able to testify to the interstate nexus of firearms and ammunition. We were required to inspect and examine all of the firearms that either ATF seized during criminal investigations or other agencies in those task force settings had seized during group criminal investigations. And that was mainly in order to facilitate tracing of those firearms and to ensure that the correct information was sent out to the tracing center to, in order for those firearms to be successfully traced after a criminal investigation.
What work have you done as a consultant over the course of the past 10 years?
Over the past 10 years, well, this trial, for example, perhaps expert reports that were requested either by different law enforcement organizations in particular states, working as an individual who could advise a governmental entity in terms of the type of response that they could file, in a lawsuit such as this. I also have done case reviews and evidentiary reviews for defense attorneys that were both private and the Federal Public Defender's Office in two federal judicial districts. And additionally, some business assessments for corporations that were involved in the firearms industry or investment companies that were involved in the firearms industry.
Does your consulting work require you to keep abreast of the current market for firearms and firearm accessories?
Yes.
And how do you do that?
Well, one of the most important things that you can do is go to either local or national trade shows or gun shows. As I'm sure that anybody who's interested in firearms wants to see what the latest models and accessories are, et cetera. So during my tenure at ATF and as a private consultant, I've been to the SHOT Show, which is the National Shooting, Hunting, and Outdoor Trade Show, and it's massive. It's usually held in Las Vegas in the convention center. I've been there on 7 different occasions. Also, the gun shows that I've attended around my local area, being in Maryland, Virginia, Maryland gun shows, Pennsylvania gun shows, and will, when I have the opportunity, hop into a local federal firearms licensee and see what is available for sale and talk to the individuals that own it and see, what are the most popular firearms that you're stocking right now, or what seem to be more popular.
Do you review firearms catalogs?
Yes.
Do you review periodicals about firearms?
Yes, I do. And I also maintain a reference library of I would say 75 to 90 separate books on firearms, whether they're brand specific or they're price guides or other reference materials.
Mr. Yurgiladis, I'm going to show you an exhibit that has been pre-marked Exhibit 155.
Why don't we close the shades so he's not getting baked out of the room? I think that might be part of it.
Thank you, Your Honor.
Sun creeps around on us once in a while in here. Go ahead, please.
Mr. Yurgiladis, do you recognize this exhibit?
Yes.
What is it?
It's a copy of my CV and also what I call a qualification statement, which essentially is a document we used to provide to the U.S. Attorney's Office in criminal cases that goes into more detail about our specific training or training that we've received in the discipline that where our expertise lies.
Does it fairly represent your professional experience?
Yes.
Your Honor, I would move to introduce as Exhibit 155, Mr. Yurgiladis' CV under OEC 104 and 702.
No objection, Your Honor.
Well, 155 is admitted.
And Your Honor, at this time, defendants would move to certify Mr. Yurgiladis under OEC 702 as an expert in the areas of the technical aspects of firearms and the commercial market for firearms.
Plaintiffs have objections. Can I ask a couple questions in aid of objection, Your Honor? Mr. Yurgiladis, when's the last time you toured the Colt manufacturing facility?
I'm trying to think. I've been there approximately 7 times. I think the last time I was there was 2012.
What about the Mossberg manufacturing facility?
The last visits that I had to most of those manufacturers would have been 2012 or 2013,
So over a decade ago?
approximately.
You are not yourself a federally licensed firearm dealer, correct?
Correct.
You do not yourself buy or sell firearms professionally, correct?
Correct.
When is the last time you attended a trade show?
The Harrisburg Gun Show, I believe, in Harrisburg, Pennsylvania. I believe that was this past spring. Whether it was March, I don't recall exactly.
You testified that you keep abreast of the current market for firearms through trade shows. I will characterize it as occasional visits to federally licensed firearm dealers and then through catalogs and periodicals, correct?
Yes. As a matter of fact, I'd be happy to stop by your shop and take a look and see what you have down there that's popular.
You do not visit websites as part of your research, do you?
Oh, I do. Yes. I don't rely exclusively on them, but supplementally, yes.
Your Honor, plaintiffs assert that under 702, occasional visits to federally licensed firearms dealers and receiving catalogs and periodicals is an insufficient basis on which to qualify Mr. Yurgiladis as an expert in the commercial sales of firearms. Plaintiffs will cite back to this court's ruling regarding Ms. Hablinski reviewing a handful of documents regarding World War II. Plaintiffs feel that those qualifications are similar, where it's not a regular practice of his professional activity to visit federally licensed firearm dealers. And plaintiffs assert that catalogs and periodicals are an insufficient source of knowledge for the present market in commercially available firearms.
Your Honor, Mr. Aiello's objection mischaracterizes Mr. Yurgulaitis' testimony. He didn't testify that he makes occasional visits. He testified that he intentionally seeks out and visits federally licensed firearms dealers because it is part of his job as a consultant. He also didn't testify to having reviewed a handful of articles. Ms. Levinsky had reviewed 4 or 5 documents in a subject matter she otherwise had no familiarity with. Mr. Yurgulaitis testified that he maintains in his home a reference library of approximately 75 titles, and he has testified that he makes a study of the market of firearms as part of his professional career, which he has maintained for the past decade. That is in no way similar to the credentials that Ms. Levinsky put forward on the subject of Oregon history.
Anything in response?
Yes, Your Honor. As far as misstating the testimony, I asked Mr. Yurgulaitis, I said I was characterizing it as occasional visits to federally licensed firearms dealers, to which he agreed in the affirmative yes. If that's incorrect, I'm sure Mr. Yurgulaitis can correct me. But the objection would still stand regarding catalogs and periodicals representing the broad swath of available firearms and firearm magazines
I'll let you ask
available.
questions about that. I'm gonna overrule the objection. It's clear to me from his CV and that he does maintain a pulse on the commercial aspects of firearm sales in America. Now, you can ask questions about different things, and if you can't answer it, I'll consider that when I consider the overall weight of the testimony.
And then, Your Honor, plaintiffs would also just like to note for the record that to the extent Mr. Yurgulaitis testifies regarding visits to firearm manufacturers, all of those are greater than 10 years as Mr. Yurgulaitis' testimony, and being contemporaneous with a case in 2023, plaintiffs assert that is too far removed from Mr. Yurgulaitis to testify to.
Thank you. I understand that objection.
Mr. Yurgulaitis, what is a magazine?
Magazine is either a device or a portion of a firearm frame or receiver that holds and feeds ammunition into a firearm.
What is the difference between a detachable and a fixed magazine?
Well, a detachable magazine is, as its name states, one that can easily be detached from the frame or receiver of a firearm. A fixed magazine is that which is either permanently attached or semi-permanently, if say it's pressed into the receiver or forged into the receiver and can't be removed without the use of tools, or can't essentially be removed without damaging the firearm.
Can you purchase pistols in the United States today that come standard with magazines with a capacity of 10 or fewer rounds?
Yes.
What are some examples of pistols that you can purchase today that come with magazines with a capacity of 10 or fewer rounds?
Essentially, because there are firearms manufactured in the U.S. for states that both restrict magazine capacity and do not restrict magazine capacity, most major firearm brands produce state compliant, what they call state compliant versions of firearms. So Glock 17s and Glock Model 19s are very popular firearms that are available in state compliant models that come with 10-round magazines, as opposed to the larger capacity magazines that they come with in states that don't restrict magazine capacity. So essentially, any manufacturer that deals both in states with magazine restrictions and without magazine restrictions will make a model that is state compliant. That meaning that it comes with a magazine that is restricted to, or will only hold 10 rounds.
Objection, Your Honor. Move to strike regarding what firearms manufacturers will or will not make to be state compliant. I do not believe there's been an adequate foundation for that answer, and move to strike.
I'll overrule. Go ahead.
Can you purchase pistols in the United States today that come standard with magazines with a capacity of 10 or fewer rounds that are not necessarily state compliant? They just come with 10 or fewer rounds?
Yes.
Yes. What are some examples of pistols that come with magazines with a capacity of 10 or fewer rounds that are not necessarily state compliant, just they come that way?
Glock Model 23. There are various, well, obviously, look, Colt Model 1911s have magazine capacities that are initially only 7 rounds in 45 caliber. There are a number of SIG pistols, the SIG P320, or I'm sorry, the P365 compact. Essentially, the more compact models produced by most major manufacturers come with a 10-round magazine capacity, standard magazine capacity.
In addition to pistols, can you purchase rifles that come standard with magazines that have a capacity of 10 or fewer rounds?
Yes.
What are some examples of rifles that come standard with magazines with a capacity of 10 or fewer rounds?
Well, again, those that are considered state compliant models, quote unquote. For example, Smith & Wesson produces their M&P 15 in a state compliant model, comes with a 10-round magazine. There are also other traditional hunting rifles, like the Browning BAR, that only has a 4-round internal magazine capacity. So there are those with detachable magazines, again, much like the pistols. Many of those can be found with, or can be purchased with, detachable magazines that hold a maximum of 10 rounds.
What does a capacity of 10 plus 1 mean?
Well, essentially the plus 1 refers to in firearms that you can safely carry with a loaded round in the chamber. That is the plus 1 in any capacity description. So essentially, if you have a 10-round firearm that only has a 10-round magazine and you can safely carry one in the chamber, that will be your 10 plus 1.
So the plus 1 is not in the magazine, correct?
Correct.
Do most modern firearms allow you to safely keep a round in the chamber?
Objection, Your Honor, vague as to safely.
Sustained. You can restate your question.
Mr. Urgulitis, would keeping a round in the chamber present any safety concerns?
It would be dependent on the firearm, whether that firearm could withstand being dropped without discharging. Most modern striker fired semi-automatic pistols, it's safe to carry a round in the chamber, and even older pistols like the Browning High Power and the Colt Model 1911 have manual safeties that would allow you to carry those even though they're single action pistols.
Does the term drop safe mean it's safe to keep a round in the chamber?
Objection, leading.
I'm going to overrule.
It is a term used to describe a pistol that will more likely than not be safe from discharging a round if it's dropped. If there's a round in the chamber and it's dropped.
So in light of the explanation that you just gave, most modern firearms allow you to safely keep a round in the chamber?
Yes.
What types of firearms take detachable magazines?
Semi-automatic pistols, semi-automatic rifles, machine guns. There are a number of other shotguns. They're bolt-action rifles with detachable magazines. There are shotguns with detachable magazines. So many.
While you were an agent with ATF between 1994 and 2004, were you charged with enforcing the federal assault weapons ban?
We were, ATF was responsible for the regulatory portion after that was made law. So although from personal experience, I can say I did not work many criminal cases that involved that. ATF was responsible for enforcement of that law.
Objection, Your Honor. Move to strike pursuant to this court's prior rulings on public carry laws under plaintiff's motions in limine. The witness just testified regarding a national firearms law not at issue in this case. Plaintiffs will add that they see this going down the path of legal conclusion.
Your Honor, first of all, the federal assault weapons ban is not a public carry law. It was not the subject of the motion in limine that Mr. Aiello is referring to. And I haven't asked Mr. Urielitis for any legal conclusion of any kind. So any objection that Mr. Aiello has is at a minimum premature.
Okay. How is it at all a public carry law? Assault ban, federal assault ban. I guess I don't understand the objection. I mean, first of all, it's preliminary, and he did indicate that he wasn't involved in very many of those prosecutions, though the ATF had responsibilities on that. So I guess I would start with that. So I'll overrule.
Mr. Urielitis, you testified that the ATF had the responsibility for enforcing the federal assault weapons ban, correct?
Correct.
So were you personally familiar with the provisions of that law?
Yes.
What did the federal assault weapons ban regulate with respect to magazine capacity?
Objection, Your Honor. Calls for a legal conclusion. What did the federal firearm ban regulate is a legal conclusion.
Your Honor, I am not asking Mr. Urielitis to interpret the law or asking him for any legal conclusion. I am asking him a factual question about what the law regulated as a practical matter, and he has personal knowledge of the answer to that question because he was an ATF agent tasked with enforcing the law during the period of time it was in effect and would have been aware of its provisions. I'm asking him only as a factual matter. It's the equivalent of asking him if murder was illegal at the time. I'm not asking him to interpret the law.
Yeah, I'm just wondering about the relevance to the court's inquiry under Article 1, Section 27.
I think that Your Honor, I believe that the questions that follow this one will demonstrate to the court the relevance.
I'm on the legal conclusion question. I'm going to overrule the objection. Go ahead.
What did the federal assault weapons ban regulate with respect to magazine capacity?
It restricted manufacturers to providing or producing magazines with a capacity of a maximum of 10 rounds unless they were for the military or for law enforcement.
What changes occurred immediately after 1994 in the market for detachable magazines?
Well, after the passage of the assault weapons ban, obviously the manufacturers, as far as providing magazines for the general public, they were limited to providing magazines with a 10-round capacity. So both the manufacturers as well as the aftermarket manufacturers either modified their existing detachable magazine designs in order to stay within the confines of the capacity limit, or they either redesigned them or sort of made new models that had the same outward dimensions, but had a restricted or a lower capacity.
Other than Oregon, do some states also restrict magazine capacity today?
Objection, Your Honor. This falls within the motion to eliminate regarding public carry laws.
Again, Your Honor, I'm not asking about public carry laws. I'm asking about restrictions on magazine capacity, which was not the subject of the motion in limine or his objection.
Which is a public carry law regarding the ability to possess magazines in excess of 10 rounds.
Your Honor, a public carry law is a restriction on where and how one can carry a weapon. A magazine restriction is a different type of law.
We're back to the red apple moments. I'm gonna sustain without much better foundation.
I'm sorry, Your Honor. I don't think that I understand what foundation you're asking for. I'm not going to ask him about
We have
any
other
specific.
large capacity magazine bans. I don't know how that's defined. I don't know how that's defined state by state. I don't know how that's what he's talking about. Some have 15, some have 10, some have others. I don't know. And I also don't understand how it's relevant to the court's inquiry that other people do it. Just because they do it doesn't mean that we can do it under our Constitution. I mean, to me, that's the primary problem with the analysis is, well, my neighbor gets to do it. Why can't I? Because it's illegal. Your neighbor does it. It doesn't matter that he does it. You can't do it too.
So, Your Honor, so to speak to that question, this line of questioning for Mr. Yergulaitis has to do with the market for magazines and what is available. So to back up a little bit, plaintiffs have put forward a couple of witnesses now experts who have testified to the effect on the market for firearms that Measure 114 is that they believe it's likely to have. They've put on that testimony. This line of questioning goes to the market for magazines nationwide, first during the assault weapons ban, and then in states today that limit magazine capacity. We are not making an argument about whether ours is identical to theirs or whether it is exactly the same. We're not going to compare anything. We're going to, this is a line of question about how the market has responded to that, which directly rebuts testimony the plaintiffs have already put on in this case through their own experts.
Here's my concern about this notion of large capacity magazines, the way that it's being presented here. And my primary concern is this, that I don't know if these large capacity magazine bans require fixed plates or not. I don't know if they don't allow any type of extender. I don't know anything about the nature of these particular bans, which influences the marketplace, right? So maybe it's a limitation of 10 rounds, but it doesn't have a fixed plate because everybody wants to be able to clean their guns. And I don't know that he knows that.
Well, I'm not going to get into it at that level of detail with him, Your Honor. And
If you're going to be in marketplace discussions and what's available in the market, I think that's a crucial distinction to make.
Honestly, Your Honor, it's really just one follow-up question of how the market in general has responded. We aren't intending to go into the nitty-gritty of the market for magazines in each state that has a magazine capacity limitation. It's a general statement about how markets respond to regulation. We're not going to go into the specifics of any one state. And I understand your ruling from earlier, and I understand that you don't want comparisons between Oregon's law and other laws at that level of granular detail, but that isn't where this line of questioning is going.
If you can show me that it's a red apple, like our red apple, then I'm happy to hear about it. Anyhow, in terms of responsiveness of the marketplace,
So,
go ahead.
Oh, I'm sorry, Your Honor. I didn't mean to interrupt you. Later in my questioning on a different subject, we are going to touch on some other states, and I do have a handout with their magazine restriction statutes as well as the federal assault weapons ban. May I approach and show it to Your Honor? We have it printed.
Okay. You can approach. Did you have a copy from Mr. Aiello?
And Your Honor, that handout is really a reference for later in the questioning, which I'm sure we'll get into at the time, but this question really is just a broad general question about how markets respond to regulation. That's all that it is. I'm not going to ask him to compare anything.
Anything further?
Yes, Your Honor. Plaintiffs would also say that this is speculative about the impact on Oregon's marketplace, and would also, just in response to defendants' arguments, state that plaintiffs' evidence goes to show the scope of the firearms to which ballot measure 114 applies, not any implementation evidence, which has been excluded by Your Honor.
I am not going to ask any forward-looking questions of any kind, and I am not going to ask him about the effect on Oregon's marketplace, and I am not going to ask him to speculate on anything.
Then I don't see any relevance of how the marketplace has responded in the past if defendants aren't attempting to argue that the marketplace will, hopefully, if it goes into effect, respond in kind in Oregon. So then relevance.
I am not going to argue. I am not going to ask Mr. Yergilitis what is going to happen in Oregon in the future. I will note that plaintiffs have put on significant testimony as to what they believe will happen to the market for firearms in Oregon in the future because of Measure 114. I think even if I did ask him, it would probably be admissible and relevant under 401 to rebut plaintiff's evidence, but I'm not going to ask him that. I'm not asking him to speculate in any way. The arguments that Mr. Aiello is concerned about are legal arguments, not factual arguments that I'm going to ask my witness about.
All right, I'll let him testify to, repeat your question again.
My next question is going to, so I asked him if some states also restrict magazine capacity today. I can't remember if he's answered.
He has not answered that.
Then that is the question.
I'll overrule the objection as to that.
Mr. Yergilitis, other than Oregon, do some states also restrict magazine capacity today?
Yes.
How have manufacturers responded?
Well, much like they did in 1994, manufacturers don't make money, which they are in business to do by not providing what the market wants. And so therefore, in 1994, manufacturers provided what the law allowed them to provide. And they have done much the same as, in those states, in the marketplace, to address markets in those states that have regulations on the maximum magazine capacity.
Are 10-round capacity magazines less reliable than large capacity magazines?
Not in my experience.
Will most firearms that take a detachable magazine function with a magazine that holds 10 or fewer rounds?
Objection, vague as to most.
What does most mean? Most could be 50.1. If that's it. So is it 50 plus 1 is what you're asking about?
Well, I suppose I wasn't asking him for a specific scientific number, but
It was a scientific testimony, right? So
well, I don't.
You don't think so?
Well, it's expert testimony. I don't know that it's scientific. I don't think he's done a study.
Okay.
But I will.
So he's being offered just to talk about what he sees in the marketplace.
He is being offered to testify to his extensive knowledge of firearms based on his experience with ATF as a firearm examiner, and also his expertise in the marketplace, which he's been qualified to discuss. Yes. But I will, if most is vague, I will rephrase that word. Will a significant majority of firearms that take a detachable magazine function with a magazine that holds 10 or fewer rounds?
Objection, Your Honor, vague as to significant majority.
Your Honor, I'm just trying to ask him for a sense of, out of the firearms in existence, a sense of how many will take a detachable magazine that will function with 10 or fewer rounds. I'm not asking him for a number. And Mr. Calloway testified to the same information in his testimony.
I'll let him testify. I mean, to the degree that it's relevant to the court's inquiry, I'll allow this evidence to come in and I'll make a weight decision afterwards. not as to whether you're credibly answering the questions, but to what weight it offers this court in terms of its constitutionality under our Constitution in Oregon.
Yes, Your Honor.
Go ahead, please, miss.
Will most firearms that take a detachable magazine function with a magazine that holds 10 or fewer rounds?
Well, since magazine capacity in, for example, a semi-automatic firearm is not a determinant of whether that firearm or the arbiter, if you will, of whether that firearm will function or not, the answer to that is yes. I personally own firearms that I have both restricted capacity magazines and large capacity magazines for, because I happened to purchase them during the federal assault weapons ban, or they were manufactured during the assault weapons ban. And therefore, there is no difference in the operation other than a firearm with a 10-round magazine will need to be reloaded more often than one with a larger capacity.
Is that true whether a firearm is a handgun or a rifle?
Yes,
Are you familiar with the brand Glock?
yes.
What is Glock?
Glock is a manufacturer of probably one of, if not the most popular handgun lines ever produced, both in Europe and in the United States.
What are some popular Glock pistols?
A Model 17, Model 19, Model 23. I believe that the plaintiffs and a witness, and I will agree with him, that Glock is a world unto itself. Models change almost on a daily basis. But I have to couch that with, I couldn't, tell you every pistol that Glock makes at the moment.
Does the Glock 17 come with a magazine holding 10 or fewer rounds?
Yes,
What about the Glock 19?
yes.
What is the Sig Sauer P320?
It's a semi-automatic pistol manufactured by Sig Sauer in New Hampshire.
Is the Sig Sauer P320 a popular handgun?
Yes,
Does Sig Sauer sell a P320 with a magazine holding 10 or fewer rounds?
yes.
What is the Smith & Wesson M&P?
It's a semi-automatic pistol line manufactured by Smith & Wesson in Springfield, Massachusetts, although I believe they're maybe moving their production or part of their production to Tennessee.
Is the Smith & Wesson M&P a popular firearm?
Yes, that line is very popular.
Does Smith & Wesson sell the M&P with a magazine holding 10 or fewer rounds?
Yes, they sell their M&P pistols and their M&P AR type rifles with that capacity.
Are you aware of any major firearm manufacturer in the United States that produces handguns that does not manufacture models that take 10 or fewer rounds?
No,
Do firearms accessory manufacturers make aftermarket 10-round magazines?
yes.
What are some aftermarket manufacturers that make 10-round magazines?
Two of the largest, Checkmate, Metgar, Magpul is another large aftermarket magazine manufacturer. They make 10-round capacity or 10-round maximum capacity magazines for a wide variety of firearms, both rifles and pistols. As a matter of fact, they also manufacture, I believe, the standard factory quote unquote magazines for a number of manufacturers that don't make their own magazines.
Can you purchase AR-15 style rifles with 10-round magazines?
Yes.
What is a manufacturer that sells an AR-15 style rifle with a 10-round magazine?
Well, as I mentioned before, Smith & Wesson manufactures or offers their M&P 15 with 10-round magazines.
Have you personally fired firearms with varying capacities of magazines?
Yes.
What effect, if any, did magazine capacity have on the operation of a firearm?
Other than having to reload it more often if you exhausted the 10 rounds, there was no change in operability or no effect on operability.
Do you personally have available to you a firearm for home self-defense?
I have a number of them, yes, but sorry.
Do you have one firearm that you would consider your primary home defense firearm?
I have if something happened in the middle of the night, there is one close by. It's secured, but close by.
What is that firearm?
A Colt Delta Elite 10mm semi-automatic pistol.
How many rounds does it carry?
8 in the magazine and 1 in the chamber.
And why did you choose that firearm?
1911 model pistols are a time-proven design. They are easy to work on if you wish to do any work on it yourself. They're reliable, they're rugged, and I just happen to like the 10mm caliber cartridge because I load my own ammunition.
Do you feel that a total 9 rounds is sufficient for self-defense?
Objection, Your Honor, lack of foundation. We don't have any foundation laid for Mr. Yergolaitis being an expert in self-defense, home defense, or any other type of defense.
How is his personal opinion as to whether he thinks his decision is appropriate for his own self-defense at all relevant to this court's inquiry?
Well, Your Honor,
We could put everybody in this room up on, they could all tell you a different story about what they think is sufficient for them for self-defense. And frankly, he's also a very well-trained firearms expert. So I would imagine his need for additional rounds is significantly lower than, say, me.
well, Your Honor,
So
that may or may not be true. I don't know your proficiency in firearms, but that would go to the weight of his evidence.
Proficiency in firearms.
That point would go to the weight of his evidence, it's not whether it's admissible. And the inquiry throughout this week has been whether Measure 114 places too heavy of a burden on the right to self-defense. And so his testimony that he personally chooses 9 rounds is relevant to that inquiry for whatever that's worth to the court. And perhaps you will decide it's not worth much. But we have
Maybe
heard.
I think it's very relevant to the fact that a highly trained individual believes it's appropriate to have 9 rounds in self-defense, and others who are less trained may need more rounds. But I don't know that it's a relevant inquiry of this particular individual at this particular stage of the proceedings.
Well, plaintiffs, Your Honor, have presented, again, multiple witnesses who have testified to how many rounds they believe they need in self-defense. And some of those people included sheriffs who gave anecdotes about wild animals. So I think that, for whatever it's worth, I think that this testimony is as relevant as their testimony was, and the court can take it for whatever weight the court would like to give it.
And Your Honor, plaintiffs would add that plaintiffs' witnesses were actual Oregonians, and Mr. Yergolaitis is not.
Your Honor.
I'm going to, look, I'll let you introduce the evidence. I've just told you how I'm intending to weigh it, so feel free to ask the question and he can answer it.
Mr. Yergolaitis, do you feel that a total 9 rounds is sufficient for self-defense?
For your self-defense is what I said you could ask.
Okay. For your self-defense?
Yes.
Did you have a duty weapon when you were with ATF?
Yes.
What was it?
At the time I left ATF, it was a 6 Sauer P229 and 40 caliber.
What was the capacity of that firearm?
It was 13 plus 1, so 14 rounds.
Given that you had experience with a large capacity magazine as a law enforcement officer, why didn't you choose a firearm with a higher capacity for home self-defense?
Well, because I'm no longer a law enforcement officer. And as such, my need for self-defense and my need for a semi-automatic firearm is different than what it was when I was a law enforcement officer.
How is it different?
Well, my concerns are about keeping myself and or my spouse, who is a fairly good shot with that pistol as well, safe, as opposed to apprehending a fleeing felon or serving a search warrant or participating in an arrest warrant or a traffic stop as I had been doing for a living. So my needs for, in terms of what I consider appropriate in choosing a firearm and its capacity is significantly different than it was.
And the 40 MMs are easier for reload.
They are.
Okay, go ahead, please.
The 10 millimeters are easier to reload.
Why would a law enforcement officer need to have access to a large capacity magazine where a civilian does not?
Objection, Your Honor, calls for expert testimony, and this is outside the scope of his expertise. He's concluding that, or he's being asked to conclude why a civilian does not need a so-defined large capacity magazine. He has not been qualified as an expert to give such a conclusion.
Your Honor, Mr. Yurgulaitis' personal experience is as a law enforcement officer and as a civilian. I can rephrase it to ask, in your personal opinion, he doesn't have to testify that this is an expert. He has more than enough experience to be able to give an opinion on this subject.
Sure, and I have an amica brief that says just the opposite of what you're trying to elicit from him from the National Association of Police. And so if you want to have him give opinion evidence over 701, he's welcome to do so. I've relied on that other document. You're allowed to counter that through his testimony if you wish. I do want to let everybody know that all of our systems go down at 6 p.m. tonight for patch updates. So even though I may sit here till 6, we can't do anything beyond that.
Thank you.
And I know that he's traveled a great distance.
He has.
Well, it's not soft shell crab season, so there's no particular reason.
You're always welcome to come to Maryland.
Go ahead.
Mr. Yurgulaitis, in your opinion, why would a law enforcement officer need to have access to a large capacity magazine where a civilian does not?
Again, as I stated before, I mean, in my own personal choice for the firearm that's, closest secured to me in the middle of the night, there are different, your job as a individual defending yourself against something in the middle of the night, I'm talking about a home defense situation, is different than, for instance, that of the deputy sitting in the back of the courtroom this afternoon. It's not, my job as an individual is not to engage in a protracted gunfight with somebody trying to break into my house in the middle of the night. My job is not to do traffic stops, not to serve search warrants. My needs personally, in terms of what I select as a firearm, are different than they were when I was a law enforcement officer.
How long does it take you to reload a firearm with a detachable magazine?
1 to 2 seconds, depending on the situation.
How long, on average, in your experience, does it take for a brand new user with no experience on that particular firearm?
Depending on the situation, it can take longer. I mean, on the same firearm, maybe 5 or 6 seconds after they've practiced it a number of times.
Did you ever have to qualify on a new firearm when you were with ATF?
Yes.
Did you watch other people do that?
Yes. When in the early 2000s, ATF switched their primary shoulder weapon, at least for enforcement activities, from the Heckler Koch MP5 to a Colt M4 carbine, which is a derivative of the M16 platform. ATF required that we go through a 40-hour, basically 1 week long conversion course where, you spent the first day, if you had no familiarity with AR-15 platforms, taking it apart, putting it back together, taking it apart, putting it back together, and learning that rifle from, every single pin and bolt, every single part of the bolt carrier, et cetera. And then we did increasingly faster shooting drills and increasingly faster reload drills, and increased stress levels in those drills. So it was 1 week of going from 0 to 100 and being proficient with that firearms platform. Subsequent to that, we had to qualify on it every quarter, like we did with every other firearm that ATF had as standard issue. And I can speak from personal experience, even though we had to qualify with it every quarter, I could, almost every time we were out at the range, there would be one agent that would try to load the magazine in backwards or not release the bolt catch before bringing it up to his shoulder to fire. And I have done that. I can guarantee you I got tapped on the back of the head by the firearms instructor once after I did a magazine, swapped out a magazine, put it up to my shoulder, pulled the trigger, and it went click because I did not release the bolt catch on the side and load around into the chamber. So even if you're experienced it with a particular firearms platform in a stressful situation, you may skip a step. You may miss the magazine well when you're trying to put the magazine into it. So, obviously repeated practice with your chosen firearm is going to make your chances for survival in a self-defense situation better. However, that's a perishable skill and it's something you need to do regularly.
What years was the federal assault weapons ban in effect?
1994 to 2004.
What was your job in 1994?
In 1994, I was still a field agent in the Baltimore Field Division. I was there until 2003.
What was your job in 2004?
In 2004, I was the program manager at the ATF National Laboratory for ATF's forensic firearms training programs.
Between 1994 and 2004, were you familiar with the civilian market for firearms?
Yes.
Where did you learn about the market for firearms during those years?
Largely because I was lucky enough to attend a number of factory tours. A lot of the information came from either attending the SHOT Show or from firearms factory tours where we had production personnel and or marketing, sales personnel or product planning personnel that we would talk to.
Did civilians continue to purchase firearms through the commercial market between 1994 and 2004?
Certainly.
Did they continue to purchase firearms with a capacity of 10+1?
Yes.
What is a magazine extension?
Magazine extension is a device that will increase the capacity of a detachable magazine.
Is an extension designed and intended to increase the capacity of a magazine?
Yes.
So you can't use duct tape and parts around the house to create an extension?
I suppose if you were extremely creative, you could, but no, I would not guess that you could.
Do firearms commonly come with magazine extensions?
I wouldn't say that they commonly come with them. I'm aware that manufacturers on a periodic basis will make a special edition for a wholesaler that they deal with. And they may include extenders with those magazines as a special feature or a different firearm finish, or say an optic on the firearm that they don't normally offer with, as a production piece to the general public.
Do Glock 10 round magazines take an extension?
I believe that almost all, or most, if not all, Glock magazines will take a magazine extension. Some of the ones that have a 10 round capacity, maximum capacity, may not, depending on if the bottom of the magazine is the type that has a sort of a polymer plug at the bottom that takes up the bottom 20% of the magazine.
But at least some of them do.
Yes.
All right, let's say that you have a 10 round magazine that has a removable base plate. How would you increase the capacity of that magazine without using an extension?
Without using an extension, I don't know that is possible. I have not done that myself.
Did you hear testimony earlier in the trial about reduced capacity magazines that use dimples to keep them to 10 rounds?
Yes.
Can you increase the capacity of a reduced capacity dimpled 10 round magazine without using additional tools or parts?
Can you increase the capacity of a dimpled 10 round magazine without tools or parts? No.
Do manufacturers make 10 round magazines that have not been reduced from a higher capacity?
Well, I'm sorry. Can you repeat that again? I'm sorry.
Do manufacturers make 10 round magazines that have not been reduced from a higher capacity? In other words, they just come with 10.
Yeah. Yes.
Okay. Can you give me an example?
I believe Glock makes magazines that have basically a polymer plug at the bottom that reduces the capacity. That's not a conversion, if you will, or a modification of a larger capacity magazine design.
I'm trying to get at magazines that don't have a plug or a dimple or anything, just a straight up magazine with the base plate at the bottom that has 10 rounds. Do those exist?
Oh, yes.
Yes.
I'm sorry.
That's okay. Can you give me an example of one of those?
SIG makes 10 round magazines for their smaller compact pistols because their designed capacity is 10 rounds.
So maybe the P320 compact, does that sound right?
320 compact is one.
Could you increase the capacity of a Sig Sauer P320 compact 10 round magazine without using additional tools or parts?
No.
Can you add a magazine extension to?
By tools or parts, what do you mean? Those are two separate things. Can you increase the capacity with tools, or unless you use a tool, you can't increase the capacity? Is that what you're saying?
That I believe so, Your Honor. I think we're asking if you just had the magazine and you had no tools and you had no additional parts, could you increase the capacity?
Sure. Got it.
Can you add a magazine extension to most 10 round magazines with a removable base plate?
I would say presuming that someone produces a magazine extension for that magazine, yes.
All right. Mr. Yergulaitis, I am going to hand you an exhibit. And Your Honor, these are physical exhibits. I don't have copies for the court, and opposing counsel.
Checked by the deputy, they're fine.
It has been, and opposing counsel had an opportunity to inspect these exhibits before this testimony.
Yes, Your Honor, I did. And I just, because we're at 5:05 and we're going into the weekend and Mr. Yergulaitis is leaving, I'd just like to make sure the exhibits are staying here.
I have assured opposing counsel that they are staying here.
Thank you.
They're in an evidence bag, and I admit them, they're staying here. I promise
Yes.
you that.
They're not going home with him.
I do want to note, I don't know how far along you are, but I really need to get give him an opportunity to be cross-examined and such, so.
Your Honor, I don't believe this section will take very long. My guess would be 15 minutes.
15's
And
great.
This is the end of this is
15
work.
is perfect.
Great.
You're speaking my language.
Great. Wonderful.
Continue. It's only 8 o'clock at home.
Exactly. It's the night is young.
Mr. Yurgielaitis, I've handed you Exhibit 174. What is it?
It's a Glock factory 9mm caliber 10-round magazine for a Model 17 semi-automatic pistol.
Did you purchase it?
Yes, I did.
Where?
At Village Sports in Westport, Massachusetts on August 30th of this year.
Did you put it in that bag?
Yes, I did.
Is that your handwriting on the bag?
Yes, it's my handwriting on the seal, and I also initialed the back of the package when I purchased it.
Your Honor, for the sake of time, plaintiffs don't object to the authenticity of any of these exhibits, if that will help speed you along with it. I've had the opportunity to look at them and I plan on using them myself, so it would be foolish of me to
Great. I'll
object.
just get them all in.
Brian, moving on.
All right. Does Exhibit 174 have a removable base plate?
It appears to, yes.
Will it take an extension?
It should.
Could you increase the capacity of this magazine without using additional tools or parts?
No.
All right, Your Honor, I would move to admit Exhibit 174.
No objection.
174 is permitted.
Just knocked off the desk.
Mr. Yurgielaitis, I have just handed you Exhibit 175. What is it?
It is a 10-round magazine in 5.56 or 223 Remington caliber ammunition for an AR-15 type rifle. The brand name is Amend 2, AMEND, and the number 2.
Where did you purchase it?
I purchased that, or this magazine, at the same location, Village Sports in Westport, Massachusetts on August 30th of this year.
Does it have a removable base plate?
It's a little bit tough to see because of the packaging. However, on the back of the package, they do state that it says toolless disassembly for quick ammo dump and cleaning,
So that would be a removable base plate.
presumably.
Yeah. Okay, go ahead.
Could you increase the capacity of this magazine without using additional tools or parts?
No.
Grad too.
You're moving to admit 175, are you?
Yes, I am, Your Honor. Thank you.
It's admitted.
No objection.
Mr. Yurgielaitis, I've handed you Exhibit 176. What is it?
This is the third of 3 magazines that I purchased from Village Sports in Westport, Massachusetts on August 30th of this year. It is a 6-hour factory magazine for a Model P365. It has a 10-round capacity.
Where did you purchase it?
Village Sports in Westport, Massachusetts.
Does this magazine have a removable base plate?
It appears to, yes.
Would this magazine take an extension?
If it has a removable base plate, it would.
Could you increase the capacity of this magazine without using additional tools or parts?
No.
Oh, right. Your Honor, I move to admit Exhibit 176.
176 is admitted.
Mr. Yurgielaitis, I have handed you Exhibit 178. What is it?
It's a Magpul brand PMAG 10 round capacity magazine for a Glock 17 model or a Glock Model 17 pistol. And I purchased that from D&L Shooting Supplies in Warwick, Rhode Island on August 30th, 2023.
Does this magazine have a removable base plate?
Yes, it does.
Does this magazine take an extension?
I believe you can, if it's, I have not seen an extension for a Magpul for this model, but presumably they make one. So yes.
Could you increase the capacity of this magazine without using additional tools or parts?
No.
All right, Your Honor, I would move to admit Exhibit 178.
178 is admitted.
Mr. Yurgielitis, I have handed you Exhibit 179. What is it?
It's a Smith & Wesson factory 10 round magazine for their M&P 9mm caliber pistol. And it was purchased from D&L Shooting Supplies on West Shore Road in Warwick, Rhode Island on August 30th, 2023.
Does this magazine have a removable base plate?
Yes. It's hard. Let me restate that. It appears as though the base plate is removable. However, the bottom 20% or so of the magazine is a solid blocking plug.
I see, so a plastic plug that you
Yes.
could pull out.
Yes.
Okay.
However, I am unsure whether you can attach an extension to this.
You anticipated my next question.
Thank you.
Could you increase the capacity of this magazine without using additional tools or parts?
No.
Your Honor, I would move to admit Exhibit 179.
This is,
Oh, was that 180?
yes.
Oh, I'm so,
180.
darn it.
That's all right. 180 is admitted.
I think we missed 177 as well. Just
We did, but it's intentional. It's a receipt. It's coming later.
understood.
That's 170.
All right, Mr. Yurgielitis, did I now hand you Exhibit 179?
Yes, you did.
Great. What is it?
It's a Magpul brand PMAG 10 AK/AKM, which is a 10 round magazine for an AK platform rifle. Caliber is 7.62 by 39, has a capacity of 10 rounds, and it was purchased by me from D&L Shooting Supply in Warwick, Rhode Island on August 30th, 2023.
Does that magazine have a removable base plate?
It appears to. It's hard to tell from the packaging, but I believe it does.
Assuming that it does, would it take an extension?
Yes.
Could you increase the capacity of this magazine without using additional tools or parts?
Not to my knowledge, no.
Are you moving to admit it then?
I am, yes, sir.
Thank you. 79 is admitted.
Mr. Yurgielitis, I handed you Exhibit 182. Is that correct?
Yes.
What is it?
This is a Sig Sauer factory magazine for a model P365 9mm caliber semi-automatic pistol. It is a 10 round capacity magazine, and I purchased it from Davis Shooting Sports, 1230 Pulaski Highway in Goshen, New York on August 31st, 2023.
Does this magazine have a removable base plate?
Yes.
Would this magazine take an extension?
Yes.
Could you increase the capacity of this magazine without using additional tools or parts?
No.
All right, Your Honor, I would move to admit Exhibit 182.
182 is admitted.
All right, Mr. Urgulitis, I've handed you Exhibit 183.
Yes.
What is it?
It's a Glock factory magazine, 10-round capacity and 9mm caliber for the Glock G43X and G48 model semi-automatic pistols. I purchased it as well from Davis Shooting Sports on Pulaski Highway in Goshen, New York on August 31st of this year.
Does that magazine have a removable base plate?
Yes,
Would that magazine take an extension?
yes,
Could you increase the capacity of this magazine without using additional tools or parts?
no,
Your Honor, I move to admit Exhibit 183.
183 is admitted.
All right, Mr. Urgulitis, I've handed you Exhibit 184.
yes.
What is it?
It is this is the brand name, Wyndham Weaponry, Windham Weaponry, common spelling, 223 or 5.56 caliber 10-round magazine for AR-15 or AR platform rifles. I also purchased that from Davis Shooting Sports in Goshen, New York on August 31st of 2023.
Does that magazine have a removable base plate?
Yes,
Would it take an extension?
yes,
Could you increase the capacity of this magazine without using additional tools or parts?
no,
Your Honor, I would move to admit Exhibit 185.
185 is admitted. 185 or 184.
that's 184.
184.
Oh, 184. Skipped ahead.
184 is admitted.
It's late in the day.
Seven, 81.
All right, Mr. Urgulitis, I have handed you 3 exhibits.
Yes,
The first one, Exhibit 177.
correct.
Is this the receipt for the magazines you purchased in Massachusetts?
Yes,
Your Honor, I move to admit Exhibit 177.
Objection hearsay.
I think it's a business record. I'll allow it.
Is the next exhibit I handed you Exhibit 181?
yes,
Is this the receipt for the magazines you purchased in Rhode Island?
yes,
Your Honor, I would move to admit Exhibit 181.
Same objection.
Same objection.
Overruled.
Understood, Your Honor.
181 is admitted.
Did I hand you Exhibit 185?
yes, you did.
Is this the receipt for the magazines you purchased in New York?
Yes,
Your Honor, I would move to admit Exhibit 185.
Same objection.
Overruled.
No further
185
question.
is admitted. All right. No further questions? Go ahead. She came in under 2 minutes.
Yes, Your Honor. Mr. Urgulitis, you testified regarding the Glock magazine. There were several. Let me be more specific here. I believe it was Exhibit 174. Can we recall that exhibit, Your Honor? Sorry.
Don't be sorry, Mr. Aiello. You want them just to have all these magazines? Is that what you're gonna ask them questions about it? Pile them up over
Call for
there.
that.
Yeah, so why don't we do that?
They're just gonna pile them up and then sort through them. I think they're in numbered order, but, okay. Well, one just fell in the trash, so. Yeah,
thank you.
and 2 more. He was asking about 174, which is 9 of these, so. Oh, 2 more, another one.
Thank you.
So we'll start with Exhibit 74. Can you remind me what firearm that is for?
I'm sorry, exhibit number 174.
Yes, sir.
It states on the package it is for a Glock 17.
What is the standard capacity magazine for a Glock 17?
17.
Okay. How has that magazine been modified so that it only accepts 10 rounds?
Well, without actually taking it out of the bag and examining it or taking off the base plate, it's obviously looking at the back of it, it's been converted or been manufactured as a single stack magazine as opposed to a double stack. I would presume from my knowledge that there is a polymer filler inside the magazine tube that has basically forced it to be a single stack magazine.
Is the polymer on the sides of the magazine?
Without without disassembling it, I couldn't tell you for certain.
So you don't know how that magazine has been modified to only accept fewer than 10 rounds or fewer, do you?
Well, Glock will manufacture magazines to fit their pistols that have a larger capacity magazine. The 10-round magazines that they manufacture, they basically, the polymer component on the outside of the magazine body is thicker than it would be on the original 17-round magazines.
That's for magazines that are double stacked, correct?
Correct.
Okay. Do you know if that magazine has a spacer in it?
Without disassembling it, I couldn't tell you.
So you don't know whether the spacer can be removed without tools or parts, do you?
Well, you can't, let's put it this way. I can't even take the base plate off without a tool. And a tip of a pen is a tool. My finger is too large to depress the detent at the bottom of the magazine. So I couldn't even disassemble it without a tool.
So when you say that a magazine is not capable of being extended without tools or parts, you would include in that definition such a rudimentary tool as a pen, correct?
Well, I'm talking about a pen and any other tool you might need to shave off polymer, to make a base plate fit, or to turn the metal, if there's any metal magazine lips at the bottom of the magazine tube that need to be adjusted or curled or tuned, so to speak, in order to make that spacer fit, or to make an extension stay on there. Plus, if I recall correctly, and it's been in my experience, most magazine extensions require you to tighten up a set screw at the bottom. So again, I suppose if you have, at the very least, a screwdriver and a pen would be helpful in putting an extension on the bottom of this particular magazine.
So my question, sir, was in your definition of tools or parts, you would include a pen among tools, correct?
Yeah, actually I would, because the forensic firearms and tool mark training programs that I ran at the ATF laboratory, a pen is a punch tool or can be a punch tool. So yeah, a pen is a tool, a pencil is a tool, depending on how it's used.
Let's look at Exhibit 175 now.
I'll take that back. Are you done with this exhibit?
Yes, Your
It's
Honor.
pretty crowded up there.
175 is which magazine, counsel? I'm sorry.
I believe it's for it's a 10-round 5.56 for an AR-15.
Oh, okay. Yes, I have that.
You wouldn't, you would include on you can remove the base plate of that magazine with a pen, correct?
It's a little difficult to see, just because of the packaging. So there is most base plates on AR-15 style magazines or rifle magazines don't necessarily have a detent that you would punch a pen into. In order to remove them, you sort of have to tap at them from the back end of the base plate in order to get them to slide forward and come off the curved or the curled metal that's at the bottom of the magazine tube. So a pen, without taking this, opening this up and taking it apart, I couldn't tell you for certain, but a regular standard Colt AR-15 magazine that's metal, I could not disassemble with a pen.
Okay, I'm gonna, without recalling Exhibit 174, just asking another question about it. That magazine could, in the future, accept more than 10 rounds if it was modified, correct?
Well, you just said Exhibit 174, and we're
went back
looking
to
at
the-
175.
It went back to the.
Yes, sir. I'm just going back to 174. That was the,
The Glock magazine?
yes, sir. So that magazine could in the future be capable of accepting more than 10 rounds if it was modified through an extender, correct?
Yes.
Is the same true with Exhibit 175? Could it, in the future, accept more than 10 rounds of ammunition if it was modified with an extension?
Possibly if someone makes an extension to fit the shape of, the base of this magazine tube. But it potentially, if somebody manufactured it, certainly.
At the risk of drawing an objection, I'm going to ask this question this way. Could the magazines in Exhibit 176, 178, 180, and 179, and 182, and 183, and 184, so let's just say all the magazines, those could in the future, if modified with a base plate, be capable of accepting greater than 10 rounds, correct?
Potentially, however, I do not believe that 180 could be modified as such because of the lower 20% of that magazine being a solid polymer piece or a solid polymer slug. However, I do believe that that is the one exception. So
Okay.
I would say with the exception of Exhibit 180, that would be correct.
Okay, so let's talk about Exhibit 180 then. Can that polymer plug be removed? How is that polymer plug attached to the magazine?
Well, it looks like it's basically slides on much like a magazine base plate would. There's a notch on the front end of it, an L-shaped lateral cut that goes to the back of the magazine tube. So if someone did or would manufacture an extender that would adapt to that particular profile, then it could be modified, potentially.
You could remove the base plate and the plug and replace the base plate, correct?
Without doing it, I couldn't say. Possibly.
Okay.
Yes.
So you don't know whether you would need additional parts in order to modify that magazine to accept more than 10 rounds, correct?
Well, a base plate's a part. So if you wanted to replace that plug, so to speak, if we want to call it a plug, with a base plate, you would need a base plate. So that would be an additional part.
Is the plug attached to the base plate?
It appears to be molded as in one piece from the bottom of the magazine, the metal magazine tube, all the way to the bottom. It does not appear to be a separate piece.
How many rounds of ammunition can be fired from a 10+1 magazine?
11. Although I should say, I'm sorry, let me modify that if you will. How many rounds can be fired from a firearm with 10+1? The magazine itself is only 10, presumably, in this example. So it would be the firearm with a 10+1 configuration.
You testified regarding drop safe firearms. You recall that testimony?
Are you done with these exhibits? I don't want to crowd.
Yes, I'm
anymore.
sorry, Your Honor.
I'm sorry.
I tried to do it in one fell swoop and then
It's my job to be courteous when I can be.
Thank you.
you testified regarding drop safe firearms, correct?
Yes.
And you testified that you can carry around in the chamber so long as the firearm is safe to do so, correct?
Yes. In
You-
other words, I would not carry my 10 millimeter 1911 pistol with a round in the chamber unless I had the manual safety engaged on it. That doesn't mean that that particular pistol is drop safe, quote unquote. However, it's dangerous to carry it with the safety off. It's safe, in my opinion, to carry it with the hand, locked and loaded with the safety engaged. So it's a condition in some firearms. It's a manufacturer safe. It's either manufactured into it or you can add active safeties to pistols. So drop safe is kind of a catch-all term for a lot of different things.
That's your recommendation, correct?
Well, it's not just my recommendation.
All firearms are capable of carrying a round in the firing chamber, correct?
Yes.
Regardless of whether they're drop safe,
No,
right?
certainly. That's
Regardless of whether they have a safety, correct?
correct.
Glock firearms don't have a safety, correct?
Well, they have a type of safety. They're-
Safety's in the trigger, correct?
Correct.
Law enforcement officers commonly carry Glock firearms, correct?
Yes.
You were asked whether most firearms, whether most handguns are capable of accepting a magazine of 10 or fewer rounds, correct?
Yes.
Can you define most for me?
Well, that's, we don't have the time nor the opportunity to go through, the 30 some odd thousand firearms that are available to the purchasers, these days. I would say a large percentage, if not most, if not all, almost. How about we go to all almost? Because there's another nebulous term that defines a large percentage. I can't give you a numeric percentage. I don't have any statistics on which ones can and which ones can't.
You testified that shotguns accept detachable magazines, correct?
Some do.
And that's regardless of whether they are semi-automatic or pump action, correct?
Correct.
The same is true for rifles. Bolt action rifles can accept detachable magazines, right?
Some can, yes.
Even hunting rifles can be modified to accept detachable magazines, correct?
Some can, yes.
You saw Mr. Springer's video and testimony on that issue, correct?
Yes.
Do you disagree that that's a capability of, I think it would be a colloquial term, hunting rifles, correct?
I do not disagree.
Do firearms manufacturers recommend aftermarket parts for their firearms?
Some manufacturers even offer aftermarket parts on their company websites as being compatible with their firearms or recommended by them or endorsed by them.
When you were a law enforcement officer and you engaged in law enforcement activities, you had access to backup, correct?
In varying quantities depending on the situation.
You could call for help, correct?
Well, you can call for help. That doesn't mean help's going to come or help's going to come quickly or help's going to, that helps around the corner. Depends on, it's situational and relative to the location.
During your testimony, you made reference to a gentleman in the back of the courtroom as one of the sheriff's deputies. Do you recall that testimony?
Yes.
You stated that his position is different than that of a civilian, correct?
Yes.
And you've been here were you here for Sheriff Jenkins' examination?
I'm not sure if I was here for that or if I watched it. If you could summarize some of his testimony, I could tell you whether I observed it or not. Yes, I heard that.
Easily identifiable.
So you're aware that Sheriff Jenkins disagrees with your conclusion, right?
Which conclusion?
That law enforcement needs access to firearms that civilians do not.
Yes, that's his opinion.
And you're aware that Sheriff Bowen disagrees with you as well, correct?
Can you quote me something where he said it? I'm not certain.
Surrounded by wolves.
He testified remotely about being Union County Sheriff and being surrounded by wolves.
Yes, I recall that. And I think there was one thing that was remarkable about his testimony about that circumstance, in that he stated that he, I believe, fired 30 rounds to scare off the wolves. I don't think he mentioned to the court that he was carrying a .22 caliber semi-automatic pistol.
How do you know that to be true?
He said it was a PTR 30 and he emptied the magazine. So he was surrounded by wolves, certainly, apparently, according to the story, if it's true. But he stated that that was the pistol he was carrying, which is really not something I would be carrying on my hip if I was walking around in wolf country.
You'd want a larger caliber, correct?
The same thing that's by my bedside would work.
You'd want an 8+1?
Certainly.
No more rounds than that?
Oh, no, I'd carry a few extra magazines.
Can you identify for me a Glock firearm that does not accept an extension?
I cannot think of one. There's not one that immediately comes to mind.
So you testified that some may not. So were you incorrect?
The Glock catalog, it could have changed during my testimony. So there may be a new Glock model there that just came out in the past 45 minutes that I'm not aware of that they might not make an extender for. So I can't say with absolute certainty, but it's likely that all Glock pistols, there are extenders for likely all Glock pistols.
I believe you testified that there was no way to increase the capacity of a 10-round magazine without an extension. Is that a correct summary of your testimony?
Objection, that misstates testimony.
I asked him if it was a correct. The question is that correct? So he's
Fair
more than
enough.
welcome to correct me.
Fair enough.
No, I thought that the question was, could it be increased without parts or tools?
Yeah, I believe that was the question regarding specific exhibits, but so I'll ask the question open-ended. Are there ways to increase 10-round magazines without extensions?
Without extensions, possibly. Without tools, no.
You observed several methods of increasing the capacity without an extension, correct?
I can think of one or two. I'm not certain that I caught all of the testimony with from your witness where he was using epoxy or grinding epoxy off on a belt sander. I kind of caught that out of the corner of my eye while I was doing something else. So I was not present here for that testimony.
I'm putting you on the clock because I got to allow them to redirect. So you're on the
Okay.
clock.
I am almost done. In your time with the ATF, did the ATF consider epoxy to be a permanent alteration?
Not that I'm aware of.
No further questions, Your Honor.
Thank you, Ms. Hoffman.
Thank you. Mr. Yergulaitis, when plaintiff's counsel asked you about all of the exhibit magazines and if they could be modified, you answered yes. Do you recall that?
Yes.
Did you mean that they could be modified with an extension?
They can be modified with an extension. They could be modified in other ways. You could potentially you could take the base plate off a magazine, take the internal parts out, and modify the spring. If it had dimples, again, pound out the dimples, remove the rivets if there's rivets in it, or whatever other way that the manufacturer has chosen to restrict the capacity. So,
if you had a magazine with a removable base plate, would a pen alone allow you to extend the capacity of that magazine?
a pen alone? No.
Would removing the base plate of a 10-round magazine without adding an extension to it increase the capacity of that magazine?
I'm sorry, could you please repeat that?
Yes. If you had a 10-round magazine with a removable base plate,
Yes.
and you removed the base plate, but you did not add an extension, would removing that base plate increase the capacity of the magazine?
No, and it would likely render the magazine inoperable.
Mr. Yergulaitis, I want to go back to your answer to my first question on redirect. When you described the various ways a person could modify a magazine, every means that you described would require parts or tools or both, correct?
Yes.
Thank you. No further questions, Your Honor.
Thank you. Thank you, sir. Wish you safe travels.
Thank you very much.
And you are released from further testimony.
Very well. Have a good weekend. Thank
You
you.
as well, thank you. So we had a calendar for 1:30. I'm more than happy to start earlier than that. It's on Monday. I think it might make sense for us to reconvene at 9. So we have enough time to work through any additional legal arguments that you've developed today or that come to your brilliant minds over the weekend. And then we can get into closing arguments and analysis on what are the facial challenge issues that exist in this case, which I think are going to be fairly extensive in terms of time.
That's very good with defendants, Your Honor. We will have a couple of matters for the court Monday morning, but we will not call any additional witnesses, and then we will rest.
All right. Then you'll have your extra witness, maybe. You'll think about it over the weekend. I'll give you that time to think things through. And then we'll get into closing arguments. I'd like to try real hard to be done on Monday for everybody. I knew I was right to schedule 6 days. We're going to lose our record, so I'm not going to take on any more argument because I'm not certain I can get it completed within the time frame. And when they say shut down, they shut down everything, including our record for the patch. So I have no control over OJD in that way. Anything else from a shorter perspective between now? Anything?
No, Your Honor.
No, Your Honor.
9 a.m. I wish you all a good weekend. Thank you all for your hard work and attention this week. It's been a challenging week. It's something I needed. So thank you.
Thank you, Your Honor.